Good afternoon. This is the House Judiciary Committee. It's Thursday, the 20th of February, 2025. We have a number of bills. Hello. Hi. Oh, CT, don't you break the table like last time, then we have to get another one, and it's very expensive. We don't have any money this year. We can't afford to fixing the tables you break. All right. But we have a number of bills. We have 115 witnesses, so it might be a bit, but we're going to get through all of them. We're going to start with Delegate Wilson's bill, House Bill 950. It is you. Mr. Chairman.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of Judiciary Committee. Chair C.T. Wilson here come in strong support of House Bill 950, crucial step towards safeguarding our children. This bill closes a dangerous gap in current law by ensuring the vital information about child abuse and neglect reaches all organizations entrusted with their care. By expanding these protections, we're taking a firm stance and putting children's safety first and holding those responsible accountable. The problem is, currently, DHS can only disclose findings of child abuse or neglect to the superintendent of a local school system or the principal of a non-public school if the employee is found responsible. However, cannot share this vital information with youth sports organizations, government-operated child care centers, other organizations that supervise or care for the children. This creates a serious risk. These individuals that are barred from working in schools due to findings of child abuse may still be able to work with our children in other settings. What the bill does closes the loophole by allowing DHS to disclose child abuse or neglect, to coaches, team administrators, managers of youth sports programs, administrators or personnel of any organization providing adult supervision and care of children. Why the bill matters? Because it protects children beyond schools. Kids interact with trusted adults in many settings, not just in schools. Closes a critical gap in the law. Those found responsible for child abuse should not be able to move to another child-serving environment unnoticed. And it enhances safety and accountability. Organizations responsible for child well-being should have access to the relevant information to make informed staffing decisions. In conclusion, it's a common sense measure that strengthens and protects children across Maryland. We must be proactive in safeguarding our youth from predators, not reactive after the harm has already been done. By broadening DHS's disclosure authority, we close a dangerous gap in protections and ensure that no child-serving organization is left in the dark about potential threats. I respectfully urge a favorable report on House Bill 950. Thank you for your time. In addition, I do have an amendment. Unfortunately, I believe it has not been received yet, but it will be received today. And it basically just ensures that DHS will still be able to keep its federal funding for whatever that means. But for now, anyway, by changing the words, adding for a recreational athletic competition or instruction for participants who are minors. So it's a clarification amendment. It should be reaching your committee today.
Delegate Kaufman, for a question.
Yes, Mr. Chair, thank you. Thank you, and to the other Mr. Chair, Chair Wilson, thank you for taking your personal pain and using it to be an unbridled champion for the children that need it most. So thank you. I want to, maybe your amendment touches on this, but because they talk about aligning the bill with the Child Abuse Protection and Treatment Act, and they also talk about suggesting to the committee that that we define a specified legislative state purpose of the disclosure of the information. And I just wanted to make sure that you don't have an allergic reaction to any of the DHS's suggestions.
Not at all. I'm here on their behalf. In discussions with them, and I believe that they're the subject matter experts on this. So any input that either they or this committee has to make this a better bill, as I said, our job is to make bad bills good and good bills better. So I'm looking forward to any amendments that may help that.
All right. Thank you, Mr. Chair, and thank you for your leadership. Thank you, Mr.
Sir.
Chair.
Anyone else? All right. Seeing none, that concludes the testimony on House Bill 950.
Thank you, Mr. Chair.
Thank you, Mr. Chairman. That's very easy. This is the way it's going to go all day today, and the bills will not take any longer than that, except, wait, maybe not. House Bill 1191, Delegate McComas is there with Michelle Smith, who's also walking up. Virtually, we have Judge Hecker and Darlene McLaughlin. I think I got that right. Oh, no, that's your Chief of Staff. Sorry. but that's okay. Delegate McComas for 3 minutes.
Thank you, Mr. Chair. This is my favorite committee, and you know it. And even though I'm on appropriations, this is the love of my life committee. HB, now I'm not doing that, it's the truth. And
Move on, favor.
Ben Barnes will say that. Okay. This is testimony in support of 1191. Delegate Susan McComas for the record. I also want to tell you that the cross-file in the Senate, and I don't have the bill number. Oh, wait, I guess I do.
548.
548 passed unanimously in the Senate, which is a great thing. And all of the senators in JPR signed onto the bill, which is a really great thing because it never got out of the Senate. So I think it's got some legs, so I hope it has some legs. So with that said, this product is resulting from the grueling studies and analysis commissioned by the Maryland General Assembly over a decade ago, i.e. Judge Dumais and I were on that committee, and a number of different people in all of the areas, psychologists, psychiatrists, social workers, judges, the whole bit. Through various amended and modified forms of the HB 1191 over the years, that Judge Dumais worked on, as well as the Maryland State Bar did a great job. We feel that this is proposed legislation that makes sense for everybody, for the self-represented litigants, for the judges that have rotations that maybe are not that familiar with domestic cases, with the attorneys who maybe who might do a few custody cases, and to those that are the experts on custody cases. If one is delving into custody decision-making, we talked about, my aide and I, we talked about, oh, well, do we want to have a lot of books come in here and show you like this big volume of books of all the case law you'd have to go through? And she didn't think that was a good idea. She said, well, maybe we'll just Xerox all the current decisions and all the mechanisms of the bill, and how it condenses it and simplifies it, and it's going to be in an annotated code. So if people really want to look at certain decision-making factors, it'll be very easy. Well, we decided against that because we didn't want to take up too much paper. So the bottom line is, this is a great bill. And I mean, it's going to have all of the factors that the judges decide on, and it's going to help all litigants understand that kids come from a mom and a dad, and that they have to be able to work things out, or there's going to be, the judge is going to have to make a decision. Now, the good thing about this whole thing is that Judge Solomon doesn't have to decide that, well, if we're going to, cut the kid in half. We don't have that anymore, thank God. So with that, I please ask you to send a favorable report on this bill. Thank you.
Thank you, Your Honor. I was thinking of the judge. I would defer to him if he has a docket that he needs to.
Your Honor, Judge Hecker, do you have we'll let you go. Let's let Judge Hecker go first here. Judge Hecker for 2 minutes.
All right, thank you. Good afternoon, Mr. Chairman, members of the committee. And thanks for the opportunity to speak on behalf of the judiciary in support of House Bill 1191. As Delegate McComas indicated, this is a long time coming. It's the product of the Commission on Child Decision-Making back to 2013. And what this bill does really is to centralize and to clarify and modernize, really, the factors that judges are required to consider in making custody determinations. Many of you, I suspect most of you, have heard the term best interest of the child. That is the sole focus of a judge when making a child custody decision. The factors that lead the judge to what the judge believes is in the best interest of the child is really where the rubber meets the road, and where this legislation assists the court and the public and attorneys in understanding the judge's decision. It's one thing for a judge to articulate their decision on the record or in a written order. It's another thing, and vitally important, that the parents, the litigants, understand how the judge reached that decision. And by codifying or including in the statute the factors which a judge is required to rely upon, I think this will make the public understand a lot more easily how judges come to their decisions in these very difficult cases. And so I see my time is kind of running short. I'm happy to answer any questions, but we urge you for a favorable report on this bill.
Yes. Thank you, Mr. Chair and members of the committee. I know you're familiar with this bill because you passed it as a favorable committee report last year. I'm happy to answer any questions. Suffice to say that this is our primary bill. My name is Michelle Smith. I'm here for the Maryland State Bar Association Family Law Section, and this is our bill we are championing. We have championed for many years, and with the passage out of JPR, I couldn't be more ecstatic. This bill is important because it centers the examination on the children. The factors from the statute are so much better than the factors that we have dealt with for my whole career and for many decades out of case law that pro se litigants, non-represented litigants can't find and don't understand. These factors are in plain English. They center on the children instead of on the parents, and they make for much, much better law. In the interim, I did a study. We are one of only 8 states that don't have factors codified, and every state has the best interest of the child as a standard. I'd be happy to answer any questions. Thank you for your time. We urge a favorable report. I couldn't be more strong about that. Thank you.
Finally, maybe? Is that where we are with this bill? Okay. Are there questions? No? All right. Thank you very much. That concludes the testimony on House Bill 1191. All right. House Bill 1209 is next, and it's Delegate McComas. We'll hear from Thomas Rawlings, who's virtual. And yes, Delegate, please go ahead.
Thank you, Mr. Chair. I appreciate it very much. HB 1209, Child Abuse and Neglect Reports and Records. This bill has been very carefully crafted and passed out of the Senate twice and somehow hits the rocks in the House. That's the history of the bill. It's a very simple bill that clarifies Maryland's obligations under federal law to release to the public DHS records when a child who has a history with the department suffers a fatality or a serious near fatality injury. Under the Federal Child Abuse Prevention and Treatment Act, CAPTA, every state is required to ensure that the public is informed about cases of child abuse or neglect that result in the death or near death of a child. The state must make public the child's age and gender, the cause of the fatality or near fatality, information describing any prior reports of child abuse or neglect involving the family, information regarding investigations pertinent to the child abuse or neglect that led to the child's death or injury, and services provided and actions of the state on behalf of the child. The problem with the current Maryland law is that while it provides for release of this information, it has an exception that swallows the entire rule. Under current law, the state's attorney of the jurisdiction can block the release of this required information merely by stating the release of the information would harm any related investigation or prosecution. Of course, there will always be an investigation into child abuse and neglect and fatality. The presence of an investigation should not allow an agency to avoid its legal duty to the public. I mean, the public's paying for this. DHS contends that releasing the information will infringe on the privacy of these families. Privacy must not be the determining factor when the very life of a child is at stake. In 2011, the federal government Office of Accountability issued an extensive report to the chairman of the Committee of Ways and Means of the House of Representatives. The title, Child Mistreatment, Strengthening National Data on Child Fatalities Could Aid in Prevention, speaks volumes. The report analyzed the deaths from maltreatment involving a failure on the part of the adults who are responsible for protecting them. Prevention is the key word here. Arizona has a website that provides the public with notice about an incident at the time of the initial report. The site is updated after investigation with subsequent report and provides the findings of the agency indicating the persons responsible. By making such preliminary reports, the public is on notice and alert to make subsequent reports should they observe further alarming evidence of abuse or neglect. Thus, the public becomes an active participant in the prevention of child fatalities in the aid of the already caseload-laden HDS. While I have complete confidence in the work of the Fatality Review Board, keeping these reports from the public only hurts the children, as the vigilant eyes and ears of the public are not utilized to protect our greatest legacy to the future, the children. Federal law requires such disclosures, and failure to follow the law may result in federal government withholding our state's CAPTA grant while opening the door to future litigation. Hopefully you can read the last paragraph, because I'm at 5 seconds. Thank you, and please support a favorable report for HB 1209.
Tom Rawlings, please, for 2 minutes.
Well, good afternoon, Mr. Chairman. I'm Tom Rawlings. I'm a child welfare attorney, former judge, former head of the Georgia Child Welfare Agency, former state child advocate in Georgia, and have been very interested in the issue of transparency in cases involving child deaths and near fatalities from neglect for many years. In my experience as an administrator, as a former judge, as a child advocate, I find that unfortunately, when we don't share with the public these details of what happened to this child, how did the system help or not help the child, then unfortunately the public loses confidence in the system. And if there's one thing that's really needed in the child welfare community and the child welfare system, is for the public to have confidence that that system and its good social workers and its good people are doing their best. And so, in my opinion, and I think if you look at some of the recent statutes that have been introduced along several lines around the country, really shedding light on these issues does not hurt a child's privacy. It actually helps the public to understand why we need the child protection system. And I just want to urge you, as I did last year, to please consider making this change so that we can really build greater transparency in the system, greater public confidence in the system, and as Delegate McComas said, really make sure that we're complying with what the federal law not only allows, but requires. So thank you very much. Happy to answer any questions.
All right, we'll take questions, and I want to go to that last point and ask a question of either the delegate or of Mr. Rawlings. What specifically does the federal law require?
So the federal law, Mr. Chairman, requires that the state provide in situations of a child death or a near fatality, that the state make public records associated with that child of any investigation generally by the Child Protective Agency, and of course deleting details that might need to be deleted, such as perhaps the name of the reporter who provided the information about the child's personal details in terms of date of birth, the child's social security number, for example, the names of a sibling perhaps who may have survived, who may still be living. But there are redactions that can be made. But again, the gist of the federal law is that we need to get the information out to the public in as complete a manner as possible while having some redactions of limited information for privacy issues. Because without that, the public simply doesn't understand what the system is doing and believes that the administrators of that system are simply hiding something.
Okay, I may have more questions, but I'll go to Delegate Arakan here.
There we go. Thank you, Mr. Chair. Thank you so much, Delegate, for bringing this really important bill. I just wanted to find, have you seen the Baltimore Banner article about the child deaths in our state? Have you taken a look at that?
I have been a bit under the weather.
I know.
I have seen it, though.
Yeah.
I did read it, but by honest to God, I can't remember what I read.
That's okay. I'll just give you some of the 83. The deaths of children in our state have tripled basically since 2014. There was like 83 children killed in 2023, and 15 of those had been children that were taken from the parents and then returned to the parents. Really disturbing. And the department's response was basically, we're not sure if our numbers are right. So this could be a really important piece of legislation to dig into what looks to be a catastrophic problem inside DHS. So I just wanted to state that. And then I don't know if you've seen, if there's any testimony for or against your bill, but if you'd like to add anything sort of in rebuttal for what the opposition may come in with, I would like to give you the opportunity to do that.
I have not seen the opposition testimony, but I will say that I always thought it was very odd that Senator James was lauded for her work and her research on the bill. The 2 times that it was filed by Senator James, this would be the 3rd year, but she did not, I asked to have her cross-filed, but I know that she's had some issues. And so basically, that did not get cross-filed. The custody bill did get cross-filed because Chris West was going to be the senator for that, and she took it, and then he ended up, she was not available, so he ended up testifying for it. So anyway, at least we've got that one resolved, the child custody decision. The concern is that she negotiated with the head of the State's Attorneys Association and basically worked a deal out that if this was not going to hurt them, that they would disclose what's not going to hurt their investigation. The thing is I think everybody looks at their own particular job, and so they want to make their job as less complicated and onerous and everything. So the default is going to be, well, we can't disclose anything. Good God, right. We can't do that, you know. And I think the problem is that kids are dying. And I will tell you my first session, we're not going to tell you when it was, in Judiciary, under Joe Valerio, Tony O'Donnell, who was the Republican whip for Judiciary, wanted to have an investigation about the death of Sierra Jobs. And the little girl had been given to an aunt or someone who had mental illness, and the little girl died. And she died of starvation, and she was not allowed to urinate in the bathroom or anything. She was putting her feces in the between the walls. So bottom line is oh, we can't disclose anything. Oh, no. And so Tony wanted to have a hearing about it, you know, prior to, you know, getting into the legislative session. It didn't happen. And the little girl died. And I don't, you know, I remember that name of that little girl. And I thought that's so tragic because somebody screwed up.
Yeah. And it looks like they still are.
They gave it to this relative, and this relative, I think, might have suffered from schizophrenia. I don't know, because it's a long time ago. But it was a very, very sad situation. And there's been more of those kind of situations. And I can't give you all the list, but I would defer to Judge Rollins here as to what he has to say about it. But I remember that, and that was many years ago. And that little girl, very sad.
Mr. Rollins, do you want to add anything here?
Mr. Chair, I nothing to add. I think Delegate McComas did a good job there.
All right. Let me go to another set of questions that and one of the questions was something that you mentioned a moment ago, or was mentioned in the article, and then in the last couple days in front of the Appropriations Committee, the department was there and made significant changes to the number of incidents that had occurred in the past. In fact, in 2023, I think it almost doubled the number that they actually reported. You indicated you're getting over not feeling well, so I would refer you to that article. But I will say that last year there was a letter from the Maryland Department of Human Services that was listed as an informational letter that really should have been called a letter of opposition. It raised a number of different concerns and a number of different questions that they wanted the committee to consider. This year, what is being submitted is also a letter of information, but it could probably properly be described as a letter of support. I will say, and just put on the record, that I am somewhat flummoxed by the department's maybe cavalier attitude to what's going on in this area of the law. And I'm very disappointed that there's no one here today to testify either for or against on this bill. I think that honestly, this is a big issue, and it's a difficult issue, and it's an issue that deserves more time, but it goes to a question. Your bill deals with kids who are in foster care or under the supervision of the state. The total number of cases, as I understand it, where there was a child who died because of child abuse, died or had a serious injury because of child abuse, does not indicate whether that was all kids or whether it was just kids under state supervision. I don't know that this is necessarily going to end up in this bill, but it may be something. Would you agree that it would be important that we have a sense of all circumstances where this happens? And is that what the federal law requires? Does the federal law go to deaths in state facilities, or is it meant to be broad? Is it meant to be could it be outside of a state facility?
I would defer to the judge.
Judge Rawlings.
So yes, sir. It's not necessarily a child in the custody of the state. It is the
Foster care.
The child and family had prior involvement with the agency, to clarify that.
Okay.
So think about it this way. Normally child abuse records are confidential, but this is an exception, so that if a child dies, if there may be some neglect or maltreatment associated with that, then the agency should say, this is what we did or did not do prior to this incident.
Okay. Go ahead.
Just in response, Chairman, my concern is that I had a case, okay, and I represented the dad, and the dad said, oh, I'll let the kid go to wherever, all right? And I'm not sure he was the actual dad, but anyway, that was how it was presented. And the young man said to me, well, I belong to the state. So he was in foster care or he was in an institution or whatever. I think we, as a state of Maryland, as being a progressive state, a state that cares about our kids, we are the parent at that point when this child is in foster care or is in the custody of the state. We have an obligation to these kids. We're the, I forget the fancy name, there's a Latin name, you know, that we are the parent. Pardon? Yes.
In loco parentis.
In loco parentis. I think we've got to get with the program, and whether it's a little step or a big step, I don't really care. I think we need to do something, and I think we could start with just this little bit here, and then if we feel, and expand it, because these are kids that are vulnerable. They're you know, we're creating other ACEs when they're injured or harmed, and I mean adverse childhood experience. And I've also heard, which is kind of blew my mind, was I went to a meeting with the hospitals, and I'm not going to divulge any confidentiality, but the bottom line is people will have kids that are either in foster care or their parents, and they just drop them off at the hospital, and the hospitals have to deal with it. Now, that's a whole nother kettle of fish, a whole nother problem that, you know, our emergency rooms, and then the doctors can't take the kids out. You know, the kids can't go out of the hospital. They have to be monitored by the medical profession. Medical profession's there to take care of people, not to babysit, because the family or the foster care parents or whoever's got the custody of this kid can't take care of the kid, and they just walk away. Well, that's another ACE. That's another adverse childhood experience for that kid, being abandoned, left at the damn hospital. Excuse me, but you know, I mean, we gotta do something. We gotta get some blood and some sweat into this thing, and quit playing the political, bureaucratic baseball bat. Oh, it's not us. It's not us. There's a problem here. Houston, we got a big problem. So I'm sorry, Mr. Chair.
No, you're fine. And thank you very much for your testimony here today. I don't see any further questions as of right now, but we'll be working on this issue a little bit more. So thank you very much.
Thank you, Mr. Chair. And I know you
Mr. Rawlings.
Get it.
And that concludes the testimony on House Bill 1209.
Thank you, sir. Thank you.
All right. Before we get to Delegate Schlega, I see you. Delegate Pasteur. Do you have someone you wanted to recognize very quickly?
I do indeed. I would like to have the young lady, Maya Graham, who is a student at Morgan, please stand.
Come to the table, please.
Maya, please tell everyone here why you're here today.
Hello, my name is Maya Graham, and I'm here with the Maryland Student Legislature.
And tell us just a tad bit about that, please.
So it's an organization for college students to get more equipped with these types of proceedings. And we have mock trials and leadership training institutes.
And what would you like to be when you grow up?
Well, I would, currently I was thinking about law school, but I love to be here doing what you all do. I really respect it.
Well, thank you, Maya.
Thank
Any
you so
other
much.
delegates?
Anybody else? Yeah, oh, Delegate Williams has a question. Delegate Williams, you. Oh, you want Delegate Kaufman to go first, or Delegate Kaufman?
Well, I was just wondering, Mr. Chair, if my shadow Anjana from Johns Hopkins University could please stand. Yes, there's another.
Shadows can come up collectively, please, and then we'll move on very quickly. Your shadow, just come up very quickly.
Hello.
So we do have a longer day, and I apologize to those who are waiting, but at the same time, we do want to recognize the people. We recognize the students who are here who join us today for some part of our hearings. And so very quickly, if I could start here with the person on my right, your left, please introduce yourself and what school you're from.
Hi, my name is Anaga Kapsi. I'm from Johns Hopkins University, and I'm majoring in public health, pre-law student.
All right, please.
Hi, my name is Pragna. I'm from the University of Maryland, and I'm majoring in environmental justice.
All right.
Pass the mic.
Hi, my name is Alisa, and I'm from Mount St. Mary University. I'm majoring in philosophy, politics, and economics.
All right, thank you.
Hello, my name is Antonio Luna. I'm a major in economics, and I go to Mount St. Mary's University.
Great.
My name is Alan Stewart. I'm a Stevenson University Legal Studies major.
All right.
Hello, my name is Michelle Aguirre. I go to Mount St. Mary's University. I'm a senior, and I'm studying political science.
Great.
And she lives in District 22.
She lives in District 22. And one more, we need to move the microphone.
My name is Jennifer. I am from Mount St. Mary's University, and I'm majoring in psychology.
Thank you all very much for being with us today. Delegate Valentine, with one last question for this group. One second. You don't get off that easy.
This question is for the individuals that go to Mount St. Mary's University. Two-part question. One, what town is Mount St. Mary's in?
It's in Emmitsburg.
And and for extra points or extra credit, could you tell me what legislative district that's in?
4.
Very close, 2A.
That's all right.
4's about 6 miles south.
Don't listen to Delegate Schmidt. All right, thank you very much. Thank you all very much. Delegate Szeliga, please accept my apologies for jumping out in front, but since there's so many of them here today, we wanted to recognize them very quickly. Thank you. Thank you all for being here. All right, Delegate Szeliga on House Bill 649. There's one person in opposition. We'll hear from you, Delegate Szeliga.
Thank you, Mr. Chair, members of Judiciary. That's a hard act to follow. The bill before you, House, for the record, my name is Delegate Kathy Szeliga. I'm here for House Bill 649, Family Law, Children in Foster Care. And I think the bill as drafted is a little more detailed than I'd like it to be. But let me just give you the general gist of what we're doing here. I am a former foster care parent, and so I'm very familiar with the foster care system as it used to be when we did foster care in Baltimore City. And we accepted lots of emergency placement children. And as a foster care family, we had 2 young children in our home, of biological children. And I wanted to be sure that I had the information about the children coming to our home. And we had small children, so we didn't really have to worry about, really criminal background, but it was great to have educational, family background. Obviously, we held that information very much in confidence as part of our training as foster care parents, but really to be able to help those kids that came to live with us. And there was a report a couple years ago about a young man in Harford County that actually murdered Kayla Hamilton. And he's in prison. He admitted to murdering her. And it came to light in that news report that that young man was placed in 2 foster care homes. Now, I don't know if they were group homes or, of course it's confidential. I don't know what those homes were. But as a foster care parent, I thought, wow, the family should have had the right to know. And of course, when you dig a little bit deeper in, he was an MS-13 gang member, and the Aberdeen Police Department had actually recommended that he not be placed in foster care. So I think this is just basic protection. We provide foster parents with all known information about the child with regard to the child's medical, mental health, behavioral, educational, social, and emotional background. And I think we just need a simple criminal added to that. Again, the bill is far more complicated than it needed to be, and it just needs to be known criminal. I don't think they need to hire a person to do detailed background checks, but it seems reasonable that the social worker could ask, does this child have a criminal history? I need to let the family know that. We have a shortage of foster care families. I'll wrap it up. I know the timer went off. But, if we're going to bring more foster care families into the system, we need to let them know that we care about them and their children that are in the home. And I will just say the opposition testimony is very focused on the foster child and has zero regard to the children in the home where that foster child is being placed. So I think we need to balance them both. Thank you, Mr. Chair.
Questions? No problem. Delegate Schmidt, I see you.
Thank you, Chair. Thank you, Delegate, for bringing the bill. Thank you for your commitment to the foster care program, all that you've done in the past. You had mentioned the family should have a right to know, and then you elaborate a little bit more on that. How do we determine that? Is that from like a checklist? If we already have some of the history there, is it just adding another box to the list?
And when we had emergency placement, that's obviously a little more complicated. With an emergency placement, that child is being taken out of the home and dropped off at your house. And so they have some known information, the social worker that will share with you. About those things. If it's a child that's being moved from a foster home to another foster home, there's an opportunity to know much more about that child. But I don't think it's onerous to ask the social worker to ask the police, does this child that we are placing in the Smith household have a criminal record? Yeah. And then they can tell the foster family who could accept that child. The foster family could say, that's fine. It's a misdemeanor, it's a, and again, confidentiality is important, and foster parents know that. They get as much medical history as they can to care for that child properly and also care for their own children.
Yeah, I guess the concern is if it's a deterrent to a family, yet they should know what the crime was.
Yeah, and they could still say yes. Yeah. But, putting your own, frankly, I'll tell you that my husband and I stopped doing foster care because we were concerned about our own children's health and some things that had happened in the house. And we continued to do like emergency friends. We have a lot of friends who still do foster care, and you can't let your foster care in your home go with, like, my foster kids couldn't go with my mom. If my husband and I went away for a weekend, they had to go to another foster family. So we would be like weekend help for friends who had foster kids. But, you know, you should have full information when you make that commitment for the child and for your own family.
Yeah, sounds good. Thank you for explaining that.
Thank you.
Thank you, Mr. Chair. Thank you so much, Delegate, for this bill. Can you just tell me, so I just want to make sure I understand the timeline. So the case you referenced in Hartford, the child had been charged, I guess, with murder and rape and then was placed into foster care.
I can't guarantee that.
I think that's what I think that's what it was.
Yeah, I do too. I think that's when I thought of this bill, you know, but I would want to double check that before I guaranteed you. But that was my understanding as well, because the Aberdeen Police Department
how they
said,
know.
don't put this child in a group family setting, and they did it anyway.
Oh wow! So wow. Okay.
So but let me verify that timeline, because I like to be correct.
Okay, awesome. Thank you so much.
Delegate, how do you get around, if a child has been found delinquent, the records are supposed to be sealed and confidential. How do you get around that?
Yeah, you know, as not a member of the Judiciary Committee.
That's fine.
You know, the medical records are also confidential. So, you know, there has to be an ability to accommodate both under very strict confidential. Listen, when we became foster parents, it was a very in-depth thing. They examined our house, they looked at our bank accounts, they looked at all of our finances. You know, that was not we had to take a course. It wasn't easy like, oh, we'd like to do foster care. And they're like, here, just sign here and we'll put kids in your house. You know, it was fairly complicated. So I think there has to be a way to accommodate that, because we do also give medical information about those children.
Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you, Delegate, for the bill. I think I agree with you. I think it's important to know with whom is in your home. You still want to share the love and provide that guidance for the child, but I just think out of fairness, it's just respectful. I want to again ask you a little bit more about the process. So when you are having a child placed in your home and it's not, say, the emergency piece of it, but just having a child placed in home, at what point are you given the behavioral, the social, emotional, and the medical information? And is the medical assistance card and all those things that you might need to take the child to the doctor, is that all provided for you, like, at that given time, or was it everything piecemealed?
Well, and we did foster care, you know, 20 years ago. So I think Delegate Sample Hughes, I think a lot of it's governed by the local counties that place that child. And with us, we had emergency placements. We would have young children brought to our home in diapers, and, you know, here's Bobby. We know his parents are this and this. You know, his health is this and this. Very, very little about that child when you get an emergency placement who has just been taken from a home or left somewhere. But when you get a child that is coming from one foster home to another, there's an opportunity to know a lot more about that child. But yeah, we took our kids to the dentist, you know, to get medical care, and we had that, you know, Medicaid card for them. And so they would provide some things in writing, some things were just told, you know, verbally to you.
Okay. I was just wanting to, just kind of like our chair was saying, like, how do you get around that part of the confidentiality piece? But I think it's important for you to know, and I was just curious in the timeline and what is standard now that you receive around that mental health or behavioral health.
Yeah, those things were verbal, you know, verbal transferring of information. There was, you know, nobody's looking for a detailed, you know, kind of checklist of, you know, the intent of this is not to make it, you know, a big complicated project, like, you know, the fiscal note has a big because the department wanted to kill the bill. So, you know, that's what they would do. They'd make it a very complicated process. But we have this list: medical, mental health, behavioral, educational, social, emotional background. So why can't we just add known criminal? Again, not asking for secret, you know, private detective background check, but a phone call, you know, and being able to determine how do you cross that confidentiality with, you know, protected records, but we do that with medical records as well for these kids, which is obviously really important, you know, information on, especially on the medical piece when you're caring for kids coming into your home.
Yes, indeed. Okay, thank you. Thank you, Ms.
Delegate, thank you for bringing the bill, and I certainly understand your logic on a lot of the different, you know, if the kid is a member of a gang or different thing, but the fiscal note also indicates that you want information about whether a student was suspended or expelled, and I know plenty of people, you know, who mouthed off to the teacher that I went to school with, who are now well-adjusted adults. So are you concerned that if they have to, you know, if in 5th grade they got suspended for something, that by the 7th grade it might be harder to get them placed in a home because they're branded with the scarlet S of suspension? So I just wanted you to speak to the that aspect of your bill, because I get the criminal charge, the criminal stuff.
Thank you, Delegate Kaufman. We currently do give educational information to parents, which is important. But, you know, think about the families that want to do foster care. These are families that want to help children in need, and they know that the kids coming to be placed in their home have a lot of challenges. And you embrace that. I mean, the kids that came to live with us had a lot of challenges. And we didn't hold it against them, but it would just be nice to know. Well, if, you know, Bobby was suspended in 5th grade for mouthing off to the teacher, when he comes to live with our family in 7th grade, I'll be able to counsel him and say, you know, look, we're not going to do that. My 2 kids don't mouth off to the teacher. Hopefully they didn't. So you're not going to do that either. So I don't think information in a foster family creates a prejudice, because the families that are doing this, trust me, I mean, there's always bad actors, but I have plenty of friends that still do foster care today. And they do it for the right reasons, and their heart is not in a matter of judgment, as you're supposing.
Okay, thank you very much.
Thank you.
Seeing no other questions, that concludes the testimony in favor of House Bill 649. We'll go to the one person testifying in opposition. Aubrey Edwards-Luce, please. And we'll hear from you for 2 minutes.
Good afternoon, Chair, Vice Chair, members of the committee. I'm the Executive Director of the Sarah Neil Meyerhoff Center for Families, Children, and the Court at the University of Baltimore School of Law. CFCC strongly opposes HB 649 because the bill would violate foster youth's privacy rights, burden the child placement agencies, distract from the agency's responsibility to keep children in foster care safe, and perpetuate the criminalization of foster youth. First, the U.S. Constitution, federal FERPA, Maryland law all require that children's judicial and educational records be kept confidential. Divulging information as envisioned in this bill, especially without consent from the youth and their parents, would violate the children's rights to privacy, and it's contradictory to the rehabilitative and restorative purposes of Maryland's juvenile justice and school disciplinary systems. Secondly, implementing this bill would cost the Department of Human Services hundreds of thousands of dollars, additional effort finding rejected foster children more prospective homes, and individual caseworkers a lot of time. Additionally, the sensitivity of this information would require training and accountability to ensure that the caregivers properly store and dispose of the children's confidential information. Thirdly, while most resource parents are perfectly safe people who love children very much, the agency needs to be cautious when providing information that a predator might use against a child in care. Children who I have worked with who've been harmed in foster care have reported that their histories were used against them. Children in foster care are entitled to safety, but neither they nor their parents are afforded the privilege that is envisioned in this bill. Lastly, implementing this bill would place a punitive measure upon an already vulnerable group of children, and it would further inhibit the child's ability to gain foster housing and support. Behind every arrest, adjudication, conviction, suspension, and expulsion is a child's experience of feeling pressured, scared, misunderstood, hungry, bullied, or ignored. Providing the child's rap sheet without their consent in the context of their strengths and even their needs is not in their best interest. Thank you.
Questions for the panel, for the witness? All right. Delegate Sample Hughes.
Okay, thank you, Mr. Chair. I won't talk too much today because I know we have a lot of witnesses, but this is kind of concerning for me. And I guess from a couple of standpoints, I mean, yes, we have bad actors in anything and everything, but it very well could be that if that child has had some criminal history, that child may be matched possibly with someone who have maybe had previous issues like that in their childhood, can relate and can help mentor that child even more so by them having that experience potentially, right? The other area, well, it's a question, will be, would you find yourself concerned if the foster child was in the gang, or the guerrilla gang, or MS-13, all those wearing specific colors? I know in my jurisdiction it's a lot about the colors. And then I, as a foster parent, also had another teenager in my home, my child, that be in the rival gang. I mean, there's so many things to this. We're talking about people who are in the homes. They're in their home, not just, I'm taking care of you for 5 hours a day.
Yeah.
You're staying there. Would that concern you at all, to not want to know anything?
So I'll respond by saying I'm a hidden foster care parent, so I understand this idea of like taking a child into your home permanently, having their responsibility and their safety in your hands. I think there's a couple of different pieces to this, right? But there's a way in which caseworkers can ask foster parents without divulging the child's personal information about whether or not this would be a good match, right? Matching is so important. You can ask the question of like, if there was a child who was in this gang, or if there was a child who had this type of criminal background, right? We don't need to diverge an individual child's information in order to then give the foster parent an ability to either reject or accept them, right? But the goal of that conversation should be, to your point, of like whether this would meet their needs, right? Whether they could service them, not necessarily like whether or not they should be in the home. But I also think that there's a way in which to have that conversation that doesn't divulge an individual child's personal information.
Okay, and then one last thing. We talked about the fiscal note. What's interesting to me is that the department right now owes a lot of foster parents money from where they have totally ignored the fact that they haven't paid them for the services they have rendered. And this is information I have directly from constituents. They are taking care of the children, doing their very best. But when you go like 8 months without any compensation to try to help, that's a concern. So they're talking about the fiscal note. That's a whole nother issue. They at least need to take care of the people who stepped up to the plate and are serving as foster parents.
Yeah, there's a lot of ways in which that money that would be used in this fiscal note could go towards other things that would make the system more improved and better for foster parents and for children.
The system's a little broken before we even deal with this bill, but something needs to be addressed. Okay, thank you, Mr. Chair.
Thank you.
Delegate Pasteur.
Thank you, Mr. Chair. A question for you on your side. It's a little disturbing to believe that the system hasn't processed, so there must be something, and that's what I'm asking you. What is that something? Hasn't processed that the issue that Delegate Shalega brought up is not important on both sides, both for the family and for the child. So just like there's specifications for foster parents who handle or take in children on an emergency basis. Not everyone does that. So the system finds out from the foster parents whether they're willing to do that, and that's part of the background. Is that correct?
That's correct, yeah.
Okay. Then following with that, knowing that there are children who are either in danger or could endanger someone else, are you saying that the system doesn't ask parents, because I don't know whether it was the delegate or chair who brought this up, that the system doesn't ask folks who might have a history or a background or something that would make folks think that they would be able to handle children who have a history, if you will. They never ask that question?
I am not aware of whether that practice happens consistently across all jurisdictions, but that would be my recommendation, is that they have a process in place where they're asking the foster parent, kind of irregardless of what any individual child is needing, are you able to provide housing and safety for a child who has this type of criminal, and I would reject saying criminal because children are typically processed in the juvenile justice system, but have this type of juvenile delinquency type of experience.
Well, there are counties where they do that, where they ask, I know that for a fact.
Yeah.
Where they ask folks and ask if they're willing and able. And it's one, yes, for the safety of the foster parents, but it's also for the safety of the child who's coming in, because you can have a history, but you now want to be safeguarded as well. In addition to which, that issue needs to be addressed, because we must not conflate having gang affiliations, et cetera, with having never been suspended from school. That's apples and oranges in terms of our children, what might happen in school, and really who they are and how they live their lives. So maybe what we should be looking at is some state regulation so that we can do what the chair said. Would you agree that, as the chair said, there must be a remedy for it? It's because some, I keep wanting to say LEAs, but that's a school thing. Yeah. Some counties do that, and they have figured out a way to talk to foster parents.
I think as long as there is a conversation that's happening that's not violating the student's privacy rights, and like I said, I think that there is a way in which you can engage a conversation about a type of history without naming a child, putting, kind of creating a concern where the child is going to have their information with someone who may or may not accept them. And I would say also to the perspective that was put forward about disclosing the medical information, in my practice with regards to representing kids in foster care, we had to ask for parents to sign waivers in order for that information to be able to be disclosed to people inside of the agency and foster parents as well. And so at the very minimum, there needs to be a consent in order to comply with the constitutional and federal and Maryland laws.
And certainly that's a possibility, a way. Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Thanks for being here. So you had mentioned that there can be sort of an exchange of information, but not have it in writing. So, like, I guess a caseworker could just like verbally share some information with people without having sort of like a hard copy. Is that what you were?
I was meaning without like naming a specific child. So inside of like FERPA and privacy rights, we talk about like personal identifying information.
Yeah.
And so I was envisioning a process where we're asking the foster parent, you know, if there was a child who had this gang affiliation or had this like history of suspensions, what kind of services would you be able to provide? What kind of safety? But we really need to make sure that we're not disclosing children's personal identifying information without the proper waivers.
Okay, so you said for the medical information to be shared, a parent would sign a waiver for that?
That's correct.
And is that true for the educational information as well? Are there waivers signed?
That's how I practice as well. And I did practice in DC, so I would
Okay, so
refer
it's
to
a little,
DHS.
okay, a little different, but probably there was still some overarching federal guidelines here. Okay, all right, that kind of helps us. So there could potentially be some kind of waiver. You know, I mean, I would think if my child was struggling, I would want the person that was going to take care of my child to understand the full breadth of what my child was bringing to the table, because I would be more concerned if a child was placed in a home and then a family was like, something's not right here, and we feel like we were lied to, and then the child being uprooted again and sent out. I mean, think about the trauma for the child to be rejected.
Yeah.
And have to put their stuff back in that bag and go to another home where the next people probably don't know either.
Right.
So.
Yeah, doing that matching and information sharing, and that's kind of towards the end of my testimony. What I think really needs to be prioritized here is the care for the child. What does the child need, as opposed to whether or not the placement will reject or accept them, right? I think the information needs to be shared from a perspective that you're talking about, Delegate, about making sure that the needs of that child are first and foremost, because this is what the agency's priorities
Supposed to do, right. And then the other worry, of course, is if there's other kids in the home, other foster kids as well, you know, how do we weigh whose rights are more important in that situation? Like, you know, like if somebody was charged with, you know, a rape or a murder, I would, as if I was a foster parent, would not want my other foster children, especially if they were the same age or gender as the person's previously predated victim. I wouldn't want that person to be around my other foster care child. So how do we get to that, strike that balance where we're protecting all the kids involved in the situation?
And to your point, in one of my footnotes, I refer to a movie called Foster Boy.
Yeah, I saw that.
And that is one of the scenario is actually that the foster youth was abused in the home is actually by, I think, the biological child, so not a foster child. But there's all of those concerns that need to happen. You know, hopefully, if your concern is about two children in care, the agency should have all of that background information, right? So it's not that the agency can't necessarily.
So the agency does have the criminal information then?
The agency can get that.
Oh, they
can get access to it. It does take time, right, to be able to do that, but.
Right.
So it's.
So not for an emergency placement, probably.
Right, exactly. So, so it does take time, but they can access it. It's the disclosure that's protected.
Okay.
Under the laws.
Okay, I appreciate it, thanks.
Yeah.
Seeing no other questions, we thank you very much, and that'll conclude the testimony for House Bill 649. We're going to go now to House Bill 721. There are several witnesses in House Bill 721, and that's this Delegate Addison's bill. Janice Harris, Tamika Winkler, Judy Templeton Pirantazzi, Kyriaki Karodulu are the first on the list.
So it's my bill, but this young lady who's my intern wanted to testify on the bill, if it's okay. Okay.
That's fine. Go ahead and present the bill.
Good afternoon, Chairman Clippinger, Vice Chair Moon, and honorable members of the House Judicial Committee. Thank you for the opportunity to speak before you today regarding House Bill 721, grandparent visitation. For the record, my name is Sawanja Jeffrey, intern for Delegate Jackie T. Addison. House Bill 721 aims to amend current visitation rights for grandparents in specific circumstances, recognizing the vital role they play in the the lives of their grandchildren. Grandparents often serve as critical support systems for their grandchildren, providing love, stability, and consistency, especially during times of family distress such as divorce, annulment, or paternity disputes. When a family faces challenges, it is not unusual for children to find themselves in distressing and uncertain situations. In these moments, the presence of a grandparent can be a source of comfort and security. This bill emphasizes the best interest of the child, a principle that should guide all decisions involving minors. By allowing courts to grant visitation rights to grandparents after a divorce or custody action, we acknowledge that maintaining these essential family bonds is often crucial to a child's emotional and psychological well-being. By including language that grants visitation rights if a child has resided with a grandparent for at least 12 months, House Bill 721 recognizes the deep and meaningful relationships that can develop over time. These relationships are often akin to parental bonds, and the disruption of such connections can be detrimental to a child's stability. Also, the provision that allows visitation rights when a parent is deceased, acknowledging the profound grief that families endure. Importantly, this bill grants the court the discretion to evaluate each case based on its unique circumstances. Personally, my grandparents played a big role in shaping who I am today. When thinking about this bill, I wonder what is holding grandparents back from having rights. I urge the committee to support House Bill 721. By doing so, we send a clear message that we prioritize the well-being of our children and recognize the indispensable role that grandparents play in their lives. Thank you.
Would you like to go next?
I'm ready to testify for all grandparents that have been alienated from their children and grandchildren. It's a contemporary epidemic, and it's been proven by experts to be a form of abuse for children and elders. There's no help or justice for grandparents, and I have personally battled through the abuse, trauma, injustices for the past 3 years. I've been to 5 consults with reputable family law practices, and I've been told the same story. Grandparents have no rights. What I didn't know is that we are also susceptible to abuse, to include restraining orders from false accusations, cease and desist, and threats using the children as pawns. We are traumatized and abused and have no protection on top of the total loss of our grandchildren, who in my case were very attached to me since they were young, and I rescued them from their abusive parents that were in a toxic marriage. Their mother is mentally unstable and has full custody of them 3 hours away in Ocean City, Maryland. I have been in therapy support groups and suffer with anxiety and panic disorder due to this abuse. But I'm sure my grandchildren suffer from more. I have a letter from my counselor. I'm not going to worry about saying that right now. I'm blocked on my phone, email, text. I have no contact whatsoever. I am not allowed to send them anything. It gets sent back to me in envelopes with big black letters saying refused. I'm very concerned about my grandchildren and the mental abuse that they are enduring. I have tried to reach out to her via professional mediation, have sent monthly notes continuing to tell my daughter that I love her. They are all sent back. She took a restraining order out on me at one point, and again, false accusations. It was dropped and shielded, but she uses that as a threat against me. I teach at a college, and that is something clearly I don't want in my record. I live in fear that she will villainize me, tries to ruin my career, and I gotta stop.
What was your name, please?
Oh, Judy Templeton Pierantozzi.
Thank you. Who would like to go next?
Okay. My name is Janice Harris. Good afternoon, all, and thank you, Delegate Addison, for inviting me to testify. My name is Janice Harris. I'm a 62-year-old disabled veteran who is the proud mother to 4 adult children and the doting grandmother to 11 grandchildren, and one of them is here today. I am also a de facto parent to one of those grandchildren. His name is Ian. As a de facto parent, I raised Ian since he was 13 months old. Ian is now 10 years old. During those first 8 years, I have imprinted an unbreakable, loving, maternal bond with Ian as I work tirelessly to stabilize, educate, nurture, support, and advocate for him and all of his special needs. In September of 2023, the Circuit Court for Baltimore City Family Division unjustly reduced my access to Ian to 2 hours every other weekend at my cost. And for context, as a grandparent, in order for Ian and I to see each other, I must pay $160 every 2 weeks. This is a travesty and an absolute miscarriage of justice. This is not in the best interest of Ian, a special needs child who was yanked from a loving, stable home with his Nana and placed in a well-documented abusive and neglectful environment with his father. Talk about insult to injury. In closing, it is true that it takes a village to raise a child. Grandparents are a vital part of the richness of the beautiful and complex and loving core memories and lifelong experiences of a child. And as my beautiful Ian continues to grow, it is true that he will be unpacking all of these childhood traumas, perhaps for a lifetime. Yet one undeniable fact is that he will also have his lifetime to savor and cherish the beautiful, warm, and loving memories of his life with me, his Nana, his de facto parent, who is also his maternal grandmother. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Tamika Winkler, and I'm coming for you today as a grandparent. I would like to ask you guys to grant grandparents visitation due to me losing time with my grandson since he's been 1 year old due to my son getting into some trouble. My grandson was with me every day until he was 1 year old and one day, and his mom took him away. And I just ask that you guys can at least grant visitation rights, even though y'all stated that it's in the law where grandparents can get visitation. It's not as easy as everyone state that it is. I go to court and I try to apply for me to see my grandson. They states is up to the parent. And so I lost a connection with my grandson. And I just get sad and feel bad because it's for other grandchildren in my family, that's great-grandchildren that get to spend time with my parents, my sisters, my brothers, and my grandson not there to do Tai Chi with my dad, to do Bakwa with my dad, to do story time with me, to go out and volunteer. My Chase man used to be on the campaign trails with me, everything, and now he's not here with me. He's 8 years old, and I lost him. This is the last time that I saw my grandson, and he's missing out. Thank you, Chair, Vice Chair, members of the committee, for listening to my testimony.
Good afternoon, esteemed members of the committee. My name is Dr. Dennis Winkler. I am a licensed clinical professional counselor specializing in trauma, attachment theory, and family dynamics. I am here today to express my support for House Bill 721, which seeks to help children maintain meaningful relationships with their grandparents during times of family disruption. In my clinical practice, I have seen the critical role grandparents play in child's emotional and psychological development when these relationships are disrupted, whether due to parental separation, remarriage, or loss of parent, or anything that serves as a disruption. The impact on a child can be profound. Many children perceive these losses as abandonment, leading to confusion, anxiety, and a diminished self-worth. These effects often persist into adolescence and adulthood, manifesting as attachment difficulties, depression, and challenges in forming healthy relationships. Research consistently shows that stable, nurturing relationships with grandparents contribute to a child's emotional resilience. Studies from the American Psychological Association and Boston College indicate that children with strong grandparent connections experience fewer symptoms of depression, greater emotional regulation, and stronger sense of identity. Grandparents also benefit in experiencing reduced loneliness and improved well-being. House Bill 721 recognizes these relationships are essential. The bill allows grandparents to seek visitation when it is the child's best interest, particularly when grandparents has provided long-term care and when the child's parents is deceased. These are among the situations where maintaining grandparent-child bond can help mitigate the long-term effects of grief, family disruption, and ultimately trauma. The bill ensures that any visitation is carefully considered and granted only when it serves the child's best interest. The legislation respects parental authority while providing a legal avenue for grandparents to offer emotional stability and nurturing presence that the children may need during difficult family transitions. In closing, I urge the committee to maintain relationships. And
Thank
Be faithful, yes.
Good afternoon. Thank you, Delegate Addison, Chairman Clippinger, for the opportunity to testify. My name is Audrey Carter, and I am a grandmother. I have 2 grandsons. I've been there since the day they were born. They lived with me for several years on and off. During this time, I was able to see and talk to them every day. I took them to school, fed them, purchased their clothes, took them to doctor's appointments, involved them in sports, and was called when their parents were unavailable, much like a de facto parent. My one and only son was shot and killed on June 9th, 2018. My grandsons were 8 and 13 at the time. These pictures are when my sons were 10 and 15, right before they left my home to go back to their mother at her request. That was when talking and seeing them became very difficult. Our communication became very sporadic, and I was no longer privy to their school or social lives. I even tried to file for joint custody, but was denied. Since my grandsons left my home, and after the death of their father, our relationship had greatly suffered from my absence and limited involvement. They are now teenagers, and I really don't get to talk to them, even though I bought them phones. My younger grandson only calls me now for money, and my older grandson was and is not doing well since he left my home. Visitation would have helped him during this difficult time. I teach and help other youth, but not my own, and I feel like I've lost 3 children. We should not be denied visitation from our grandchildren because parents feel we will interfere. We are here to be of support and an extension to help them and our grandchildren, because it is in the best interest of the child. I urge you as a grandmother who loves and misses her grandsons to pass this legislation. Thank you.
Mr. Chair, and I promise I won't ask questions on every bill, but this is important. So I wanted to, Delegate Addison, I have a question for you, and then just for Miss Judy also. So Delegate, unfortunately, the family law section of the Bar Association has a number of things that they have concerns about with your bill. They're just frankly not crazy about it. And so have you had a chance to read the letter? Because before the representative comes up, I wanted to give you a chance to sort of give a prebuttal, and especially, and I know you're at a disadvantage because like me, you're not a lawyer, but their assertion that it might not pass constitutional muster or anything that, any other assertion that they made that you would like to rebut.
Thank you for the question. No, I did not see the letter yet, but I will read the letter. But I do want to say to you that I did put an amendment for the bill, and it says for parents that are incarcerated, death, or have a mental illness. But I will read the letter.
Okay. And then I'm sorry, I forgot your last name, but
Oh, it's okay.
Miss Judy.
Just say Templeton, it's easier. Go ahead. Or Judy's fine.
I have a question for you. My heart goes, I had wonderful relationships with my grandparents, and I miss them every day. But my question, and so I'm sorry that you all are estranged from your children and grandchildren. My heart really goes out to you. But can you tell me why? Because, you know, I'm not a therapist. Some people tell me I may need one, but I'm not a therapist. And as such, why is the legislature the best venue for you to work out your family difficulties rather than a mental health professional who's in a much better position to help you than I am?
So, okay, I do work with a mental health professional, but it's the problem that is systemic right now going on. And so we have to change the law, because whatever, I can work on coping, of course, but it isn't even my coping that I'm concerned as much as my grandchildren's. So, and as I said before, I have been to lawyers' consults in and out of court, and we have no rights, so we have to start here. This is the place to start. If we don't get this resolved, whatever else we do is just white noise.
Thank you, and Mr. Chair, I will send, our Delegate Addison, I will send you the letter because you should have a chance to respond to it at some point.
Are there further questions for the panel? Seeing none, we thank you all. She did not get the chance to speak?
Right.
All right, well, she should get the chance to speak. So you go ahead for 2 minutes, please.
Hi, my name is Kiriaki Cordogalo. I'm 15, and I have like 6 grandparents in total, like with my blood relations and then my step parents. So I'm so sorry. Without my grandparents, I don't really know who I would be. My grandma, she would always babysit me throughout my childhood. My mom wouldn't have an income if she wasn't there because she watches my siblings while she works. And when my mom was single, it was like the only opportunity we had. At about 8, I was introduced to my stepdad's mom. She immediately accepted me as her granddaughter, and I never felt less since I wasn't related to her in blood. When I met her, she was raising her grandson. She was a very safe space for him, and she's been a safe space for all of us. My siblings, they always constantly ask for her. So when his dad Take your time. So when my cousin's dad began to hurt him, he immediately felt safe to go to her. Now she only gets supervised visits, as you have heard. All our family wants is for her to be able to see him. She's done so much for our family. All my cousins, she's taught them how to read and to write. She's taught them life skills. Without my grandpa, I wouldn't know lots of stuff too. He takes me places. He's taught me how to ride my bike. It's the small things that really count. I'm sorry. Thank you.
Thank you very much for testifying today. Thank you. It's very difficult for people who are here all the time to testify, so thank you very much for coming here today, okay? Are there any questions? Seeing none, thank you all very much. We'll hear from the person testifying in opposition, Michelle Smith.
Thank you, Mr. Chair, members of the committee. Again, I'm Michelle Smith on behalf of the Maryland State Bar Association Family Law Section. Wow, mood lighting. Did you stop my timer? Stop my timer. Keep going? Okay. All right. So I'm here for the Bar Association, but I'm also here as a grandmother, and my heart breaks for those grandparents and that granddaughter that just testified. The problem is our law does not allow this bill to survive constitutional muster, just as Delegate Kaufman pointed out. It's a travesty. We need to change it, but not through this bill. Some grandparent needs to bring an excellent appellate suit with an excellent attorney and change this law, not only in our state, but in the federal system, because we are dealing with a Supreme Court case called Troxel that requires that grandparents prove that the parent is either unfit or that they fit into exceptional circumstances in order to have either a third-party custody or visitation. That's our law, and we have to live with it until it gets changed, but probably not by this body unless it's going to be a third-party custody statute, which I would be more than happy to work on with anybody here who may be smiling at me. Thank you. We urge an unfavorable report, but it breaks my heart.
Questions?
Mr. Chair.
I'm sorry, Delegate Phillips, I missed you.
I wanted to hear more about the third-party statute.
But when we don't have one, we have a body of case law. It's very complicated, and I could certainly talk to you about it offline. There's a little bit about it in my testimony as well as in the judiciary's written testimony. But it's a set of factors that have to be proven for any third party who wants to be a custodian of a child before you get to the best interest standard. So if we had a statute, that would apply to all the caregivers, whether they be grandparents or not, who are basically de facto parents or who meet other standards. And perhaps the grandparents could get a little more of a leg up if we had a statute that specifically applied to them. The current statute that we have, I think, is 9102, and it's there. Grandparents can file for visitation, custody visitation, but it's so watered down by the case law that, in my opinion, and we've talked about it with various members of this committee before, we really need to focus on an actual statute for third-party custody to try to get grandparents a little more of a leg up.
Thank you.
Mm-hmm. Thank you.
Anything else? All right. Seeing no one else, thank you very much. And that concludes the testimony on House Bill 640. Oh, no, that was that last one. On Delegate Addison's bill. So we're going to go now to Delegate McCaskill. That was House Bill 721 that we just finished. Going to Delegate McCaskill on House Bill 847. We'll hear from Delegate McCaskill. We'll hear from Ronnie Taylor from Free State Justice, who should be virtual. I think it's the delegate's first time before the committee.
I'm sure you will.
Okay. 3 minutes, please. Go ahead.
Thank you, Mr. Chair, for having me and announcing that this is my first time. If it's okay with the body, could I please just introduce so that I have someone here with me called Shadow? Sure. So I have Milani here with me from Morgan State University, who is studying political science and philosophy. Thank you. All right, now starts my 3 minutes? Reset. Okay, perfect. Thank you. So I am, of course, Delegate Alethea McCaskill, and I'm asking for a favorable report on House Bill 847. I am to speak to you about a sensitive topic here in Maryland that we can no longer cower from. Domestic violence has torn apart families, tormented intimate partners, and eroded public trust for far too long. This does not have to be the case any longer. Maryland has the unique and profound opportunity to position itself as a leader in preventing intimate partner violence by making certain amounts of information regarding domestic violence offenders available to the public. Those about to enter in trusting relationships with partners that lead to unknown violence deserve to know all pertinent information regarding their partners before entering committed relationships if they choose. Those entering such relationships built on trust, particularly those contemplating long-term commitments such as cohabitation, marriage, or even starting a family, and this would be helpful. This goes beyond dating. One should have as many resources as possible in the toolbox to make sound decisions. As my mom would tell me since I was a little girl, be always mindful of the company that you keep. No one should be left in the dark about the history of violence that could put you at risk, and violence that could have otherwise been prevented. Please keep in mind, according to the CAWC Connection for Abused Women and Their Children, nearly half of domestic violence cases go unreported. By assuring that certain information regarding domestic violence offenders is accessible to the public, we can take a step forward with transparency, accountability, and most importantly, safety. While the passage of this bill will make Maryland a trailblazer in prayerfully preventing partner violence, such a registry is not a novel idea. States across the country have taken brave steps towards publishing necessary information about domestic violence abusers. States across the country, including Oklahoma, Tennessee, Vermont, and New York, have already recognized the urgent need of such measures and have implemented similar similar policies to empower individuals. There are many states with various laws and various punishments for this type of behavior. Please do not take this bill for granted, nor should you think that this bill is only to protect women. For this bill is to protect men, women, children, and those who deem themselves any gender identity in which they choose. By following in their footsteps, Maryland just has the opportunity to both join a growing movement and set a new standard in how to combat intimate partner violence. Remember, the intent of this bill is not to overprescribe penalties to any certain group of people or the prevention of recidivism. The intent of this is to warn individuals who may be seeking information whether to be intimate partners or not. I am asking, so I didn't know here in Judiciary that we also had 3 minutes, but I think I did hear you say at the top. But thank you, Mr. Chair, and hopefully you all will indulge me with questions on the other end to make up for what I also would like to say.
Oh, no, we never do that in this room. Never, ever. Delegate Grammer, I wonder what you'll ask about.
Thank you, Mr. Chair. Can you send us a list via email of the other states that do this, maybe with some links to policies so we can actually look at their statute and what it looks like?
We absolutely can. Thank you.
Is there anything else that you wanted to say?
That's actually one of the things I did want to say. Thank you.
Within reason. Did you have some other points you wanted to talk about?
If that's okay with. Sure. Okay, I just want to make sure.
We close at midnight, it's fine. Everyone else behind you is waiting.
Okay, listen, so that everyone can have dinner at a real dinner time today. I just want to say, that I have read through the opposition. I have had conversation with the Maryland Office of Public Defenders. I have had conversation with many others. I know that there is a lot of concern around the fiscal, and we can discuss that. And there also is concerns about the victims being exposed. We can also discuss that. Part of their concerns is about them getting penalized again if they knowingly submit incorrect information. Well, I just want to say that is deceit, and so they just have to make sure that this is part of being preventive and not having repeat offenders, but also for folks to protect those who may possibly want to date or may not know that they're in these kind of relationships. And so I just wanted to make sure that I added just that. Thank you, Mr. Chair.
That's fine. We're going to hear from Ronnie Taylor. I should have heard from Ronnie Taylor, who is here to testify in favor of the bill. Please, go ahead.
Awesome. Thank you so much. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the House Judiciary Committee. For the record, my name is Ronnie Taylor, and I serve as the Advocacy, Policy, and Partnerships Director at Free State Justice. I am also a survivor of domestic violence. I know what it means to live in fear, what it means to wonder if today is the day where my name will become another statistic, and I am here today to urge you to support House Bill 847. This bill establishes a domestic violence offender registry in Maryland. It's not complicated. It's about public safety. It's about giving survivors, people like me, the ability to make informed choices about who they want to let into their lives. It's about making sure that those who abuse and abuse again are no longer allowed to hide in the shadows. The facts are clear. Domestic violence doesn't stop unless we stop it. Those with multiple convictions are more likely to reoffend. This registry will make that information accessible, not just to law enforcement, but to the people who need it the most, which is survivors. LGBTQIA+ individuals, particularly Black and Brown transgender women, experience intimate partner violence at alarming rates. Yet too often, they do not seek help. They do not trust the system. They are afraid of being outed, dismissed, or worse, ignored. I too felt all of these ways. This bill gives them a tool, a chance to protect themselves. We register sex offenders, we track repeat DUI offenders, we know that patterns of harm exist. Domestic violence is no different. I urge you to issue a favorable report for House Bill 847. Survivors deserve to know who is dangerous before it is too late. Thank you.
All right, Now, questions. Any further questions for those in favor? All right. Seeing none, we thank you very much. That concludes those people in favor of the legislation, and we're now going to go to Office of the Public Defender who's opposed to it. Vanita Taylor, please.
I apologize. You all usually know I have a cane, so I'm trying to do it without it. So deep breaths.
You did great. We didn't even give you that hard of a time in this. I don't know. We're losing our edge. It's nothing. Thank you, Delegate McCaskill. Ms. Taylor, please, for 2 minutes.
Good afternoon, Chairman Clippinger and honorable members of the House Judiciary, Public Defender's Office. And my name is Vanita Taylor.
You need to talk into the mic because, yeah.
Did my 2 minutes start again?
There, yeah, start again.
Good afternoon, Chairman Clippinger and members of the House Judiciary. My name is Vanita Taylor. I'm from the Public Defender's Office, and I was with you till 9 o'clock the other night. And I'm glad I'm early. Thank you so much. The Public Defender is requesting an unfavorable report on this bill. House Bill 847 is a bill that purports to solve a problem that doesn't exist. We have Maryland Case Search. For any crime, the public can go on Maryland Case Search and look up somebody, and it's there. It's accessible. It's available to the public. Registries are things that make people feel good, but there's been no data. I did some research to try to find some data that they actually promote public safety. This kind of registry doesn't promote public safety. What it does is it makes it difficult, frankly, for people to make agreements about cases. If you're in district court and you see one of these cases, they go very quickly. Many are no pros, PBJs, nolo contendere. They are suspended sentences. They're not incarcerable offenses. And the public defender is able to move those dockets and get it done. And what happens now is you're going to go on a registry, and your penalty for not registering can be far worse than the penalty for whatever act you did. People don't check registries. It's something that if it's there, it makes all of us feel good that we've done something. But when you're dating someone, who checks a registry? Who would check this registry to say, I need to find out if he's on this registry or not? Who does that? I did a poll of my nieces and now you two, because you're, see, they're cutting into my 2 minutes. The bottom line is this. There's been research done that the registries are ineffective and do not do what they're supposed to do. You can get this information from the case search in Maryland without adding another fee. This is another fee and cost that adds to the budget in this state. We request an unfavorable response.
Thank you, Mr. Chairman. Thank you for coming in to testify. I believe you just saw empirical evidence that it does happen. People do check. And in specific, in this bill, it says 3 or more times. So do you think that since you know people do check and you're talking about 3 or more times, you would like to revisit this issue?
Unfortunately, Delegate Conway, most people do not check. These members are great ladies, but if we had a registry for domestic violence, it also exposes both the victim and the perpetrator. The plaintiff and the defendant are exposed by this registry, by the information that it will contain, and it is public knowledge.
Okay, I just want to be clear. You just said the ladies.
The ladies who are here.
Yes, but there are men that check this too. Okay, so I mean, you can take that statement for what it is, but we're sensitive to him, her, them, they, everybody, okay? Thank you very much.
All right, seeing no further questions, we thank you very much.
Thank you.
And that concludes the testimony on House Bill 847. I understand that the Department of Human Resources is in their budget hearing across the way. So we're going to go to Delegate Phillips with House Bill 1165 and jump a little bit out of order here. And we're going to hear from Delegate Phillips, Kwame Rose, Marcus Trent, Marilyn Goldstein, Antoinette Baynard,
and everybody.
Marvin Garrison, Kim Sadaka. We can try and get everybody up there.
Everybody.
Yeah. So I'll repeat because we've got people coming in now. Kwame Rose, Marcus Trent, Marilyn Goldstein, Antoinette Maynard, Marvin Garrison Jr., and Kim Sadaka. I see you, Mr. Dews, but you're there as favorable with amendments, so I'm going to take you after. You said you want an amendment, so these guys said favorable. So we're gonna do this. All right, Delegate Phillips. If we need another chair, we've got a couple. We'll figure it out. May have to play musical chairs.
Can we grab?
Hi there.
All right. Okay, and there was one virtual. Delegate Phillips.
Thank you, Mr. Chair. For the record, N. Scott Phillips, 10th Legislative District, and I'm here requesting a favorable report on House Bill 1165. I come to you today on a bill that's designed to ensure that non-custodial parents can exercise the court-ordered custody and visitation rights in a timely and an enforceable manner. You will hear today from witnesses who have struggled to secure relief through the existing judicial process. The reality is that when a custodial parent fails to comply with a court-ordered visitation, a joint custody arrangement, the non-custodial parent must seek enforcement through the courts. This process is onerous and time-consuming, often taking 6 months or more before a petition is addressed. It's also expensive. It's also harmful to the child. A system that allows these delays to persist does not meet the best interest of the child. We heard from our therapist earlier to talk about the best interest of the child because it prioritizes bureaucratic process over a child's right to maintain a meaningful relationship with both parents or their custodians. Too often in our communities, a child's access to both parents is interrupted by the relationship between those parents. This disproportionately affects non-custodial parents, particularly fathers, and contributes to long-term negative consequences for children, including emotional distress, feelings of abandonment, strained relationships with the absent parent, academic and behavioral challenges stemming from instability in parent involvement. The current system forces these parents to rely solely on the courts for relief, yet the courts' procedural inefficiencies exacerbate the problem. I welcome discussions on refining the language in House Bill 1165 to address concerns or perceived shortcomings, but the fundamental policy issue remains clear. If a parent is adhering to their court-ordered visitation or joint custody responsibilities, they should not be denied access to their child due to the custodial parent's failure to comply. In conclusion, I urge this committee to provide a favorable report on House Bill 1165 as a necessary step toward ensuring that Maryland's legal system does not unintentionally harm children by allowing unjustified, prolonged separation from a parent who has been deemed fit by the court. Thank you for your time and consideration, and we look forward to answering additional questions.
I'll go. Thank you to the chair, vice chair, and all the committee members. Thank you to Delegate Phillips and the co-sponsors for this bill. My name is Kwame Rose. I'm a co-founder and managing director of Foundation for Fathers. We worked really hard to try to put forth a bill that we could at least get out of committee this year. I'm here testifying in support of House Bill 1165. And just to be frank, in 2022, the National Parent Organization gave Maryland a D- on their shared parenting report card, ranking Maryland in the bottom tier of states in respects to custody law. In 2024, the Maryland legislature failed to enact a single bill that would improve custody laws in our great state. To put it plainly, it is time to bring custody law and equal parenting rights into the 21st century in the state of Maryland. This legislation is about putting forth a mechanism of accountability in place to ensure that a child has equal access and time with both parents, and that a child is not punished by missing the opportunity of bonding time with an aggrieved parent. Currently, Maryland law has loopholes that enable the possibility for parental alienation, which ultimately only harms the child. The way the law currently works is if as soon as you go to court and get a custody agreement, there is no mechanism of enforcement other than filing for a motion of contempt in order to have that court order enforced. The child suffers, the non-aggrieved parent suffers, and Maryland law, this bill would erase that loophole. There's overwhelming data to support that joint legal and physical custody is in the best interest of the child. By enacting this law, it will not only close the legal loophole that currently exists, but in doing so, it ensures that a child can have a relationship with both parents despite whatever legal issues there may be. If it takes a village to raise a child, then it takes a community to support the family in whole. And that is why we are here advocating for you to vote favorably in support of Bill 1165.
Would you like to go next?
I'll go next. Would I press that?
No, don't touch.
Okay. Hi, my name is Kimberly Sadika, and I'm coming to you. First of all, I want to thank you, members of the Judiciary Committee and Mr. Chairman, for listening to this. I'm coming to you as a mom, a grandmother, a teacher, as well as a grandparent. I am a teacher for home and hospital. I teach a lot of children that are going through a divorce. When these children are going through a divorce, these kids feel alienated, they have emotional confusion. When these kids have emotional confusion, they are literally harming themselves because they don't know how to handle the situation. I'm dealing with kids that are stabbing themselves, I'm dealing with kids that are cutting themselves, and they're being put in between each parent. And what's happening is we need to put these kids first. We need to understand that they need both the mother and the father to have an influence on them. If a parent is in a different state and the parent cannot see the kid, let the parent at least talk to the student. Let the parent talk to their child. It's very important that we influence them. These kids are having a lot of anxiety, a lot of depression, low self-esteem. I have 7 students from Severna Park High School right now. That is not acceptable. We are seeing all these kids that can't even function in school because there's too much going on at home. We have a lot of attachment issues. We have a lot of identity struggles that are going on with these kids. These kids, when they're sitting at their sports events, one parent isn't there. Wouldn't it be nice if everyone could just sit together and the kid feel like they are accepted by both parents and they don't have to choose who's going to be at their game that day? Most of all, we see these kids having social withdrawal, a lot of behavioral issues. When I go to teach these kids, I can't even teach them because they're not ready to be taught. Thank you.
Good afternoon, Mr. Chairman and Judiciary members. I appreciate you having us here today. Hopefully, first of all, my name is Marvin Garrison. This beautiful lady sitting next to me is Antoinette Maynard. She is actually the blood grandmother of the children that I'm going to speak in favor of. So having said that, I'm in favor of House Bill 1165. In the next minute or so, I'm going to try to give you a unique perspective of our household. It is indeed a village. All of her children live there, and our oldest son, her oldest son, our oldest son, has a wife and 4 beautiful boys, Mason, Sebastian, Eli, and Cairo. I've just come to this household over the last 4 years, but we've been together for 6. So I've inherited these boys. I am also a father, so I know the importance of being the proper example for those to live by. Prior to me coming there, my fiance was there for these boys. In fact, their mother, who was put out of the house at 15 and pregnant with the first boy, came to her, and she was taking care of all of them until I got there. Over the last 2 months, unfortunately, there's been some domestic things going on, and now the mother has alienated us from the 4 boys. It's been devastating. It's to watch her go through this emotionally has had its toll not only on her, but on me. And more importantly, we now wonder what the boys may be going through from not being able to be around us. I am hoping that by this legislation being introduced, things like this can not only not happen to her, but more grandmothers. So I appreciate your time, and thanks again.
My name is Marilyn Goldstein. Thank you for this moment, Mr. Chairman and the members of the Judiciary Committee. I'm here today to express my full support for House Bill 1165. As a grandmother, I have experienced firsthand the devastating effects of being not able to see my 4-year-old grandson, Levi. He couldn't come in today, but I brought him with me. It's currently been over 5 months. I have loved, nurtured, and cared for my grandson. As a supportive extension grandmother, when I was going through my personal surgery, it was Levi that gave me a warm hug and came by to see me every other weekend. Grandparents play a crucial role in the lives of children. They provide stability, wisdom, and unconditional love. That shapes their growth and development. Yet, when visitation schedules are ignored and no system enforces them, we are forced then to be powerless, and more importantly, the child suffers. This bill will ensure that court-ordered visitation is upheld, and that those who deny it without any just cause are held to some accountability. It would ensure integrity to our legal system, and more importantly, safeguard the best interests of the child by ensuring that they maintain strong relationships with both parents and their extended families. I urge you to pass this legislation. Families deserve protection, and it hits all of us and the children who deserve to be surrounded by all those who love them. I'm a living witness that this law is not necessary.
Thank you.
And that it is urgent.
Thank you.
Thank you for having me.
Sir? Thank you. You turned it off?
Thank you. My name is Marcus Trent. I'm the Executive Director of Fathers Fighting for Fathers Community Mentorship right here in the heart of Baltimore City. And I know that this committee very well. I know that y'all have courage. I know that y'all have wisdom and practical understanding because you passed House Bill 440, Senate Bill 42, Relocation of Child Safety Act. It went into law last year. Honorable Senator Nick Charles, Governor Wes Moore signed into law. So I know that this committee is very well capable of common sense, of looking at practical things. I could have easily brought a bus up here of 100 fathers, but what I did brought was grandparents to show that what happens when one parent, for whatever reason, is getting alienated, it affects the entire community. It really does. And so, you know, I'm very optimistic, and I thank the delegate, and I thank the supporters that came, but we really urge each and every one of you to look over this bill, find it unfavorable. My daughter, Layla, I brought a picture of her so you can see her. Beautiful, bright, young, with the world in front of her. And this is sometimes what we have, pictures to hold on to, right? Pictures to hold on to until the next 90-day session come around that we're here begging. So I really do appreciate y'all. I appreciate y'all support, your efforts. I know this stuff takes a lot of time, but If it's in the best interest of the child, it's in the best interest of the family. Thank you.
Thank you, Mr. Chair. Thank you all for being here. Thank you, Delegate and Senator. I know this is important to you, and we've talked about these issues together over the years. I wanted to give you an opportunity to respond to some of the judiciary's concerns that while they think your goal is laudable and that people violating orders doesn't make anybody more angry than the judge who wrote the order, that they think that the 10 days is going to be almost untenable for them, and that they worry that in those high conflict cases where you're dealing with a lot of times undiagnosed mental health conditions in both of the parties sometimes, but certainly often in one party, that leads to this constant conflict, that it would actually exacerbate those kind of issues because the party that's maybe not as on a steady footing would continuously use this 10-day thing. Oh, she was 15 minutes late, filing for another 10 days. Oh, she was 20 minutes late today, filing again. That's kind of what they've laid out as their concern, and that at the end of that, if we're looking from a best interest perspective, is a child whose mom and dad are now drugged back into court every 10 days, basically, because the mom has, ADHD and can't show up on time to save her life, whatever, something along those lines. So I just wanted to sort of paint a kind of picture and get your feedback.
So Delegate, that's a great question. And yes, I did read the judiciary's letter. And this is what I would say. At the end of the day, 6 months is too long. A year is too long. And the stories that I've heard from non-custodial parents, and I want to stress non-custodial parents, I didn't use a gender. The stories I've heard are just untenable. And so while I understand that there's judicial efficiency,
right,
if we're working on the best interest of the child, what judiciary has not come back and said is what they could do to make this system work truly in the best interest of the child.
Yeah.
There are all types of studies that talk about emotional, emotional attachment theory, right? And when you remove, or when a child does not have contact from a close, personal, intimate relationship with a parent, they lose that attachment. And we talk about some of the ills in our society. We have a lot of children that are growing up in single-parent households. And so they're losing that detachment from the non-custodial parent. It impacts what happens to them in school. It impacts how they respond to stress. Those things are proven. I mean, these are, once again, I think our psychiatrists or psychologists talked about that with the grandparents. So the fact is that we have a system from a judicial process. It is to ferret these things out, but it, in my opinion, is not working in the best interest of the child if we could go 6 to 12 months before we come through with some type of resolution.
Yeah, I understand. I mean, in my own case, when we actually got our first emergency hearing, I think it was like 8 months for an emergency. That was part of that was my county, the backlog. So I definitely see that there is an absolute issue in the scheduling of family law cases. I know that, my ex and I both of us would agree on just this one thing. That process took way too long for both of us and for our kids. So maybe it's a funding issue. We're still dealing with COVID backlog. I mean, and the other piece that gets forgotten a lot, because it's family law, a lot of these judges, most of these judges, do all kinds of cases. So we have the right to a speedy trial on the one hand, so our judges are pulled from family law, put in criminal. I mean, my own case in the last couple of months got delayed because there was criminal things that came, so it's such a convoluted situation, but a lot of it is just the inability of us to get these cases heard in a timely manner. And it's hurting everybody, I agree, and it's hurting the kids too. So thank you for taking a look at the opposition.
If I could just also add, because your question was about the procedural issue of what if a parent is 15 minutes late. So in order to file this motion, you would have to then You file the motion, but you give an explanation. So,
Right.
and then the judge would have the discretion of approving the emergency hearing or denying it. And so the judiciary's concern it still does not limit the judge's ability to approve this emergency. You have to explain, like, oh, okay, this isn't about being 15 minutes late. This is about this parent has denied me visitation for the last 48 hours or 3 days, and whatever, however long, and it gives that immediate recourse. But it's not intended to deal with, the petty back and forth that co-parents are like inevitably going to have.
Right. So that's interesting. So in their letter, I'm not sure if everybody's on the same page on sort of what that would look like, because they think that the without just cause would be essentially established only by the petitioner, that they wouldn't be able to weigh into it without granting this hearing. So the way you guys are foreseeing it is that there would be a petitioner files this petition, writes down what their justification is, and then at what point before the actual hearing would a judge look at it and say, I'm denying this? So there would be like a hearing before the hearing?
No, so what happens is, so like in other states, you have, so in like Washington, D.C., just because of the proximity.
Yeah.
If a parent is violating the court order, it has to be extraneous circumstances to get an emergency hearing.
Right.
The judge, then it's sent to the judge's chambers, and within like 24 or 48 hours, the judge issues a decision about, yes, this is an emergency, please be in my courtroom by such and such time today.
Okay.
So it's
That's
not
how
a
it works.
hearing.
It's not a hearing.
It's reviewed while the judge is in chambers, and then.
And I would equate it similar to kind of you might get a temporary restraining order, and then the judge would call you in to argue the facts of the restraining order.
Okay. I understand that a little bit better. So, all right. Thanks, guys.
I would just double down that we're not here, for petty situations. They are real life parents on both sides, but many of the fathers were grandparents. We're talking about, 2 or 3 months that they have gone, about.
Yeah. I mean, I've heard of some pretty appalling cases of people violating court orders. Oh, yeah. Somebody probably just leaned on them back there. Yeah.
Mood lighting.
Yeah, it's very romantic in here now as we talk about divorce and custody. Okay. Well, I appreciate you guys sharing your stories, and I'm sorry for those of you who have gone through this. There is no greater punishment than not being able to be with your children.
Thank you, Mr. Chair. Short of this mechanism, what is the remedy of the court to deal with these issues? What is the mechanism we use now?
You apply for an emergency hearing, as Delegate Arkan said, and you wait for the court to give you your date.
Something I've been picking at in the back of my brain as not related but not directly correlated issue is how long does a court from jurisdiction to jurisdiction take to respond to issues like that? Do you have any data, like statewide, for the jurisdictions, how long it might take, for example, in Baltimore County versus Prince George's versus Garrett County? Do you have any of that data at all?
I don't, but we will request it. I know last year we requested that data and did not get it. And so we were relying on anecdotal data. But I will request it again.
And I think that's important because Delegate Arkan kind of picked at it. Like, the courts really just aren't. Are they staffed properly? Are they responding in a timely manner in general? And I think at least if we could take a look at that data, how long it takes to respond on a statewide basis in a jurisdiction to jurisdiction comparison, I think that'd at least be formative for me to kind of look at this broadly. Because if we could maybe deal with this more effectively by just analyzing how long the courts are taking to respond, I think that might be a start.
So, there's representatives from different organizations. We both help fathers in, different jurisdictions throughout the state of Maryland. And in doing so, on average, we're seeing like 5 to 9 months for the next court hearing. And I don't think it's an issue of if the courts are staffed properly as much as Maryland law is just very vague on the protections of the non-custodial parent and instituting punitive damages for violating person. And this is not an issue that's unique to Maryland, but this is why some other states have instituted punishment for a violating parent for the custody orders, because the custodial parent realized that there was no way to enforce these court orders once you left family court. And so folks started taking advantage, and you see states like Ohio or Delaware who have instituted these punitive measures for if you violate, these are the remedies, and the judge is then bound to issue an order based on the specifics that the law has. But Maryland law currently is just very, very vague and leaves too much gray area.
I get that argument. My broader concern is I've asked similar but different questions about family law, and there seems to be a giant discrepancy jurisdiction to jurisdiction and how long it's taking the courts to respond to family law issues, which frankly are probably some of the most impactful on a day-to-day basis for families. So I think, it'd be formative for everybody if we could say, if we're looking at like a 3-month difference between jurisdiction to jurisdiction, I think it's something we maybe take a peek at.
And I will do that. I'll go back and try to do that again.
Yes. My question is, Delegate Ercan, by being gracious and sharing her personal story with us, sort of alluded to this, but why is it so important to reduce the time to get into court? And my second question is, the Women's Law Center of Maryland is opposed to your bill because Judge O'Malley, who's the executive director, contends that what you want to accomplish, Delegate Phillips, is already accomplished under family law 9-105, unjustifiable denial or interference with visitation. So I wanted to give you a chance to answer those two questions.
Sure. Particularly in early years, once again, the separation of a parent from their child, the brain doesn't, the brain develops at about 75% of its capacity between 0 and 5. If you think about that, and you think about taking a parent out of that equation for that period of time, it has a long-term significant impact on that child. So that's one of the reasons we've got to speed this process up. To Judge O'Malley's point, we're back in the same thing with Delegate Ercan mentioned. So yes, you can proceed under that, but if it takes you 6 to 9 months to get into court to address the issue, then that's not a remedy that is in the best interest of the child. Once again, I'm really focused on what's in the best interest of the child and what has been shown through developmental studies that we need these parents in the child's life. And any extensive separation is not healthy for the child.
Thank you, Mr. Chair. Thank you, Delegate Phillips.
Seeing no further questions, thank you all very much. All right, we'll hear from Christopher Dews, has a favorable with amendment testimony.
Mr. Chair, members of the committee, Christopher Dews for the record. Believe it or not, Delegate Ercan actually addressed the vast majority of the concerns. We don't have the privilege of seeing what testimonies have been submitted in, but our concern was the definition of just cause and simply how is that determined? And I believe that was actually answered in the original panel and hearing, that it's not going to be, well, the person came 15 minutes late, and so now it's kind of used against them in that capacity. So that's it. And I thank the sponsor for putting this bill out there. We think it's very important that families come together and that the visitation rules are followed. And I guess move favorable.
Seeing none from Mr. Dews, thank you very much. Now in opposition, Michelle Smith, and then also listed in opposition, virtually Eric Smith, not here. Michelle Smith, please.
Thank you, Mr. Chair, members of the committee. Very lively questions for that, so I'm just going to dive right in and respond to some of the questions. My name is Michelle Smith. I'm here from the Maryland State Bar Association Family Law Section. It is true, as Delegate Kaufman pointed out from another written testimony, that this is already accomplished in 9-105. I have a great deal of respect for the delegate sponsor of this bill and have testified about this bill previously. What I understand him to be saying today, and maybe he'll correct me if I get it wrong, is that he wants an expedited hearing. And that may be accomplishable by changing 9105 to suggest some procedure that's expedited. Some of the language in this proposed bill would conflict with 9105 and the law, so we have other problems with it. But if it's just really getting an expedited hearing, because I do agree that there is great discrepancy, and now the delegate's gone that asked this question, but there is great discrepancy across our state as far as how fast you're going to get a hearing on this issue. And some of it is too long. But I want to dispel these myths that there's going to be a judge who's going to do a chamber's review of these motions and within 24 to 48 hours issue a ruling. No, not happening. Doesn't happen now, and I don't think it can happen. It's also not akin to a temporary protective order. That would be you getting a hearing immediately in front of a judge on this issue. That's a completely different process in the protective order scheme. So with regard to this particular statute, this bill, we would suggest an unfavorable report. It really defies due process because there's 15 to 18 days that the person has to respond to a petition. So we can't even get it set within 10 days for due process reasons. We have other reasons why we would like you to issue an unfavorable report that are in my written testimony. Thank you.
Thank you, Mr. Chair. Thank you for being here and helping us with this, grapple with this. So your suggestion is that we tweak 9105 and sort of put in an expedited, but it would not be able to be the 10 days because of the way the system's already set up. So what about like 30 days? Would that be, do you think, something that's doable?
I just want to correct the record that I'm making that suggestion, not because I think that we've thought it through sufficiently in order to come up with an amendment, but I'm willing to talk with the delegate about that. Okay. I don't know about 30 days. I think we should get some input from the judiciary. Mm-hmm. Now, I did work with Senator Charles on the relocation bill that passed last year, and that was successful. So I would point us in that direction. Look at the language in that bill.
Okay. Okay. So there's maybe potentially something we could do here, but maybe we would need the judiciary to also come to the table. Maybe this turns into a work group. I don't know. Just a suggestion.
No comment. But you know, if I were directed to, I would certainly serve on such a work group.
There we go. All right.
Well, that's one. Only need like 25 other people.
Okay, you can put me. You can put me on it too.
All right. Seeing no further questions, thank you very much. That concludes the testimony on House Bill 1165. Now, the department. We have an administration bill here. This is House Bill 218. Who's coming up from the department? There are a number of people testifying favorable with amendments. And then there are several people who are unfavorable. So we'll hear from the department first. And whoever wants to present the bill, I'm going to give them 3 minutes and then 2 and 2. So whoever from the administration would like to present, do the overview of the bill, that would be fine. And then we'll go from there. So who'd like to start? Go ahead.
Good afternoon, Chair Clippinger and members of the committee. I am Carnitra White, and I serve as the Principal Deputy Secretary for the Department of Human Service. With me at the table is Joe Jones from the Center for Urban Families and our Executive Director of Child Support Administration, Jonas Johnson. Today, we respectfully urge your favorable report of House Bill 218, including our sponsor amendments. House Bill 218 relies on research and data from successful states to make innovative, audacious, and long overdue changes to Maryland's child support program to strengthen families. The purpose and function of child support programs have evolved since 1975, when the program was first authorized. HB 218 will better align Maryland's child support program with the function and purpose of child support programs today, strengthening families by ensuring children have support of both of their parents. To ensure children have support of both parents, this legislation expands collection options and streamlines our tools when a parent is unwilling to pay without punishing parents who want to pay but cannot afford to do so. Our work at DHS is meant to invest in and support families, not punish them when they are trying to make ends meet. The tools at our disposal are engagement tools to encourage parents to pay and offer support to those who are unable to pay. HB 218 is comprehensive and its provisions are designed to work together. It represents the first major overhaul of the state's child support system in decades by focusing on equity. I'll lift up a few parts of our bill that implement our vision for a more equitable child support program in Maryland. HB 218 will cap the maximum amount of child support payment and arrears at 25% of the parent's income for individuals making less than 250% of the federal poverty guidelines. The bill would require a multifamily adjustment to the amount of child support order because a parent might support more than one child. Our legislation would end transferring child support payments to foster care when a child must be in out-of-home care. This is a critical change that data clearly demonstrates safely reunifies families faster. And when child support orders are more equitable, parents can avoid arrears and enforcement actions while improving payment consistency and reliability. If arrears occur, this legislation would provide additional time to help parents remove barriers to payment. House Bill 218 would administratively exclude from the driver's license suspension program non-custodial parents whose income is equal to or less than 250% of the current federal poverty guidelines. We appreciate your favorable report and appreciate the opportunity. Now, if you would allow Mr. Jones.
Yeah. Good afternoon, Chairman Clippinger and members of the House Judiciary Committee. My name is Joe Jones, founder and CEO of the Center for Urban Families, a West Baltimore workforce and family strengthening organization that advocates for legislative initiatives that strengthen urban communities by helping fathers and families achieve stability and economic success. CFUF supports Governor Moore and the Department of Human Services House Bill 218 with the inclusion of the sponsor amendments that they have introduced today. An Urban Institute study has found that non-custodial parents who earn less than $10,000 owe 70% of the child support arrears. In CFUF's primary service area, there are 5 zip codes where there are 8,000 individuals who owe more than $120 million in back child support. HB 218 brings a realistic and balanced approach in 3 ways. One, it sets the maximum wage garnishment rate at 25% for Marylanders earning less than $250,000 of the federal poverty guidelines. In essence, you think about Bill Gates. If you took up to between 50 and 65% of Bill Gates' income, he may be pissed, but he would not be destitute. You do that for low-income dads who earn less than $10,000, you put them into a situation they start working in the underground economy, and most important, they are not tax-paying citizens in the state of Maryland. Number 2, it recognizes that child support guidelines should reflect the fact that family compositions have become more complex and that child support orders should be calculated based on all children and the obligor, the non-custodial parent financially supports. And number 3, it eliminates the requirement for the Department of Human Services to pursue a child support order against parents whose children have been removed into foster care. And finally, we are encouraged by the department's willingness to work in collaboration with CFUF and other partners. As Governor Moore likes to say, those closest to the problems are closest to the solutions. When the government works with impacted individuals and the people and organizations doing the on-the-ground work, legislation is more fair, more effective, and more meaningful. I urge a favorable with amendments report. Thank you.
Ms.
Answering technical questions. Okay. There we go.
Whoa.
Now it's really bright. All right. We'll take it. We'll take it. Questions for the panel. Delegate Tolles, I think, and I saw Cardin.
Good. Oh, I thought Carter. I was trying to.
Yes, please.
Thank you, Mr. Chair. Just a real quick question. So I don't usually get in the minutia, but there's a lot in this bill. It's like 25 pages. We don't often get 25-page bills here. So page 18 talks about independent contractors requiring them to submit Social Security numbers within 20 days. So I'm thinking, I mean, in this day and age, we have like Walmarts and we have people are coming in and out, Amazon delivery people, I don't know if they're independent contractors, Uber people. There could be in 1 month, there could be in Maryland, there could be hundreds, if not thousands of independent contractors coming in and independent contractors leaving. And I'm just wondering if you're creating more work for yourself with this 20-day requirement. And also, it looks like there's penalties for the employer. And I'm just wondering if there's, if that may be a little onerous on just about everybody, including you guys. It's page 18, line 24. Subject to the provisions of subsection, within 20 days after an independent contractor begins employment, the independent contractor's employer shall submit to the administration the Social Security number or the tax ID number of every single employer. So every month, you're gonna have to hire like Uber's probably gonna have to hire one person or two people just in the state of Maryland just to be reporting this, I would think. I'm just curious.
Don't press it. Oh, don't press it. Oh, okay. Can you hear me okay? Yes. Okay, sorry about that. If I'm not mistaken, Social Security numbers are already being reported to the administration, and it's primarily for matching purposes. We match through the Social Security Administration. We want to ensure that we have the right person by having the Social Security number, because as you know, that's a unique number. We don't want to match someone solely on the name because you may pick up someone inadvertently and it would be an error. So that's why we do ask for Social Security numbers.
That's excellent. I think that's great. So I think that that on 1099s, you have an annual reporting. This is every 20 days. So this would be like 20 times a year, but it can't be like a specific date of the month because it's got to be at least within 20 days of each employee, each independent contractor coming in.
This is on new hires, on newly hired individuals.
Right.
So right now, the current law requires that they report on newly hired individuals to the administration. We're simply asking also that they include the Social Security number of that individual.
Okay, so yeah, I'll check that. That's interesting information. Okay, thank you.
Thank you very much, Mr. Chair. So let me kind of piggyback a little bit off of Delegate Carbon's question. I think what he's referring to is a possible burden to the employer, because now you're asking for additional information that they normally would not necessarily pass on to you in a 1090, with the 1099 information. It appears to me like what you're attempting to do is probably treat people as though they're W-2 earned income earners as well. And so I think that's what we're talking about. Now you've created more of a burden for yourself. So just, if you want to comment a little bit more about that, you're welcome to do that. But I have some other questions as well. So let me kind of run down all my questions to you. Maybe that can help a little bit too. You've also added additional time on contempt proceedings, okay? So now we've gone from 3 to 7 years. Talk to us a little bit more about this, because we do need to dig in a little bit into this legislation, because it is, as Delegate Cardin mentioned, multiple pages that we've not dealt with before. The other thing also is the procedures around winnings, and I'm talking about the fantasy competition, the sports wagering. Kind of what are your procedures or thoughts around how this would really actually work? And then the other thing I'd like to talk about too, or ask you to talk about, is the liens on personal injury awards. So if you could possibly talk about those 4 different things, that would be very helpful to us to understand this bill a little bit more clearly.
Okay.
Get all that?
And I'll walk it back as I need
Let's
to.
start with question number 1. Why don't we give that the short version?
Can I come back to number 1, and can I start with the contempt?
Okay.
It's challenging.
All right.
Yes.
Yes.
The president will keep track.
Currently, under the statute of limitations ends when the child emancipates, 3 years after the child emancipates. Currently, we are not able to file any contempt or anything as far as going into court. We extended the time from 3 to 7 years after the child emancipates because it also allows us an opportunity to engage with the non-custodial parent. And it also does not allow a custodial parent, if I'm not mistaken, to even file pro se after the child has emancipated for 3 years. So their support, as far as the arrearages are concerned, we're left to the administrative tools that we have. And if those administrative tools don't work, then there's nothing that we can do to collect the arrears that are owed to the children or to the custodial parent on behalf of the child. So that is one of the main reasons for the extension of the contempt. Allow us more time to engage, allow the opportunity to collect the arrears that the child was due prior to the child emancipating, because the statute of limitations ends 3 years after the child emancipates. Did that answer that question?
It does, but 7 years, extending it even more, 4 years more is a lot of time.
Yeah.
So I think that's something you should really think about, procedurally, how we could, lessen the time, what more we could do about that particular area. So that's one question down. Okay.
Okay. The lottery, the winnings. We, fantasy and sports betting and all of that, that's big in Maryland now, or it's getting larger, I should say. The administration currently already intercepts casino and lottery winnings. We wanted to bring sports betting in line with the lottery and casino to allow that as another avenue to collect on behalf of the custodial parent for the benefit of the child.
So approximately how many parents or how much are you intercepting, I guess, in the casino and lottery right now? Because that kind of gives us maybe a baseline to deal with the sports wagering. I'd like to just understand how many parents we're talking about that fall within it, because I believe that you only have to provide information on your winnings if it's over $2,500. So, how much are we intercepting, or how many parents is this really affecting? Do you have an idea? And if not, you can get back to us on it.
Yeah, I'll have to get back to you on that one,
Okay.
because I'm not sure right now what the cap would be, because definitely we wouldn't want someone that has maybe $20 or $25 for that to be intercepted. So I would have to get back with you on the cap. And I will also get back with you on how much we intercept currently for lottery and casino, which we don't know about sports betting because we don't have that data right now.
That
So we
information's
wouldn't
not
have
there.
that.
But, and also, what is the percentage that you guys actually take from the lottery winning?
We'll get that to you as well.
Okay. Because, what I guess I'm getting at is, if there's a person that is a lottery winner and they win $1 million or whatever it is, how much are we saying that we would take for arrearage, from that person? Is it a 25%? Is it all the money? Is it
I was
all
going to
the
say,
arrearage?
I'm saying cautiously, but yes, it is up to the amount of the arrears that are owed. So if a person's lottery winnings consist of $50,000, if the arrears are $50,000, then we will get the $50,000. If the arrearages are $25,000, we would only get the $25,000, and he would take home, or she, the $25,000. So it's whatever the amount of the arrears.
Okay, all right. And then personal injury liens.
Okay. Personal injury for the liens, it's 25% of an award, and it's the net income. So if a person wins a lawsuit because of a personal injury claim and they are awarded a certain amount, then the administration would be allowed to intercept the 25% of that amount, not the entire amount. No, that person would still be able to pay legal fees, medical bills, and so forth and so on. So it would only be the 25%.
And why is there a difference between the lottery amount that you're able to withhold or to intercept versus the lien on personal injury?
Because a personal injury could mean that a person could be out of work, unemployed due to a personal injury. And if definitely we would not want to intercept the entire personal injury, whereas a lottery or casino winnings may not have anything to do with the employment.
But it could be life-changing for someone.
It could be, yes.
Okay.
Yes.
So just thinking about that as well.
Yes,
Okay.
thank you.
All right. Possibly.
Possibly. I sense a bill going to subcommittee. Delegate Tolles.
It's a
Thank you. Thank you, Mr. Chair. I echo the sentiments of my colleagues. It's a very expansive piece of legislation. I know we met a couple times about this. I do still have some concerns. And so I would like for you talked about the sponsor amendments. Can you tell me what those sponsor amendments that you're looking to do would be?
There are quite a few.
And they're attached to our written testimony.
Yes, they're.
They begin on page 6 of the written testimony.
So my understanding is you submitted the amendments in written testimony.
Yes.
Yes.
Page
Part of
6
their
of our
written
written testimony.
Can you
Okay.
just briefly tell me what they are? Because yeah, just to those that are listening that don't have the testimony in front of them.
House Bill, I have it. Amendment number 1 on page 4, line 9. That's the first.
If you could, sorry, pull up the microphone a little bit. Oh, sure. Thank you. Or just speak a little bit. Thank you.
The First Amendment is on page 4, line 9. Okay, do you want me to go through the amendment?
Well, just give me a cursory, review of what those amendments would be. You don't have to say the page, but.
Okay.
Because and my rationale for that is that I wanted to know if you were able to change some of the strong objections I had to this bill. So before I ask that question, I want to know what you attempted to fix first.
Yes.
Thank you.
I will start off by saying the 60 days, we are in agreement to extend it to the 120 days in the amendment for the driver's license suspension. Currently, right now, the law allows the referral or selection after 60 days. We have agreed in the amendment to extend that to 120 days, both for commercial and regular driver's licenses.
Okay, I have a bill that states that. Okay, okay.
Let's see. Oh, sure. Also, we have amended and added a new section where if an individual has an income for the current year not greater than 250% of the federal poverty guidelines, the maximum garnishment for the combined support arrearage should be 25%.
Okay, I'm going to do this because I don't want to take up too much time. So I'm just going to just ask some pointed questions. I'm going to backtrack just to be sensitive of time. And I know we have much more to do on our agenda. So I do stand, again, I thank you for taking the time to meet with me a few times on this issue. You know, I worked on this issue with a number of colleagues over the past few years. I too agree with Delegate Crutchfield regarding the winnings, for the fantasy winnings. I do agree it could be life-changing for some, and I don't think that's something that you all should take, so I would maybe look at reconsidering that. But could you explain when it talks about the $150, the administration may certify the agency, and it looks like it's existing law for the other types of winnings. Are you saying that you could take individuals who are at least in the rearages of $150, you can take, say they win $250, you would take $150 of that dollars and they would be left with $100 of their winnings?
Which
Is
section
that
are you
correct?
reading from?
Page 7, and I'm looking at sort of a bill I've been working through for the past month or so. But the administration may certify the agency on line 14. And it just says, basically, my question, do you see it? So if they take, just to reiterate my question, if they win $200 and they are in the rear just of $150, you would take the full $150?
That's correct.
Do you understand that individuals could bet $100 and win $200? So, sometimes people don't win. If you're lucky, that's awesome, but you generally don't win on your first time you bet. So these individuals who are betting might not be their first winning. They may be at a loss and then turn around and win. But you could be taking the winnings that they just basically did to break even. Is that correct?
That's correct.
Okay. That, I think, is an issue. My colleagues brought up the 1099. I had an issue with that. I would just say this with the opportunity to possibly come back with the court's indulgence for other questions. But one of the other major issues I had with the legislation was that, do you still have this in the bill where you would take individuals who the non-custodial parent is paying to the custodial parent, and the custodial parent, I think it's on page 24 or so, or toward the end, where it talks about foster care. So the non-custodial parent would still pay the custodial parent the payments for child support, even if the child was taken to foster care, recognizing the current law gives the administration, the agency, the ability to take those take the child support payments. You want to change it so that it will continue to go to the custodial parent, even if that child is not present in the home. Is that still in the legislation?
That is.
Can you explain the rationale for that? Because I'm completely struggling. If the child is in foster care, it's called child support for the child. That means the child is not getting it. The custodial parent is getting it. If the custodial parent has a child in foster care, that means they're not taking care of the child, and the money is not being used for the child. And if the child is in foster care, that could possibly mean there could be some issues with the custodial parent, perhaps drug use or not ability to take care of the child. Can you explain why you would keep that in the bill?
If I'm understanding you correctly, this is where there is a foster care case, and the case has been referred to the Child Support Administration for enforcement. Foster care payments don't go to the custodial parent. Foster care, when the child is in foster care, in care, the child support goes to the state.
Right.
Doesn't go to the custodial.
That's the current law, correct?
That's the current law, but the proposed law is to not have foster care cases referred to the administration, so we would no longer collect from the non-custodial parent on a foster care case. So there is no money to go to anyone when the child is in foster care.
Okay, because when I met with your team, they said that the custodial parent would get the money, so that's not the case?
No.
Okay.
Because we wouldn't have a case in that situation, because the child is still in care.
So can you explain what this change would do? Again, I apologize, I didn't.
That's okay. In the bill, the new law is to stop the collection of child support when a child is in foster care. There will be no collection, no child support at all.
So what happens to when the child is in foster care and the non-custodial parent is still paying? What would happen to
there would be no collections. Non-custodial parent would not be paying. The case would be closed.
Okay, so they would not, no, so they could, so nobody gets anything?
Correct.
Okay, so you may want to talk to your office because they kind of miss some of the information.
And
Okay.
then that is unless a judge says otherwise, a judge or magistrate. A judge or magistrate may order a non-custodial parent to continue to pay if it's not in the best interest of the child, where reunification is not the plan for that parent. So there is a possibility that.
Okay, but I don't want to get too much into these details, but we can talk about that more
Yes.
offline because I got some misinformation.
So we're going to
Thank
be
you.
likely going to the subcommittee.
Yeah.
For sure, going to the subcommittee with it. So just because I want to intervene here a little bit to move on if I can, because there are still several people who
Thank you
have
for the course
questions. Is that okay?
indulgence.
Okay. Thank you. Delegate Arakan.
Thank you, Mr. Chair. So I was just listening to my good friend from beautiful Prince George's questions, and the thing that stuck with me, and I know Delegate Crutchfield mentioned it as well, was the talking about the winnings that your guys are trying to add in, which I think is reasonable. And I did hear the idea that, like, you know, sometimes when people are betting money, like they have to put money down, they probably lost a lot of money. But would the department say it's a fair assessment that men who have a bunch of arrearages should not be putting hundreds of dollars down in betting in the first place? Yeah, okay, thank you.
Delegate Taylor.
Thank you, Mr. Chair. Thank you for being here, and thank you for acknowledging that we have a system that's pretty much broken. I just looked through what I thought would be all the amendments, and maybe somewhere House Bill 218 deals with the issue of licenses being taken away in error. Is there an amendment, or is there somewhere here that deals with the errors, the persistent errors of driver's license being taken when the custodial or non-custodial parent is either paying child support or has already been determined that taking away the license is not in the best interest of the child?
That is not in the bill. There's no mention of the errors regarding the driver's license suspension. The main part of the bill is to not penalize the low-income wage earners by offering the 250% of the federal poverty level to where they will not be suspended. But no, the bill does not speak to errors that may have been caused by the administration.
Sure, and I know that you've been around for a little while now, a couple of months. Are you aware of the errors?
I am aware of some of the errors, yes, that are true errors. I am aware that there may be a need for worker training on some of those errors. I cannot say that they're all systems-related errors, because they are not. They're mostly worker error, where a person may have brought in a document and that document was not processed timely. So I am aware of those errors, and that's why the administration, at least under my leadership, we have started a training program for our staff to make sure that they are up to speed on what the current law is and the policy. Actually, just last week, we just provided training statewide on the investigations when it comes to driver's license suspensions, as well as other enforcement remedies that we have to ensure that they are adhering to policy, and that is statewide and required for all staff.
Okay, thank you.
You're welcome.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Is interest applied to the arrears?
Is interest applied to arrears?
No, Maryland does not charge interest.
Are the arrears applied to personal estate?
When you say arrears apply to a person's estate?
Yes.
When a person has an estate,
Yes.
we are notified
Yes.
of the estate.
Yes.
And when they settle the estate,
Yes.
those arrears, yes, are paid
Thank you very much.
by the trustee, yes.
Thank you very much.
You're welcome.
Seeing no further questions for this panel, we thank you all very much. I suspect there will be more conversation.
Thank you.
All right, favorable with amendments. Mark Woodard, Cam Bridges, Amy Vora, Zachary Alberts, all right, and I'll start with the person on my right, your left, and we'll work across, please. 2 minutes each. Go ahead.
Good afternoon. My name is Ami Vora, and I'm the Advocacy Director for Family Law at Maryland Legal Aid, where our family law attorneys represent low-income parents in a variety of child support matters. We urge a favorable with amendments report on this bill. This bill includes some greatly needed changes to Maryland's child support laws and systems, including the multifamily adjustment and the guidance against filing cases against parents with kids in foster care. But what gives us the greatest pause is the bill's failure to rectify the broken system. The systemic flaws that continuously suspend the licenses of anyone with 60 days worth of unpaid child support arrears, regardless of whether or not they have a basis for an exemption from that suspensions process. Year after year, we testify about the parents that have been ensnared in this system. Parents who have had custody of their kids, parents who are making consistent payments toward their arrears, parents who are disabled and can't work, parents who can work and need their car for their jobs. None of those people should be referred over and over again for license suspension, and yet every day we help those parents with getting their licenses back. We're good at what we do, but by the time the parents come to us for help, the damage is done. They may have lost their job, they may have picked up a criminal citation for driving without a license, or missed an important moment in their child's life. DHS's bill does not create an exemption for license suspension for individuals earning below 250% of the federal poverty line. It just expands their existing investigation system. DHS currently sends notices to parents at risk of license suspension, letting them know that they have the right to request an investigation. And all that this bill does is say that being below a certain level of income is a basis to request an investigation. This minor change is not going to fix the problem. Our clients tell us they don't get the notices from DHS, and that when they go to DHS to request an investigation, these investigations are not performed. We just would ask DHS to strike the driver's license provision or to revamp it so that driver's license suspensions can be evaluated on a case-by-case basis. So for those reasons, we recommend a favorable with amendments report.
Good afternoon, Mr. Chairman, members of the committee. Mark Woodard for Job Opportunities Task Force, favorable with amendments. I specifically want to mention one particular provision of the amended version of the bill that we support, which is the limitation on wage garnishment to 25%. We think that is commendable and needs to be part of any final legislation on this subject. As was just stated, there is no exemption language for low-income obligors. On page 9 of the bill, it talks about the 250% language, but only as a factor for investigation. That's not working now. More than 20,000 people lost their licenses due to being in arrears on child support. So we offer an amendment. The amendment is basically Delegate Toll's bill to exempt 250% obligors at that income level from having their driver's license suspended. Our second requested amendment is to have a memorandum of understanding between the Comptroller's Office and DHS to provide the taxpayer information to determine who is eligible for that exemption, which means you don't need 29 additional caseworkers at a cost of $2 million. For those reasons, we support the bill with these amendments. Thank you very much for your time.
Good afternoon, Cam Bridges, Policy Advocate for Job Opportunities Task Force. I'm not going to relitigate what my colleague and Omni have already said, but I do just want to point out that some studies show that 42% of individuals who had their license suspended lost jobs as a result of that suspension. 45% of those who lost jobs could not find another job, and 88% of those who were able to find another job reported a decrease in income. Our ultimate goal is to ensure that non-custodial parents are able to maintain employment so that they can make their child support payments, which serves the best interest of the child, the custodial parent, the non-custodial parent, and the state overall.
Good afternoon. Zach Alberts with the Center for Urban Families. I really want to spend my 2 minutes talking about why the wage garnishment caps at 25% for low-income obligors is so important. Every debt in this country is capped at 25% except for child support and alimony. And the reasons why are that obviously children need more support, right? That was the thought when the CCPA was passed in 1968. The challenge with low-income obligors is that the courts practice something called income imputation, whereas if someone is not working when their child support order is taken into account by the courts, they will assign an order based on fictitious income as if you made minimum wage. And so what happens is you never had this job, and immediately your child support arrears start to build and build. There's lots of barriers to low-income people working full-time jobs, right? 2/3 of child support obligors in Maryland are low income. And so the second they are able to get a job, right, surmount those barriers that we care about helping them get by, they have 65% of their wages garnished, between 50% and 65%. So if you get a $15 an hour job because you're trying to do the right thing and support your children, you're left with $4 an hour after a 65% garnishment rate. That's $8,000 a year to feed, clothe, and house yourself. And what ends up inevitably happening is these dads job hop, right? They drop out into the underground economy or even the black market economy because it's the only way they can feed themselves. Allowing them to pay a smaller amount more frequently will ultimately end up in more money being sent to the custodial parents and will help meet Governor Moore's vision of getting children out of child poverty. It's a really, really, really important step to helping the most vulnerable folks in Maryland, and I would ask for a favorable with amendments recommendation. Thank you.
Any questions? Seeing none, thank you all very much. Those were the favorable with amendments. Now going to those people who are unfavorable. Oh, no, I'm sorry. No, that's right. Now going to people who are unfavorable on the legislation. Starting 2 people virtually, Jonathan Williams and Melody Mitchell. Neither one. Okay. Dewan Burton and Grayson Wiggins. Whoever would like to go first.
I'll go. Good afternoon, Chair and members of the committee. My name is Dewan Burton. I am the Deputy Director for Out for Justice, a nonprofit organization focused on advocacy and education for individuals directly impacted by the legal system. I'm here today to strongly oppose House Bill 218 because it places undue hardship on low-income obligors while failing to provide the automatic protections they desperately need. First, the bill does not provide automatic exclusion from driver's license suspension for individuals earning under $38,000 annually. Instead, it shifts the burden onto obligors, forcing them to prove their income after their license has already been suspended, continuing a punitive and inefficient process. A person who is unable to pay child support is often unable to work without a driver's license, making it even harder for them to meet their obligations. The bill should include an automatic safeguard rather than forcing individuals into an endless bureaucratic loop. Second, the bill extends the contempt window from 3 to 7 years, significantly increasing the risk of incarceration for individuals struggling to pay. Lengthening this period disproportionately punishes those who are already financially vulnerable, making it more likely that parents will end up behind bars instead of supporting their children. Incarceration does not generate child support payments. It only creates additional barriers to employment and stability. Finally, the bill imposes harsh wage garnishments on independent contractors by requiring their employers to report them to DHS for garnishment of up to 65% of their income. Many of our members who struggle to secure meaningful employment due to a number of barriers to include legal involvement resort to independent contracting and attempts at starting small businesses. These individuals are already struggling financially and fluctuating income. Penalizing their employers for failing to report them only discourages work opportunities and pushes these individuals further into financial distress. This bill does not provide real solution. It reinforces cycles of poverty and punishment. I urge the committee to reject this bill.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. We have two specific issues with the bill. The first is on page 4. The bill establishes a new definition of independent contractor that appears to directly conflict with the current test under the labor and employment article. And based on the amendments that I just received, I think the amended version of the bill would effectively require an employer to determine the income thresholds for independent contractors and then determine whether wages should be garnished. And it almost seems to be outsourcing the department's work to employers, which is going to have an impact, certainly. And then the way that the bill is drafted, and the second issue is on page 18, the reporting requirements to Delegate Crutchfield and Delegate Cardin's questions would be extensive. So independent contractors, by their nature, they come on to a project, do a job, and they go, and they'll often sometimes come back to the same employer multiple times in a year for a project. And so we would have to be reporting this every time that person comes back. And additionally, because of the way the bill defines employer, this seems to require joint reporting where a contractor would be reporting this information for 1099s on their work for a subcontractor. And so given the extensive amount of reporting that the bill would require and the amendments that seem to require the employer to make determinations that have never really been contemplated in the independent contractor dynamic, we'd like to just see those provisions stripped out of the bill. We don't have problems with the other 39 pages of the bill, though. Thank you, Mr. Chair.
For both of you for testifying. This is for Mr. Wiggins. I just want to confirm, so you're not opposed to the idea of making people who aren't paying child support, figuring out a way to make them pay. You just think that that there may be some problems with the functionality of this with employers and independent contractors.
Correct. Yeah, we would support people paying child support, obviously.
Okay.
I think, yeah, it's the reporting requirements, and I got to think there's got to be an internal department-to-department way to maybe share information that could achieve this without the burdens on the business.
I just want to ask you, because I was very inartful in what I asked the administration. If somebody is like an independent contractor and they come in, they do some work, they get a 1099, and then 2 months later they come in and do some more work and get a 1099, and then 2 months later they come in and do some more work for a couple of days and get a 1099. The way that I read the bill, is this correct? That they would have to then report that within 20 days each time this independent contractor comes in?
That's accurate. You're talking hundreds of thousands of data points being sent to the department. And
that's what I was trying to say, and I did not do it very well.
And even more so because of the way it defines employer, which is any person who pays earnings to an employee, and in the way that it establishes work commencing on a job site, you could have the general contractor also reporting that too. You have duplicate reporting requirements.
But we can agree that we all need to make sure that we're collecting child support. We just got to figure out how to do it right.
Absolutely, Dr. Cardin.
All right, thank you. And that appears to conclude the questions for those in opposition for House Bill 218. Thank you very much. That concludes the testimony on House Bill 218. We're now going, are we ready for Delegate Bartlett, or do we want to go to the next one and let them get ready? We'll do, are we ready with Delegate Tolles? Are you ready with your bill? Yes. 681. House Bill 681. There would be quite a few people signed up for testifying on a bill that we may have heard several times before. Hopefully they will be succinct. Delegate Tolles, Jonathan Williams, Trina Selden, Mauni Selden, April Hamilton. And if there's, all right, we'll start with this panel and then we'll go from there. Delegate Tolles.
Sorry, Mr. Chair. Okay. Good evening, almost. Mr. Chair, Madam Vice Chair, she's listening, and colleagues. We have heard this bill before last year, and so happy to submit testimony again for legislation concerning the suspension of driver licenses for child support arrearages. The consensus support reached among sponsors and advocates highlights a collaborative effort behind the bill. Such alignment reflects a comprehensive approach to addressing the complexities of child support enforcement and licensing issues. And I want to say that last year, the administration, the DHS was in support. I still believe they are in support because some of this bill is still in the current bill, the bill that they had before us. The difference is this is automatic. So this is not, you have to come back and figure out what your income would be. This is automatic, just as it was before. This year, the Legislative Black Caucus in Maryland has made this a priority bill because the issues of suspending driver license historically impact minorities more than any other group of individuals. Often the obligor is unaware that their license is suspended. Under certain circumstances, employers require their employees to have a valid license. Therefore, having a suspended license could have irreparable harm on the obligors. The Census Bureau reported that nearly 40% of Marylanders commute outside their county for employment, emphasizing the widespread mobility in the state's workforce. Notably, this trend is more pronounced in lower income communities of color. The existing provision of Maryland Code Family Law 10119 mandating license suspensions after 60 days of non-employment of child support raises concerns about the potentially harsh consequences for obligors. The imposition of a $500 fine and the possibility of arrest further exacerbate the punitive nature of this policy. It is crucial to acknowledge that child support debt can disproportionately impact individuals irrespective of their financial status. HB 681 is a crucial step in ensuring fairness, particularly for those with an income at a below 250% of the federal poverty level, or $37,650 annually, and it is automatic. The exemption provision recognizes the financial challenges of obligors, and it changes it from 60 days to 120 days, providing a reasonable time frame for compliance. It is essential to strike balance between enforcing child support obligations and considering economic circumstances. And in closing, if enacted, HB 681 will contribute to a more equitable approach in handling child support. Colleagues, I kindly ask for a favorable report as you did last year. And again, this bill passed out of committee last year. Thank you, Mr. Chair.
Hi, excuse me. Good afternoon, Chair and Committee. My name is Trina Selden, and I'm the founder and executive director of Out for Justice. Usually I leave it to my team to testify on legislation impacting our members, but I'm here today as a mother and a grandmother to talk about the impact of the child support system has had on my family. My son and I have been threatened repeatedly by the mother of his child, who has weaponized the child support system to increase his monthly payments, keep him away from his daughter, and to take away his driver's license, which he needs to work. The Child Support Administration has been less than helpful in helping our family increase his visitation rights and protect his ability to work. This bill will at least allow him to have a fair hearing regarding his driver's license so that he may continue to work and support my granddaughter. Relationships can be messy and complicated. Most of us have experienced this at some point in our lives. However, losing one's driver's license, having one's wages garnished, and increased threats of incarcerations are tools that child support uses that are not effective methods of dealing with breakups or ensuring that the children are provided for. And I urge a favorable report. Thank you.
How y'all doing today? My name is Kimani Selden, and I reside in District 42 in Baltimore County and support Senate Bill 15, House Bill 681. I'm a father of 2 beautiful little girls that I love and care for. My eldest daughter mother placed me on child support when our baby was only a few months old. At the time, I was shocked at the situation, given that I repeatedly offered to provide for our daughter and assured her mother that all she had to do was ask for what she needed. It became clear that she was unwilling to compromise unless I put cash directly into her hands or that I was put on child support. At my first court hearing, I arbitrarily agreed to pay roughly $350 a month in child support on the assumption that I would be able to further negotiate in front of the judge. It quickly became apparent that no further discussion was allowed on the matter. No one was willing to hear anything I had to say. Since that initial court decision, my monthly child support allocations have increased to $511 a month without allowing me to speak on the matter. Specifically, the court has not considered that I am a custodial parent for my youngest daughter and the breadwinner of my household. Since I was first placed on child support, I have looked far and wide for well-paying jobs to support my children in my current household. However, because my license has been suspended, I have been unable to make meaningful changes in my living situation. The only well-paying job I could find working for Amazon was outside of my neighborhood. However, with the suspended license, I could not work for this job and took lower-paying local jobs with insufficient hours. Further, I desire to have a relationship with my eldest daughter, whom, despite all the child support I pay, I am not allowed to see. I was told to go to court and obtain visitation rights, but how? I have no car, a job, or a family to support without the added Uber fees that it would require. Heading to court is a hefty undertaking that without a license, I frankly cannot do at this time. While I can acknowledge that some fathers may be unwilling to provide for and support their children, there should be some compassion and appropriate avenues for the fathers who care to be able to speak for themselves and find middle ground with child support. This situation and stagnation caused by my lack of driving license is taking a hefty toll on my family and me as well. Senate Bill 15, House Bill 681 tremendously aids lower-income constituents like myself by allowing exemption, license and suspensions for those making less than $38,000 annually. This move would prevent the years of difficulties I experienced. For this reason, I urge a favorable report on Senate Bill 15, House Bill 681. Thank you.
Hello, good evening. My name is Corinne Berry. I reside in District 25, Prince George's County. I support House Bill 681, which exempts lower-income persons from having their license suspended. And I want to thank my delegate, Karen Tolles, for sponsoring this bill. I have an 8-year-old son who I currently pay $711 each month for in child support. His father and I tried to work things out, but his abusive character and alcoholism became too much for me to bear. While I was struggling with breast cancer, he filed paperwork to take full custody of my son, which led to extensive court battles and mountains of debt. After I won joint custody, he decided to file for child support and kept my son away from me for 9 months. I have been taking care of my son since the beginning and continue to do so while I'm dealing with court and injury and managing cancer treatments, which I have now defeated. I am currently $17,033 in arrears while fighting to maintain custody for my son. My taxes were intercepted, my wages nearly garnished, and my license was suspended, crippling my ability to work, pick up my son,
comply with court orders, handle daily activities, or live my life. This bill will exempt me from having my license suspended while I actively try to secure steady employment without a driver's license. I can't comply while the court orders or earn an income. Please pass this bill. Thank you so much for your time.
Questions for the panel? Seeing none, thank you all very much for coming and testifying today. Okay. Franz Schneiderman. Corinne Berry should be virtual. If she's here, that's fine. She just testified. All right, I have her down twice here. I apologize. Mark Woodard, Cam Bridges, Amy Vora, Christopher Dews, Dwan Burton, and then Eric Smith is virtual. All right, we'll take as many as we can. Whoever would like to begin, please.
Christopher Dews here representing Out for Justice. As was stated, this is the 5th year that we have supported this bill, and it's a Black Caucus priority. We want to thank Delegate Tolles for carrying the torch on this. As the current law has already been discussed, the point is that before your license is suspended, you're supposed to receive a notification to request an investigation if the suspension would affect, if the amount that you owe is inaccurate, if you are disabled, if you need your license for a court order, or if it would impact your access to employment. Unfortunately, under this practice, as Ms. Vora said before, this investigation never happens. Unfortunately, we have an endless amount of members who contact the department, not necessarily to blame them, it's just the way that things are going right now. That when they try to request the investigation, it doesn't happen. They are simply just told to pay and pay immediately. MVA is supposed to offer work-restricted licenses, but our understanding is that DHS has documented that they do not participate in that practice. So if you miss 2 payments, your license gets suspended, as was mentioned before, restricting access to work, healthcare, groceries, and other things. Unfortunately, there is no evidence that restricting the ability to drive increases compliance for the poor. Just want to remind the committee, for those of you who were not here in 2020, Maryland eliminated license suspensions for unpaid traffic fines and fees without any type of income requirement or threshold, because the data showed then, as the lack of data shows now, that taking licenses away from lower income persons does not magically make the resources appear. I just believe that we need to be very careful about restricting access to drive for lower income parents. It frustrates both the parents, as the suspended parent cannot legally transport the child, comply with visitation schedules, as was discussed in an earlier bill, or work. This bill was a recommendation from the former federal chair of child support and has already passed a version of this in California. The California model says if you make less than 70% of the area's median income, they do not touch your driver's license. So this piece of legislation is a little more modest than that. It just simply says you make less than $37,000 or $37,650, they don't touch your license. We ask that you consider this bill seriously and urge a favorable report. Thank you.
I can go. Good evening again. My name is Ami Vora. I'm the Advocacy Director for Family Law at Maryland Legal Aid, and we urge a favorable report on HB 681, which prohibits DHS from referring parents earning below 250% of the poverty line for driver's license suspension. If implemented correctly, this bill would help our low-income clients tremendously. As Mr. Dews just stated, license suspension is not only an ineffective child support enforcement tool for low-income folks, it's also counterproductive. When low-income parents lose their licenses, they can't work. When they can't work, they can't pay their child support. The treacherous domino effect benefits no one, least of all children, many of whom are directly harmed when their parents' licenses are suspended. The license suspension may mean kids losing their ride to school, parents not being able to take them to their doctor's appointments, and kids not having visitation with their parents. We believe that this exemption will protect parents and their children from further destabilization, and that is a laudable goal. But we just want to point out that impoverished parents are actually not the only people who should be exempted from referral for license suspension. Individuals who can't work due to their disabilities, parents who have now acquired custody of their kids, and any parent whose employment depends on driving also should not be referred to MVA for driver's license suspension, yet that's exactly what DHS's automated referral system does repeatedly. Every 60 days, if you have arrears, whenever you accumulate 60 days worth of arrears, you are automatically sent over to MVA for a license suspension. We suggest that this bill be paired with HB 110, which creates a judicial process for individually assessing each case and each family's circumstances to determine whether license suspension is appropriate. But regardless of that, this is a terrific bill, and it has MLA's full support. Thank you.
Good afternoon. Mark Woodard, Job Opportunities Task Force, in favor of House Bill 681, and we thank Delegate Tolles for bringing this bill forward again this year. As has been said, this committee passed the bill last year, and it was a good thing to do then. It's an even better thing to do now. This bill needs to get across the finish line. We do have a punitive and counterproductive system in place. Suspending a driver's license from a low-income obligor results in, well, now they can't drive their car. Now they can't get to work. Now they can't earn income. Now they can't pay child support. It is totally counterproductive. This needs to change, and this bill is here, as is the one, House Bill 110 is here because the system is broken. Now is the time to fix this broken system. Please pass House Bill 681, and we urge a favorable report. Thank you very much.
Thank you all for letting me speak and be heard today. I'm April Hamilton, a single mother of a preteen girl and a toddler boy. I have a unique and impartial objective on child support matters, as I owe support for one and receive support for another. I am also a survivor of domestic violence from the father of my daughter. About 10 years ago, after an episode of physical violence, he threatened he would use my lack of familial support and my financial circumstances to take my child from me and use child support to ruin me and oppress my life. This is now the reality that I wake up to every day, but at least I get to wake up. I have had my license, which at one point I was forbidden to get, and eventually walked 8 miles a day to get. I have had that suspended several times and been held in contempt and even arrested due to not paying my support order or being able to transport myself to Hagerstown, where the case is out of. The arrest record alone excludes me from a spectrum of equitable careers in many fields. Had there been a court hearing prior to the suspension, I would have been afforded an opportunity to explain that he had dropped the order, assaulted me again, and maliciously used the assault because I pressed charges to file child support on me again. Between getting the protective order and a job in Alaska, I never received notice that the order was reinstated. And now I have been receiving TCA, which pauses my financial obligation for my older child. However, after much coordination with the DHS and the DMV and multiple phone calls and hours worth of time, weeks before your license is reinstated, my license has been suspended again repetitively for the past year. No less than 5 court dates, 3 counties, and 80 miles away, placed with the burden of getting there with no license. And for the result of each hearing to be a further delay or postponement seems like a waste of time on the state and my own behalf. One hearing in the very beginning, before the suspension took place, could have eliminated the need for all subsequent court dates. This action could reduce the amount of child support related cases on the dockets. I haven't even mentioned how not having proper transportation has impacted my daughter, unable to keep our visitation agreement, and damaged our relationship without repair. Please pass a favorable report on this bill.
Good afternoon. My name is DeJuan Burton. I am the Deputy Director for Out for Justice, and I urge a favorable report for House Bill 681. as a nonprofit whose members base is primarily consists of individuals who have been impacted by the criminal legal system, these individuals often face significant barriers to securing meaningful and adequate employment due to their criminal records. One of the critical factors that can mitigate these employment challenges is access to affordable and legal transportation. For many, a valid driver's license is essential for commuting to work, attending job interviews, and fulfilling family responsibilities. Suspending driver's licenses for low-income obligors who are unable to meet child support payments exacerbates their financial instability. Without a license, these individuals may struggle to maintain employment or secure new job opportunities, further hindering their ability to fulfill child support obligations. This creates a detrimental cycle where the lack of driver's license impedes income generation, leading to increased arrearages and potential legal consequences. By implementing this bill, Maryland would take a compassionate and pragmatic approach to child support enforcement, excluding obligors earning up to $250 of the federal poverty level from driver's license suspension, and acknowledges the economic realities faced by many and prevents further marginalization. This policy change will not only support the financial stability of low-income parents, but also promote consistent child support payments, as individuals are more likely to meet their obligations when they have the means to do so. Moreover, this legislation aligns with broader efforts to humanize and reform systems that disproportionately impact marginalized communities. It deters the further criminalization. Sorry, I think I said that. In conclusion, I'll say Out for Justice strongly urges the committee to issue a favorable report on this bill, as it represents a meaningful step towards equitable child support enforcement and the removal of unnecessary barriers that prevent individuals from achieving economic self-sufficiency and supporting their children. Thank you for considering this perspective.
Eric Smith, please, for 2 minutes, and then Mr. Schneiderman, you'll need to trade out. We'll have you testify for 2. Eric Smith, please, 2 minutes. You're on mute. You're still on mute. Now you're not.
Good afternoon, members. My name is Eric Smith. I'm the Executive Director for Winning Strategies, Fatherhood, the Courts, and Custody. And I represent the fathers who we support. We're writing to express our strong support for the legislative matter aimed at reforming Maryland child support enforcement. Specifically, we urge the passage of House Bill 681. This bill is critical in ensuring that child support policies are fair, effective, and do not impose undue hardships on fathers who actively are working towards financial stability and parental responsibility. A key issue that has been addressed that must be addressed is the accuracy of child support arrearages assigned to fathers. It is essential that enforcement agencies conduct thorough investigations to determine the actual amounts owed, ensuring that fathers are not burdened with erroneously or inflated arrearages. Additionally, we advocate for legislative review of the current policy that limits mothers to receiving support for this. Also, we ask that as fathers of the non-custodial parents be given, I'll say, an extra advantage to trying to gain their driver's licensing back. Given the urgency of these matters, we request that you work towards implementing these changes within the next few months. A timely action is crucial in preventing further financial and personal hardships on a father and children alike. Reforming these policies will not only support fathers in meeting their obligations, but also ensure that children receive financial support that they need without unnecessary bureaucratic obstacles. We appreciate your attention in these critical issues, and we look forward to your leadership in advancing these reforms. We would welcome the opportunity to discuss these concerns further and to collaborate on such solutions to benefit Maryland fathers. Thank you.
Mr. Schneiderman, do you want to testify on the bill, or would you like?
I can just say me too.
Me too. Sounds great. All right, go ahead.
Every single one of my talking points have been made 2 or 3 times already, so me too.
Did everyone pay attention to that? That was very interesting. All right, Delegate Crutchfield.
Thank you very much, Mr. Chair. So, Mr. Dews, I know you know this bill very well. Yes. Can you tell me, is this the same bill we've seen for the last couple of years, or are there changes to this bill?
There is one specific change, and that is on specifically page 5, line 32, you will find, and I wrote this down specifically, language that's asking the courts to send a copy of the guidelines to the Child Support Administration when the order is established. We put that in there for the purposes of trying to reduce, I believe Mark talked about this as well, the fiscal note, so that there wouldn't be a need for 29 new caseworkers. But yes, this would be, outside of that, this would be the exact same bill that is passed out of the committee from last year from Delegate Tolles.
Thank you very much.
Thank you.
Other questions? Seeing none, that concludes the testimony on this piece of legislation.
Yeah, we're good. Let's move. Get away good.
Vice Chair is not here. However, she is somebody who's taking her place. Her House Bill 1050. Vice Chair is ill, so we'll ask you to present the bill, and then we'll call out the first panel. Because we're not going to ask, if you want to ask questions, you can, but we'll do better sending them to the next panel. Please present the bill on behalf of Delegate Vice Chair.
I think we have a sponsor panel. Do I say that now, or they come later?
You can either have the sponsor panel up with you now, or we can have you give your remarks for the Vice Chair, and then we'll have the sponsor panel come up. It's up to you. Would you like the first panel?
Yes, please.
Aaron Kirk, Lydia Watts, Donna Burden, Alex McCord. Whoever would like to begin, please. Again, we need to get at least one more chair and who's there at the end.
Hello, Chair Clippinger and members of the wonderful Judiciary Committee. My name is Chloe Ashby. I'm the legislative aide for Delegate Sandy Bartlett, representing Anne Arundel County. Today, she has asked me to present HB 1050. She is out sick, but she is listening. HB 10... HB 1050 is not a simple bill, but if enacted, it will save lives. This bill alters the numerous provisions that govern the surrender of firearms under Domestic Violence Protective Order. The bill will expand the protective order requirement to surrender firearms to include interim and temporary protective orders. HB 1050 requires respondents to surrender to law enforcement authorities any firearm in the respondent's possession and refrain from the purchase or possession of any firearm during the duration of an interim, temporary, or final protective order. It will also establish the task force to study the use of firearms in domestic violence situations staffed by the Center for Firearm Violence Prevention and Intervention. Many of you have likely received numerous emails to oppose this bill. The writers of those emails felt the burden on the petitioner was too great as to what they had to present. In response to these concerns, there are amendments that have been sent to your email inboxes that address these issues, and our esteemed panel will explain these amendments in detail. HB 1050 has also been amended to conform with the Senate bill that was heard yesterday, SB 943. For your ease, you may wish to view that bill during this hearing. To conform with the Senate bill, we sent amendments to your inboxes as well. The panelists will go into further details on those amendments as well. On behalf of the delegate, I request a favorable report from this committee. Thank you, and we will be happy to answer your questions.
Okay, let's start from the right. From my right, your left. Sir, you go ahead. Oh.
Sure. Members of the committee, thank you so much for the opportunity to testify today. My name is Alex McCourt. I'm an assistant professor and core faculty in the Johns Hopkins Center for Gun Violence Solutions. I'll primarily be talking about our research findings relevant to this bill today. Because this bill would strengthen Maryland's domestic violence protections, the Johns Hopkins Center for Gun Violence Solutions supports HB 1050. When a violent intimate partner has access to a gun, the risk of death for the victim increases significantly. Researchers affiliated with our center have found that intimate partner homicide was 5 times more likely when the abuser had access to a gun. About 50% of intimate partner homicides are committed with a gun. Guns are also often used in non-fatal domestic violence. This violence can include brandishing a firearm, striking the victim with a gun, or threatening to shoot the victim or someone else. Individuals who engage in domestic violence are also at an elevated risk of engaging in future violence, including mass shootings. Protective orders are a key mechanism for reducing the risk of intimate partner violence, but state laws vary with respect to how these orders affect access to firearms by perpetrators. My colleagues and I conducted a study published in the American Journal of Epidemiology in which we identified these policy variations and determined which affected intimate partner homicide rates. We found that when states enacted laws that required firearm removal for ex parte restraining orders, like those considered here, intimate partner homicide decreased 13%. Additionally, we found that when states enacted laws that explicitly required relinquishment of firearms after protective order, those states experienced a 12% reduction in intimate partner homicide. This bill would require firearm removal for these ex parte orders of protection and would strengthen Maryland's firearm relinquishment provisions, bringing our state laws in line with our research findings. Accordingly, the Johns Hopkins Center for Gun Violence Solutions respectfully requests a favorable committee report on HB 1050. Thanks so much.
Good afternoon. I'm Karen Herron. I'm the Executive Director of Marylanders to Prevent Gun Violence, and I'm here today to urge you to support HB 1050 because our current system for removing firearms from domestic abusers is failing survivors, and it's putting lives at risk. Maryland law prohibits certain domestic abusers from possessing firearms, but the system that we rely on to ensure that those firearms are actually relinquished is broken. Right now, judges and law enforcement often lack the information and authority they need to act swiftly. Dangerous individuals are left in possession of firearms at the most volatile moments. With Vice Chair Bartlett being under the weather, she's asked me to cover some of the amendments, so I'm sort of skipping through and going to do that now. So as we've already heard, the Senate version is a little bit more, a little easier to look at. Some of the amendments that changed the House version were brought from that, if that makes any sense at all. So basically, this is what we're looking at. The title was changed. It's now the Family and Law Enforcement Protection Act. We're making sure that the language addresses the prohibitions to both possess and purchase firearms if a person is subject to the order. We are including the surrender of respondents' handgun qualification license when firearms are also ordered surrendered. There's some language on page 11, line 4, where you're changing the language from may to shall, increasing the task force to include more domestic violence victim representation, clarifying some language on page 12, lines 22 and 23. I will skip what that is. I can answer questions, but I'm running out of time. And then in addition, there's a bunch of modifications based on feedback from emails from domestic violence groups about safety and security and privacy of the individual. So a lot of those questions that have been coming through have been streamlined. Happy to answer more questions later.
Good afternoon, Chairman and members of the committee. My name is Erin Earp. I'm a senior policy attorney at Giffords Law Center to Prevent Gun Violence, and I'm a resident of Calvert County. Thank you for the opportunity to testify today in support of HB 1050. This bill will ensure not only that individuals with domestic violence protective orders against them are prohibited from possessing firearms, but that these people actually relinquish their firearms while such orders are in effect. Currently, Maryland law only permits judges to require a respondent to relinquish firearms while they're under a temporary domestic protective order if the respondent used or threatened to use a firearm or threatened to or did in fact cause serious bodily harm to the petitioner, but in no case requires the judge to order relinquishment. Temporary orders may be extended for up to 6 months before a final protective order is issued, leaving an open period of time where the respondent is permitted to purchase and possess firearms despite posing a risk to the petitioner. This bill would require relinquishment of and prohibition from possession and purchase of firearms for the duration of all temporary DV protective orders. This is already the standard for all final DV protective orders. To grant the temporary protective order petition, the judge must find that the respondent has abused the petitioner or other person eligible for relief. An abusive partner's access to a firearm is a serious threat to victims of domestic violence, making it 5 times more likely they will be killed. In 2023, guns were used to commit 75% of intimate partner homicides in Maryland. It's critical that domestic violence protective order respondents are prohibited from possessing firearms once a temporary protective order is imposed. It's also not enough to simply prohibit them from possessing or purchasing firearms, particularly when dealing with someone who has been abusing an intimate partner. It's imperative to establish a process to ensure that they surrender firearms in their possession at the time the protective order is imposed, and for law enforcement to act if they do not comply. I urge a favorable report. Thank you.
Good afternoon, Chairman and members of the Judiciary Committee. My name is Lydia Watts. I am the Executive Director of the Rebuild, Overcome, and Rise, or ROAR Center at the University of Maryland, Baltimore. ROAR provides direct legal as well as other supportive services to victims of crime and violence in Baltimore City, including homicide, non-fatal shootings, intimate partner violence, sexual violence, assaults, and others. I write as an attorney with over 29 years of experience representing survivors of domestic violence in the 3 jurisdictions in which I am barred, which is Maryland, D.C., and Massachusetts. The vast majority of my clients over that 29 years have been low income, supporting children, living in metropolitan areas, and I was providing those services free of charge. Many of those, and I've, over that 29 years, have represented literally thousands of survivors and or through my staff attorneys at various places where I've been the director. Many of those survivors have been threatened with death if they told anybody about the violence or left the person that was causing them that harm. Some of them have been threatened at gunpoint, many with brandishing of firearms or very credible threats of firearm violence. I just want to share very briefly one of the clients I've represented who was held at gunpoint by her husband after he had been ordered out of the home pursuant to a temporary order. He had been ordered to relinquish that firearm, did not do so. There was no mechanism in place to ensure that he did so. He broke down their front door. She had barricaded herself in the bedroom. He broke down that bedroom door and dragged her out in front of their 3 children. The only reason she wasn't killed was because the firearm misfired. I urge a favorable report for HB 1050 with sponsor amendments.
Thank you. My name is Donna Burdick. I'm also an attorney. I am a lifelong Maryland resident, and I'm an attorney in private practice, and as such, I have represented both petitioners and respondents in peace and protective orders. However, I'm not here today as an attorney, I'm here as a parent. I've had a child taken from me because of domestic gun violence. My daughter, Marlene, was shot and killed by her boyfriend on April 3rd, 2020 in Virginia. She had been living in an abusive relationship. I speak because she can't speak, and I also speak because I don't want other families to suffer as we have. I live every day your greatest fear and your greatest nightmare. There were 2 factors that led to what happened. One is that he had a gun, and we didn't know that he had a gun. He was able to legally buy a gun in Virginia at the time in a private gun purchase. He could not have passed a background check because he had a history of convictions for assault and domestic violence and numerous protective orders. The protective orders had included his family. The murderer had been arrested in May of 2019 for physical assault upon my daughter, and there was a short protective order in place at that time pursuant to Virginia law, but he did not give up his gun. For assault and domestic violence and numerous protective orders. The protective orders had included his. Okay.
Kelly Sampson, you need to make sure that you turn off your audio to your computer while you're waiting. We'll try and flag you down when we're ready to go. Okay. Please continue.
Thank you. I do want to note that I am a survivor member of Every Town for Gun Safety. Second factor is that he was in crisis. It was the beginning of COVID. He had been suspended from work because of abusiveness. There were drug and alcohol problems, some extreme mental health problems, financial desperation, and he had been a victim of gun violence himself, and he was a domestic abuser. There have been some statistics already cited. I do want to note that there's an average of 76 women shot and killed by intimate partners each month in the United States. In at least 46% of mass shootings, the perpetrator shot a current or former intimate partner or family member prior to that. And the need for protective orders are typically during a crisis.
All right. We will take questions, I believe, for this panel first, and then we'll move on. Delegate Kaufman.
Yes. I have a question for anybody but Chloe, because I don't want to put her on the spot. My question is, we often hear from friends that come down frequently and testify against gun safety bills that they violate the Second Amendment, but isn't this a piece of legislation protected by the recent, I'm going to butcher the name of it, but the Rahimi case, where the court said that domestic abusers could be forced to surrender their guns and it wouldn't be an infringement on the Second Amendment? What I guess I'm asking is, does this legislation, is it supported by what Chief Justice Roberts wrote for the court in Rahimi, if you know what case I'm talking about?
Yes, and yes, this bill is supported by what the Supreme Court held in Rahimi, which is that where it's shown that someone is a risk to the physical harm of someone else, that person can be disarmed. I'd also point out that the standard here, this is a standard that's already in effect in Maryland for final protective orders. So what we're doing is just applying that to temporary and interim protective orders, but it is already a standard that's used here in Maryland.
Okay, and just to confirm, to make sure I understand, that the Chief Justice did say that in issue for gentlemen such as Mr. Rahimi, it wasn't an infringement on the Second Amendment, right? Is that correct?
That's correct.
And also, I just want to say to the woman in the yellow shirt, I'm very, very sorry for your loss, and thank you for your bravery in sharing your story.
Thank you.
I have some questions. It strikes me that it very clearly expands the amount of information. It's the whole point of the bill, and a protective order application. I guess my question is, it goes to, in some cases, having the person seeking the protective order trying to determine whether the person, the respondent, they're asking for a lot of information that the person applying for the protective order may have absolutely no idea. And I also would ask, I guess going the opposite direction, does it lend itself to someone then answering based on a lack of personal knowledge, to be just completely blunt, in a lot of different areas here that could, in fact, when a judge reads this, impact the judge's decision-making process one way or the other. Ms. Herron?
So I think a lot of that has been taken into account with the recent amendments. So many of those more sort of speculative questions, if you will, or the ones that were, does the petitioner actually know this? Quite a few of those questions have actually been removed from the language, leaving in place enough so that hopefully the court and law enforcement, if they have those answers, and the language does say, petitioner, we've added the if known in several places to make sure that, they're not supposed to be making stuff up. This is information we need if you happen to know it. But that if the court and law enforcement has that information, then they've got the tools in their pocket if and when that respondent does not actually surrender firearms, for them to adequately take next steps.
So if you look, I had it, so there's like almost entire pages of questions that have been left out of the,
Okay.
yeah. Sure.
I mean, I don't have a copy of the amendments with me here, so I'll.
And it's a little complicated because the Senate version and the House version didn't get filed exactly the same way. So if you start with the Senate version, the House version, then the new amendments that you have in your inbox will become clearer.
All right.
Hopefully.
Go ahead.
If I may add, there is definitely a balancing act here on allowing petitioners to provide information without overburdening them, which is why the language has been changed in the amendments, if known, and many of them more sort of very detailed, like around bomb-making materials and things of that nature. I will say, though, that the questions are really based on research that indicates where there's a highest risk of somebody using a firearm, not only against the petitioner, but potentially against law enforcement or others. So it's in part a risk assessment for the judge to also get that information if known to the petitioner. So we have, through the amendments, tried to minimize the burden so that petitioners, particularly largely unrepresented folks, are not overwhelmed by the volume of questions, but are that there's a mechanism that they can provide that detail if known. I will also say, having represented many survivors in Baltimore City, many of them say, you know, the respondent, my boyfriend, my husband, whatever, possesses guns. And what currently happens is the judge says, do you have a gun? And the respondent says, no, Your Honor, and that's the end of the inquiry. So where, of course, many of those guns are not registered. So in instances like that, and you know, with this legislation, we would also be launching a pilot site so that we can be working with presumably the sheriff's office in a particular jurisdiction around how the sheriff, for example, in Montgomery County, currently the sheriff there does engage with the petitioner verbally to get much of this information, because it's also about law enforcement safety, right? If this respondent has an arsenal of firearms, the sheriff or whoever is going to retrieve that gun, if that's necessary, if the respondent hasn't willingly turned it over, obviously they want to know about how risky is this exchange likely to be. So we've tried to balance, you know, what is, I think, was a rightful critique of it being a very long list of questions and potentially very overwhelming, or to your point, perhaps eliciting, you know, exaggerations perhaps, with what we were trying to accomplish, which is both law enforcement safety, following the research about what is indicators of highest risk cases, as well as allowing for a mechanism that isn't just relying on the respondent kind of on their honor system turning over a firearm.
Could the sheriff's office simply call the gun center?
I'm sorry, say that again?
Could the sheriff's office call the gun center?
Yeah, so we talked extensively with chiefs and sheriffs and Maryland State Police to better understand exactly how all of this plays out. In many jurisdictions, that is one of the steps that sheriffs are taking before they go to a place, to a person to get firearms away from them or to ask them to surrender. They do background checks, they do calls to the gun center to see if there's anything registered to that person's name. So that is definitely a step that some jurisdictions are doing, but we are not consistent amongst the 24 odd jurisdictions that we have in the state, and that is not necessarily the case everywhere.
It strikes me a little that could be a different way to go forward, as opposed to I understand that the length of the questionnaire is significantly different as amended, and I look forward to seeing the amendments, but it does strike me as being somewhat more practical to do it that way.
It's also not going to pick up those firearms that are not actually registered, but that
But do you believe that those people who have a non-registered firearm are going to report that they have a firearm?
No, but the petitioner might.
And that's what we're hoping this legislation would accomplish. Again, in our experience, the petitioner's telling me as counsel he has many guns, and yet currently there's no mechanism for the judge to, for example, order a search warrant if necessary. So we're hoping that this by having a petition that has this level of detail regarding the gun possession. And of course, if there are no guns, petitioner can just skip this whole section, so that the judge can be alerted to a circumstance where there are unregistered firearms held by the respondent.
All right, Delegate Erica.
Thank you, Mr. Chair. Thank you guys for being here. The gentleman on the end, you mentioned some really incredible statistics. And did you say you did the studies, or did you participate in?
I participated in the study of state laws.
Okay, so I think you mentioned that 220 people had been, women had been killed. How many of those 220 people were victims who this law could actually have saved? Like, how many of them had a partner who retained a firearm, like during a temporary restraining order?
I think the 220 people may have been somebody else.
Oh, okay, that wasn't your study?
No.
What did your study show?
Our study was looking at variations in state laws and how those might affect different rates of intimate partner homicide. Okay, so I guess the same question would apply. So when you were looking at the different states, what did the death rate, like what did that look like for each state? So you could either do, pick a couple states, but just broadly, this specific law, if we were able to get them removed during the TRO process, the interim process. Because I did see here Maryland Network Against Domestic Violence wrote in and said that for the final protection order, we already have a mandatory removal. So I actually know somebody who had this happen to them. So the police came to their house and took their firearms. So that, at least for the final, I think works. So we're really just talking about the TRO process. In those other states, what are we looking at data-wise? Yeah, so we found that these protection orders in general were very important for reducing intimate partner homicide. But specifically, when states had this piece that focused on ex parte orders, so when there was a prohibition linked to ex parte orders like a temporary or interim order, there was a 13% reduction in intimate partner homicide. Okay. So one of our main takeaways from the paper was that these additional pieces, like ex parte orders and also firearm removal, those pieces are really important to protecting victims of domestic violence. Okay, so in 13%, what is that in actual numbers? What's the raw data for that? I don't have that in front of me, but I'm happy to provide it. Yeah, it just helps us know, is it statistically significant? Like, are we looking at a big pool or is this a tiny pool and we're sort of like, you know what I mean? Yeah, absolutely. Yeah, that would be good. And then the search warrant piece that was brought up, that piqued my interest. So I know you've amended a lot of the questions out. And you'd mentioned that a judge can't issue a search warrant. I assume they could if there was probable cause. Is the goal of the questions to reach that level? And is there any other states that have attained that? I'm just wondering, because it's feeling very he said, she said. I don't know if it's gonna, you tell me, is there a real chance here we're getting to a point where we're actually at probable cause? And a judge could say, this petitioner's provided enough comment, essentially, or do they have to provide actual evidence? For a search warrant? Is that right. This is in the case that someone has either an illegally possessed firearm or a firearm that's a long gun that's not registered, so that wouldn't show up in a system. So I think that it would actually be probably the actual process would likely be that the judge could alert law enforcement to be seeking the search warrant, because obviously law enforcement would need to execute the search warrant. So it's really a mechanism in which the judge would be alerted by this petitioner, because as I think we all know, it's a largely pro se litigants who are before the judges. Okay. So it's a way to elicit information that would be valuable to the judge. And again, even when representing survivors, this kind of colloquy does not happen with the court at all. We are only raising it when, one of our clients is saying, I'm very, very fearful. I know he owns guns. Okay. So, and again, I practice in Baltimore City, where there are, as we know, sadly, way too many unregistered firearms in the city. So
What currently happens, and I really appreciate your friend's experience, and that's great, does not happen in Baltimore City, that the guns are just taken.
Interesting. Okay, so different jurisdictions are
very
currently handling
different.
final protective orders differently?
Absolutely.
Okay, that might be something to work on,
And we
as
did,
well.
during this process, spoke with the sheriff in Montgomery County, and they do have a very well-developed process for how they do this in Montgomery County.
Okay.
So I think there is a model that could be replicated, or at least investigated for replication. I know all of us also spoke to other states in which this legislation currently exists. And so there are, many models across the country of how this is done in a way that I think avoids the risk of the he said, she said.
Okay, and that brought me another question up. Sorry, Mr. Chair, I want to dig to the bottom, but what other states have implemented this, and like when did they do it? So are we looking at like long-term, longitudinal data, or is this kind of like a fresh idea?
Well, actually, no, it does date back significantly. The Violence Against Women Act, which was passed more than 30 years ago, this was a prohibition as a result of that federal act.
Just the TROs or for the permanents?
For the permanent protection orders.
Okay, so for the ones with the TROs, what states are doing that?
Well, I know Washington State is probably the most longest standing. I'm looking at my gun experts. So King County, Seattle, Washington.
Okay.
They have one of the longest standing. Some of the other states that we spoke with, Connecticut, California.
New Jersey also has been doing it for a long time.
Okay, and this is all for the ex parte ones, the
correct
temporary stuff? Okay, interesting. And then for the data, where did you pull, like, where did you get, what's the source for the data? Where does the source data come from? Is this just from state websites? Do states track this stuff?
So
Because I tried to pull up some of our data. It doesn't really tell us anything about domestic violence. It's just kind of like deaths broadly.
So for our research, we have gotten FBI data.
Okay.
States report data to the FBI. Most states have done it for quite a long time, although there is some variation. And in the supplemental homicide reports, you're able to look at information about the relationship between the victim and the perpetrator. And so you're able to identify which of these are intimate partner, homicides, domestic violence, et cetera.
Okay. And then who funds it?
Who funds?
Yeah, who funds the research?
This research, I can't recall who funded this study. I could
Is it
get
peer reviewed? I mean, do you send it out?
Yes, this is peer reviewed,
Okay.
yes. This was in the American Journal of Epidemiology.
Okay, thank you. All right, thank you, Mr. Chair. Thanks for your indulgence.
In reference to the comment of to know, how would the petitioner know that the person has a firearm?
How would the petitioner know?
Yeah.
Is that the question?
Yes.
Only in instances where, they are in an intimate relationship by definition in order to seek a protection order versus a peace order. So the questions are asking the petitioner if known. So if they live together, if they were dated.
They told you, you saw it, what is no?
Yeah, but that does not set a standard for what the basis of knowledge is. It's relying on the petitioner's knowledge in the same way that, they're obviously swearing under oath that this is, everything they're stating in the petition is accurate.
So they could state under oath that they know, but they really haven't seen what they were told. Which
I suppose that's a possibility.
Right, okay. And so after the judge asked the person who's going to get the ex parte against them, how's the sheriff going to engage that person about the alleged guns?
Well, the impetus would be on the respondent to voluntarily turn over the gun, but if that were not the case, then the sheriff would go to the respondent's home.
What gun?
I'm sorry?
The gun that you know but you haven't seen. Possibly, right?
I guess the sheriff would go to the house and the respondent would say there is no gun here.
No, but you said that the judge is going to ask the respondent first, right? And the respondent says, no, I have no guns.
That's what currently happens.
Right,
yes.
and then so now you want the sheriff after that to go to the house and
Well, it would actually be
again.
after an ex parte hearing, so the respondent would not be present during that ex parte hearing. But that is what happens in Baltimore City
Yeah, all I'm
currently.
trying to find out is how is the sheriff going to make contact with the person?
By going to their home.
Their new home where they staying after the ex parte has been issued?
Or in the home that they live in, correct, wherever they are. Yeah.
Thank you so very much.
Or if the gun is in the home, this also happens in the home that the petitioner is currently in, and perhaps the respondent has been ordered to leave, that the sheriff or the petitioner would be able to turn over the gun, or the sheriff would come to the home where now only the petitioner resides to take possession of that gun until the order either was vacated because of the time limit on it, or after a full hearing, if the petitioner was found not to have met their burden of proof.
Does the sheriff, in that scenario where they've gone to the house, have the ability legally, constitutionally, to go into the house to get the gun?
I don't know the answer to that question. I believe it would have to be a search warrant for the sheriff to go in and see
So
the gun.
I guess that's where I was going. There would need to be some other action that happens. The sheriff, just in serving a protective order, an ex parte order, could not then go into the house or after the ex parte order was served, say, okay, we're now conducting a search to look for all the guns in the house. And is that, Ms. Herron? Go ahead.
That's correct, Your Honor. Sorry, Your Honor, Mr. Chair. I used to be a prosecutor. It's an old habit. Yes.
It's fun when when I'm a state's attorney at my day job and I go across the street to circuit court and I start referring to the judge as Madam Speaker. It's very confusing for everybody. It happens a lot, actually, but anyway.
Yes, Mr. Chair. There's something in this bill or that serving the interim protective order or temporary protective order would authorize, entering the home to search the home without a search warrant. And so the idea is that we're getting the information, the questions that are still in the bill during the petitioner's, petition is there so that they can get a search warrant if the respondent is not willing to turn over their firearms. If they need to then get a search warrant to enter the home and recover the firearm, they have enough particularized information that they can get that search warrant. So,
All right, Delegate Schmidt.
Thank you, Chair. Quick question, Mr. McCourt, and I know you have some other fellows here that are involved in some of the research that you do. Publichealth.jhu.edu only has numbers from the CDC back to 2022. How can we get more relevant data so that we can understand, right? Because this tells me there's 813 gun deaths in Maryland at that time. I'm not sure if it's gone up or down. We're now 2 years past this data. The alarming thing I see, right, homicides are a big portion of that. Suicides, number 2. Children, number 3, 51. But when I scroll down to the key takeaways and we talk about how the gun death rate has increased 40%, are we seeing that continue, or is it, and where is it coming from, would be my guess. And I know the fine delegate from Hartford had touched on some of this with the statistics. What are you seeing in your research that will allow us to say this is a major issue?
Yeah, that's a great question. So the data that we have on our website that goes, we have state by state data and some reports looking at CDC data. All of that is taken from the CDC's vital statistics report.
Yep, I see that, yep.
There is a significant delay in what the CDC reports. So 2023 data just came out.
Okay.
So we're in the process of getting that and hoping that our access remains good. But going through and issuing these reports. So we can only keep up with what the CDC is issuing.
And you had mentioned some peer-to-peer reporting as well. So I don't know if there's a way to bring it down to the micro level, that you see different areas that are doing different have different needs, right?
Yeah, so you can get from the CDC, you can get county level data for research purposes. But we don't go out and pull data from other sources to do that. That said, we are seeing some promising data both nationwide and locally with respect to homicide in particular. There's still a large amount of gun violence, both homicide, suicide, and different types of homicide, whether we're talking about intimate partner or involving children who are able to access guns. But yes, this is an ongoing analysis for our team.
Okay. Yeah, I appreciate that. Thank you.
And if I might, there's also, on a national level, the additional step that Dr. McCourt mentioned of identifying the relationship between the person that committed the homicide and the victim is not uniformly done across the country. So there are many, many homicides that are reported as homicides, but are actually domestic violence homicides. So the numbers are sometimes, without that additional level of analysis of the data, as reported, it might underreport the domestic violence related homicides.
I mean, as we've been having this lengthy conversation, right, I've been looking Bloomberg School of Public Health. I've been diving into each one of these things that you've been bringing up, and it's interesting to learn that, right? And if we don't have uniformity across, we just don't know. And then some of my other colleagues have touched on what we don't know is what else is in the house, what else is not registered, what else. It just keeps going deeper and deeper and deeper, which allows us to work on this bill as a committee to help you get to the end result that you're looking for. So
appreciate that.
Yeah, thank you.
Thank you.
Thank you, Chair.
Delegate Valentine.
Thank you, Mr. Chair. Thank you. I was wondering if anyone on the panel can take this. It would probably be like Ms. Aaron, probably.
Your mic. There you go. Now you've got a microphone.
Thank you, Mr. Chair, and thank you, panel. My question revolves around the terminology for the three types of orders, and I would like to get some clarification and explanation on the difference between interim, temporary, and final, and if you could give me some details on each. So for like timelines, who issues them, how long they're good for, et cetera, in each one of the three steps.
I'll probably rely on Aaron here to help me out a little bit. But so at the interim phase, not every petitioner will actually be getting an interim protective order. These are happening really only when the court is closed. So they're for a short amount of time. We're talking up to 48 hours, I think, before the court opens again.
Next business day.
Next business day.
The court's in session, yeah.
And then you end up with the temporary hearing, which if a temporary order is issued, that can last somewhere in the neighborhood of like 6 months or so. I'm looking at you guys to make sure I'm saying that correctly.
It defaults, I think at most it starts out at 7 days, but can be extended up to 6 months depending on, I think that the statute says if needed.
And typically it's needed because service on the respondent has not been accomplished. So that's the most, in my experience, I don't have data to support this, but in my experience, the most likely reason that a temporary order is extended beyond the initial 7 days is because the next hearing would be with both parties present.
The respondent wasn't served.
Respondent wasn't served, so the temporary just keeps getting extended until service is accomplished.
Okay.
Up to 6 months, but doesn't usually take that long.
And then the final order?
Is when, following a hearing where both parties are present or.
So my question on the interim, that would be issued by a district court commissioner and not a judge, correct?
Correct.
Okay. And so that order could literally be issued by a district court commissioner and then be valid till the next business day. So how do we confiscate a firearm if it's ordered at 8 o'clock tonight? It's might not be served or it is served, but then they're in court the next day at 11 o'clock docket or 1 o'clock docket.
Right.
So we're taking it, you see where I'm going?
Yeah, and I think we need to take into account that the interim, for an interim order to need to take away a firearm, it needs to be a fairly egregious situation. The person is in real fear and danger for their life, and they're coming to the court off hours to get this petition. So you're sort of lining it up, if you will, with like what we did with ERPO, for instance. We do a similar type of situation with ERPO where it's an emergency situation. We really need to get firearms out of the hands of someone who is very possibly going to be violent with them. And so
maybe not using those resources to do it in every single case, because every single case doesn't warrant that kind of emergency response. I get the difficulties that you're talking. This is a scenario where we want law enforcement acting and acting quickly.
I guess my last question is, I'm trying to phrase this properly. At what level or what time, and I believe I know the answer to this, is a respondent actually have the opportunity to speak on this matter?
I believe they have the opportunity to come in at the temporary hearing, which they don't always do from what our DV advocates tell us. They frequently don't show up. But if they wish to, they have notice and opportunity to do so.
Is that if there was an interim and that interim was served?
That's across the board, right?
That would be the only scenario in which, because a temporary sometimes is the first step, correct?
Correct, correct. So typically, the respondent only is aware that there's a hearing for the temporary order if they've been served with the interim. Or did I reverse? So yes, it very rarely is the respondent present for that first hearing before a judge.
Okay. Thank you, Mr. Chair.
Thank you, Mr. Chair. Just wanted to ask briefly about a couple points. I'm looking at the literature here. It says an average of 47 domestic homicides per year over the past 10 or so years. What's the source for that? The data source?
It's the Maryland Network Against Domestic Violence, and I know Jen was here. Oh, yes. Okay, so they're on the next panel.
Got it. And access to firearms make it 5 times more likely to kill a female victim. What was the source for that?
Every town for gun safety.
Every town. What is the ratio for male victims?
Ratio
For female to male?
Yes.
Like how many? I don't have that statistic. So
Okay.
we could certainly.
Okay. The statistic, 74% of domestic violence deaths involve the use of a firearm. Do we have the source on that?
Yes, that is from the 2023 Domestic Violence Fatality Review State Implementation Team Report.
Gotcha. Was there a reason we didn't use like the Maryland Uniform Crime Report or the National Incident-Based Reporting System? We didn't refer to that data?
No specific reason.
I don't think there's a specific reason not to use it.
Okay. And one last question. We said that one of the big purposes of this was to go after the unregistered guns. Is that, in those cases, was there evidence required, or are we relying specifically just on a statement under oath?
And I should clarify, this isn't only to go after unregistered guns. That is just, in my experience, has been one of the biggest challenges is when there is not, when the respondent does not have a permit to be carrying the firearm. So now that I've provided that clarification, I've forgotten your question. Apologies.
The question was, for the cases where you're alleging that I'm a victim of abuse, the abuser has an unregistered firearm, is there, are we relying on kind of evidence submitted with that claim, or is it strictly a statement under oath?
At this stage, it would be a statement under oath. For the permanent order, very likely the judge would be seeking some kind of evidence. But again, in an ideal world, either the respondent has already willingly turned over their firearm, or the sheriff's gone to the home and retrieved the firearm. So it would no longer be in dispute that there's a firearm exists. However, if the petitioner did not meet the standard of proof for the abuse that was alleged, the firearm would be returned to the respondent immediately after that hearing.
Okay, thank you.
All right, seeing no further questions for this panel, thank you all very much.
Thank you. Thank you.
Committee, it is 5:22. We have another 55 witnesses, which is about half of how many witnesses we had at the start of the day. We have about 55 more witnesses to go on all the bills, including on some bills that we've heard before. The words "me" and "to" are awfully helpful and are chronically underused in this committee. So just saying, might not be a bad idea to start practicing. Clinton Wolcott, Peter Benjamin, Madeline Cobb. Katie O'Malley is virtual, and I see her there. We'll take her there. Taria Stanley. Louisa Depkin. I'm watching the chairs, and when they fill up, I'm going to stop. Nicole Hollywood. I don't see anybody moving. Elaine Orange. We have Kelly Sampson there virtually too. I think that's going to take us through the favorables. And so with that, whoever would like to go first, please go ahead.
So I'll go first. Chair Clippinger in committee.
I need you to speak up or speak right into the microphone.
Okay. Hi, I'm Clint Wolcott, and I represent the Critical Issues Forum Advocacy for Social Justice. It's a coalition of 3 Montgomery County synagogues, advocates for policy solutions that promote core Jewish values, including the tradition's emphasis on the primary value of human life. And taking my cue from the chairman, I'm not going to read the 2-minute statement that I have here. The reasons for this bill were very well explained by the first panel. We totally support it, and I'll leave it at that.
Good evening, Chair Clippinger and esteemed committee members. Thank you for the opportunity to testify today. I promise I'll be quick. My name is Taria Stanley, and I am here today on behalf of Community Justice. And Community Justice is a national organization that advocates for gun violence prevention by empowering those closest to the pain to advance life-saving solutions. But I am also here today as a survivor of intimate partner violence, and I am here today alive solely because my abuser was not able to get his hands on a firearm. The harsh reality is that in this country, women are 11 times more likely to be killed with a firearm. The relationship between firearms and domestic violence is a dangerous and deadly one. When firearms are present in domestic violence situations, they significantly increase the likelihood of fatal outcomes. Studies show that the presence of a firearm in a domestic violence scenario increases the risk of homicide by 500%. For Black women, women of color, and the LGBTQIA+ community, this is more pronounced. In Maryland, the intersection of domestic violence and firearms has tragically led to numerous fatalities. In 2021, there were at least 88 domestic violence-related homicides in the state, with 57% involving firearms. House Bill 1050 is a step in the right direction because it ensures that when a protective order is issued, the abuser will be required to surrender any firearms they may possess. For these reasons, and all the reasons that were stated before me, I urge the committee to support House Bill 1050 and help to ensure that more survivors can become more victims of domestic violence can become survivors rather than victims of homicide, and that all survivors in Maryland are afforded the safety and protection that they deserve every single day. Thank you.
What was your name again?
Taria Stanley.
Art.
Let me grab a microphone. Good afternoon, Chair. Good evening, Chair Clippinger, members of the committee. My name is Elaine Arndt, and I'm a resident of District 46. Today, I'm delivering the testimony for my friend and colleague, Dr. Nicole Hollywood, who can't be here today. Like me, she's a volunteer with Maryland Moms Demand Action. She resides in District 37. She is a survivor of gun violence, a gun owner, a mother, and a college educator. I'm going to read the rest of her statement as she wrote it in the first person. I asked for a favorable report of HB 1050 because I know firsthand what it is like to have my children and me repeatedly controlled, threatened, and terrorized by an armed abuser, and that individuals fleeing domestic violence face a multitude of barriers, chief among them being a lack of clarity and enforcement of firearm prohibitions for perpetrators of domestic violence. My ex-husband, during one of his many blackout drunk moments, held a gun to my son's head. My son was only 9 years old at the time. After we separated, he started breaking into my house while armed. Ultimately, I got a restraining order. However, when the judge ordered him to turn in all of his firearms, he only gave up one, despite having an arsenal. There was never any follow-up from law enforcement. Guns amplify the coercive power and control dynamics inherent in abusive intimate relationships. This bill would strengthen Maryland law to make sure that firearms are kept out of the hands of domestic abusers when the victims first seek protection from a court through an interim or temporary protective order, which is a highly dangerous time for victims. With that, Nicole went on to point out many of the statistics that have already been cited, so I will just say that she supports those comments as well.
I am Peter Benjamin. I'm a member of Marylanders to Prevent Gun Violence. This testimony is my own and may differ in some places from the principles that Marylanders holds for this particular legislation. I'm going to skip a large portion of my notes, mainly because, as you point out, they have already been discussed. The proposed legislation modifies existing legislation. The existing legislation allows abused persons to file a petition for relief in court that can result in an interim protective order. The respondent is not expected to be very happy about the interim order or about the scheduled temporary order hearing. This interim order can result in a requirement that the abuser relinquish firearms, but does not direct it. The method for getting those firearms and ensuring that the abuser does not have them or obtain them is not clear. This legislation modifies the previous one and includes relinquishing the firearms in the interim protective order, again, subject to the judge's order. Asks the petitioner to provide information, which we have discussed, directs that the police officer go to the expected location of any weapons to assure that they are relinquished and that no new ones have been purchased, creates a task force to study the use of firearms in domestic violence situations to ensure that there is a process to make sure that guns are taken out if necessary, and creates a pilot program to test the recommendations of that study. The report is due back to this committee by November 15th, and I recommend a positive referral.
Hello, my name is Louisa Depkin. I'm a current senior at Lock Raven High School, a co-leader of Team Enough Baltimore, a youth-led organization that works to fight gun violence, and a mentee with the Baltimore County Commission for Women. The situation this bill addresses is incredibly dangerous, but not only is the life of the petitioner at risk, but their children as well. While parents may be scared of their children getting shot at school, children are 3 times more likely to be shot at home due to domestic violence incidences. In addition to the lack of safety these kids deal with, they can also have lasting mental effects. PTSD, anxiety, and depression causes these children to suffer even more. This bill not only thinks about the petitioner's safety, but works to protect children from gun violence as well. I've been lucky enough in my life to not have been impacted or know someone who's been impacted by domestic violence, but according to the statistics, it's only a matter of time. On behalf of the Baltimore County Commission for Women and Team Enough Baltimore, I urge a favorable report for HB 317.
Judge O'Malley, please, for 2 minutes.
Thank you, Chair Clippinger. Good evening, members of the Judiciary Committee. My name is Katie O'Malley. I'm the Executive Director of the Women's Law Center. You've all been very patient listening to the reasons why this bill is so important. I can tell you for 22 years as a district court judge, I was so frustrated by the fact that there has not ever been a mechanism, a statewide uniform mechanism for getting guns from abusers. In the past 5 years in Maryland, 237 people were killed in domestic violence incidents. 75% of those murders were done with a firearm. I cannot tell you how important this bill is, because it not only would allow a further investigation through law enforcement to seek a search warrant if there is reliable probable cause that a firearm hasn't been surrendered, but it also will mandate that law enforcement follows up when a petitioner believes and has reason to believe that there is a firearm that could be used against that petitioner and the family. I've known many situations, 2 personal situations, where people, after a protective order was granted, were then one woman was murdered and then another woman was almost murdered because the firearm wasn't relinquished. So I'm happy to answer questions after everyone else testifies, but I can't tell you enough that how important this bill would be. So I urge a favorable report.
Kelly Sampson for 2 minutes, please.
Thank you, Chair Clippinger. And heeding your call for brevity, I'll just say 2 things. First, Brady enthusiastically supports this bill because it will save lives. And second, just to put a finer point on it, we know that one of the most dangerous and risky times in an abusive relationship is when the person being abused tries to leave. And that's why this bill is so important. And we urge a favorable report. Thank you.
See, that was 22 seconds. That's great. All right. Any questions for this panel? Seeing none, thank you very much. Just our last call for straight favorables. Peter Benjamin, Madeline Cobb. Oh, did Madeline, did I get that wrong? I apologize if I did. Nicole Hollywood? No. No, all right. So those are the people testifying as favorables. We'll now go to the favorable with amendments. Jen Policonis, Jennifer Pollitt Hill, Karen Watkins, Andrea Mansfield. And whoever would like to go first is more than welcome. Again, these are favorable with amendments, and then we'll go to the unfavorables. Whoever would like to go first, go ahead.
Yes. Good afternoon, esteemed members of the Judiciary Committee. I'm Karan Watkins with Harris Jones and Malone here on behalf of the House of Ruth of Maryland. We are in favor of this bill, House Bill 1050, as amended to conform with the amended version that was presented and heard in the House, in the Senate yesterday. Just to be very clear, the amendments reflect those concerns that the House of Ruth had, so they have already been addressed through the amendments made, and those were basically around the litany of questions that were asked of the petitioner, and that we believed would put the petitioner in further harm, violate their confidentiality, so on and so forth. So for that reason, we urge a favorable a favorable vote as amended.
Hi, my name is Jen Poliakonis. I am the Executive Director of the newly established Center for Firearm Violence Prevention and Intervention at the Maryland Department of Health. Addressing domestic gun violence is a key component to our mission, and I just wanted to take a moment to highlight the portion of the bill related to the creation of the task force. We support the creation of this task force. It's a great example of utilizing the public health method to look at what's actually working, how can it work better, and how can we then publish recommendations so that we can make those solutions actually happen. We have a small amendment just extending the timeline for this task force from 6 months to 12 months to actually allow for quality work and a quality report. With that amendment, the Maryland Department of Health urges you to support House Bill 1050.
That appears to be one of the amendments that the sponsor already is submitting to the room.
Perfect.
Go ahead.
Good afternoon. I'm Jennifer Pollitt Hill. I'm Executive Director of the Maryland Network Against Domestic Violence. I want to share one statistic that hasn't been shared. I'm happy to answer any of the data points that came up earlier. But in the tracking that we do, 68% of victims have either left the relationship or are in the process of leaving when they are murdered. So that's why a relinquishment of guns earlier in the process will save lives. I also want to underscore the second part of this bill, which strengthens the process for taking away the guns, even under the law that's currently implemented at a final protective order. That system is not working. So there's two pieces, and I want to make sure that the second piece, that there is actual relinquishment in the final, does not get missed. Thank you. We urge a favorable report with amendments.
Yep, thank you. Mr. Chair, members of the committee, Andrea Mansfield, representing the police chiefs and sheriffs. I'm here supporting the bill with favorable with amendments. law enforcement, they fully understand the urgency of these circumstances. Their concerns, though, they have two. One's more for clarifying amendment. It's the relinquishing of the firearms at the interim protective order stage. Their concern is that there's no judicial review at that process, and they feel that that should take place when those decisions are made. But also more from a resource perspective, at the interim stage, the temporary order, that hearing may be held within a day or two after that interim order is issued. And really from a resource perspective, they would be taking the firearms and then having to, if this order does not go through to the next stage, they would then have to give those back almost immediately, and that would be really difficult for the sheriff's offices to manage that type of a process. I guess also add, it is my understanding that, really law enforcement or the sheriff can only go and actually take the firearms that the petitioner or the respondent is willing to give them. They can't just go and take them. There needs to be consent. And if there's not consent, that is at the point where they will get a search warrant to go and then actually take the firearms from the respondent. But thank you.
Questions? All right. Seeing none, we thank you all for your time this evening. All right. Two people testifying unfavorable, Mr. Panak, Mr. Jocelyn. Just making sure, Kathy Wright is not here. I have her listed as not coming tonight. Kathy Wright, no? Got it.
She's not here this evening, Mr. Chairman.
All right. All right, well, Mr. Jocelyn, Mr. Panak sat down first. So Mr. Panak gets to go first. You almost beat him. I'm just saying, it was close. Mr. Panak.
Thank you, Mr. Chair. It's not often I come into legislation that has 5 separate constitutional violations, indeed 6. So let me count them. First, it authorizes the seizure of personal property on grounds of reasonable grounds, not on probable cause. That's a direct violation of Article 26 of the Maryland Declaration of Rights and the text of the 4th Amendment to the United States Constitution. So, number 3, probable cause what? Well, Rahimi sets the standard. The standard is probable cause that the respondent poses a risk to the physical safety of the petitioner. That's the standard procedure disarming someone who has a constitutional right to possess firearms. This legislation does not allow for any such specific finding. It does not require it, and these protective orders may issue without regard to the parts of them, can be issued without a finding that there's any risk at all. And I refer you to the abuse standard that's in 4-501 that includes issuance of a protective order for false imprisonment, which may or may not include a risk of physical injury, stalking, which may or may not include a risk of physical injury, revenge porn, which can be issued for harm for economic loss. It also can be issued for the protection of a child for mental abuse. So you haven't crossed the T's or dotted the I's. Then you have the due process violations where you're taking away constitutionally protected property without so much of a hearing. The respondent doesn't even get a hearing under this set of statutes until the final protective order. He may be present at the temporary one, but he's not accorded the basic elements of due process of law, which is the right to present evidence, the right to cross-examination, the right to present compulsory process. I urge an unfavorable report.
Thank you, Mr. Chairman. John Jocelyn, speaking for 2A Maryland in opposition to this legislation. Violence is behavior, not technology. It's a false premise that by removing the firearms from a relationship will mitigate the threat. In fact, it could actually exacerbate it. Based upon the UCR report from 2023, which did a 5-year look back on domestic-related crimes, there were over 142,000 domestic-related crimes in Maryland. 202 involved a homicide. That's 0.1% of the total number. Egregious as it is, we're still focusing on the small package that we're looking at. 1.6, on aggravated assault, firearms were used in 8.7%. Knives, 18.5%, other weapons, 29%, and no weapon at all, 43%. The bill requires or allows for the confiscation of firearms in the respondent's possession. The operative term here is possession. They have no idea how many firearms the person owns or where they might be. If they are not within the person's direct control, they are by definition not in that person's possession. So any firearm that's hidden in a storage locker, at another girlfriend's house, at a buddy's house, at a hunting cabin somewhere, are not in their possession. That doesn't mean they don't have access. The unfortunate thing about this is, as the lady said, safety and protection, this bill provides neither. It will project a false sense of security. It will lead the victim to believe that somehow they've been protected when in fact they have not been. And I can tell you as a personal protection instructor, as a refuse to be a victim instructor, when you believe you're safe, that's when you're unsafe because you've let your guard down. We ask for an unfavorable report on this bill.
Thank you, Chairman. Thank you, panel. Mr. Panak, can you explain for this body the case law Henry versus the County of Nassau?
So that was a Second Circuit decision decided in 2021 in which the court rejected a ex parte order as a sufficient basis for the seizure of firearms.
Thank you.
Delegate Kramer.
Thank you, Mr. Chair. Mr. Jocelyn, you put emphasis on the word possession, and I do see some problems with the bill regarding possession. Can you elaborate about your concerns?
Anyone who's in a relationship that's gone rocky can anticipate that this eventuality would occur. Years ago, I had a friend who was a high school buddy, who was a lieutenant in Baltimore City Police Department. And we talked about this issue back and forth just casually, and he said, sometimes the order is filed just to gain leverage. Now, this is not to make light of the domestic violence problem. I said, let it go. Years later, I spoke to an attorney and about the same thing, and he said, well, sometimes when he's working a case, he'll suggest doing this because it helps in the divorce, gives them a little more leverage to use. Again, I said, humph, so what? Then my late brother, when his marriage was breaking up, and I could see that things were not going well for him, I said, get your guns out of the house. Get them someplace safe where they're secure and you know nothing will happen to them. Just don't have them in your possession. A month later, his soon-to-be ex-wife threw a diaper at him. He threw it back. She filed for protection order. It was later dropped because she couldn't establish that there was any threat. The police showed up. She said, oh, the guns are right there. My brother gave the officer the key to the storage locker. The officer opened it up and there were no firearms there. Now, I had no problem with my brother. He was never violent. I never thought that he would ever do anything, so I felt comfortable telling him, get him out of the house and don't go through the hassle of fighting to get him back. But for those who have other ideas in mind, they certainly are smart enough to do the same thing. So this is basically a feel-good kind of thing, but is not going to produce what the piece of paper says it will. And anybody who is truly violent will have a way to do this, even if they don't have the firearm. Certainly there are many other means. As a matter of fact, in domestic violence cases, the weapon of choice for a female abuser is a knife by a large ratio. Males are the victims 31% of the time, according to the UCR. So yes, there are other means, and certainly anyone who's willing to do something up close and personal as a knife is certainly willing to do something else where you don't have to be that close.
Got it, thank you. And briefly for Mr. Panak, it was mentioned on a previous panel that Rahimi was the standard and that enabled this legislation, but you actually see it different. Can you comment on that?
Sure. Rahimi said that you need a threat to physical safety to disarm someone. That was the standard set forth in federal law and therefore sustained under federal law. The Maryland statute is not the same thing as the federal statute. It authorizes protective orders without such a showing. Indeed, this bill mandates a seizure of personal property, the firearms, without any showing of that, because certainly some situations exist and where that showing could be made, but it doesn't actually require it. You don't have a requirement that there be a finding, as it is true in federal law in section 922G8, where there is that sort of risk. So if you're going to make this constitutional, what you have to do is require the court to actually make an assessment that this person actually poses such a risk to the physical safety. And before he issues the order under the Fourth Amendment, he has to satisfy the probable cause. Because you can't go up and seize property under the Fourth Amendment without a probable cause showing, because these orders are warrants. And that's what a warrant does. It's based only on probable cause. It's right in the text of the Fourth Amendment, and then Article 26 is the same. Now, there's all kinds of bases, and I outlined some, where you can get a protective order that is not based upon any risk of physical safety. So requiring the judge to actually walk through what's required under the Constitution is what will make this bill constitutional. But right now, it's not. Indeed, it authorizes a sheriff without showing a warrant at all to walk into somebody's home where it's the sanctuary under the most protected area under the Fourth Amendment and seize property without judicial supervision. That's a breathtaking violation. That's number 6. So, I mean, there's all kinds of problems with that. And then you have a further requirement that the individual actually incriminated himself with affidavits and proof that he has to submit to the sheriff and to the court that he has divested himself of firearms. That's illegal under Hayes and Freeman, as construed by the Supreme Court. So, I mean, this is run rampant with constitutional problems.
Thank you.
And if I could piggyback on what Mr. Pennock said, based upon the system, if you have a couple in a relationship, they both own firearms. The victim has some, the respondent has some. The respondent says, oh, by the way, over at her house, they're all mine. Now law enforcement is in a quandary. Who do they believe and how do they prove it? They will probably err on safety and take them all.
Thank you, Mr. Chairman. Thank you, panel, for coming in. In reference to the knife comment, can you repeat the knife comment? And I think, are you saying this because the use of a knife might be considered a personal type of crime, or do you have statistics on this, on the knife?
According to the UCR report, in aggravated assaults, this is in domestic violence, a knife was used in 4,911 instances from 2019 to 2023, and that represents 18.5%.
And versus a firearm?
Firearm was 8.7. Now, these are aggravated assaults, and it's unclear whether they differentiate. I mean, certainly homicide would be an aggravated assault, but it's unclear whether homicides are included in the aggravated assault numbers here.
Thank you so very much.
Seeing no further questions, thank you all very much. That concludes the testimony on House Bill 1050. We're now going to Delegate Tolles and House Bill 944. Delegate Tolles, Haley Lichterman, Chantra Trivedi, Nina Villamar, and then virtually Jessica Moranto, Kenneth Wardlaw, and Lucy D'Onofrio. No Lucy, but you have Wardlaw and Moranto? All right. Delegate Tolles, Nina Villamar, and then virtually Jessica Moranto, Kenneth Wardlaw, and Lucy D'Onofrio. It's lovely. It really is. Dulcet tones. Oh, members of the committee, just as a moment, just so you know, we are at 13. We have to have 12 or we got to stop. So talk to somebody. Well, you can go, but just being aware that you got to have people coming back and forth. Delegate Tolles.
Sorry, colleagues. Okay. Thank you, Mr. Chair. So Chair Klippinger and colleagues, I'm here to present Family Law Children in Need of Assistance and Termination of Parental Rights, HB 944. Thank you for the opportunity to present. This bill will repeal a provision that authorizes a local Department of Social Services to ask the juvenile court to find the reasonable efforts to reunify a child with the child's parent or guardian are not required if the local department concludes that a parent or guardian has involuntarily lost parental rights to a sibling of the child. Repealing a provision that requires the court to determine whether to involuntarily terminate parental rights, which is language from the bill. So when a child goes into foster care, the Department of Social Services has to make efforts to reunite the child with their parent. These are called reasonable efforts. The permanency plan is the goal for which the parties and family are working towards. The initial permanency plan is always reunification. The statute provides that after 15 of the last 22 months that a child is in foster care, DSS may ask the courts to change the child's permanency plan to a temporary parental rights / adoption. While it is a parent's due process right to have a contested hearing to fight for their parental rights, unfortunately, the law as it is currently written states that if a parent exercises that due process right and they lose, Department of Social Services is not required to provide reasonable efforts toward reunification for any other subsequent children that come into care. The problem with this law is, one, it places parents in the position to have to choose between their children. Do they fight for the one at the expense of the other, or future children, or do they put any other children in jeopardy of fighting for their rights to the child before the court? The law also gives no discretion to courts to choose whether DSS should provide reasonable efforts to a parent who may have lost parental rights to a previous child. Lastly, the law does not allow for the consideration of a change in circumstances or passage of time. It is both unfair to parents to have to make this choice, but it's also unfair to their counsel to have to advise, sometimes strongly, their client to make such a choice. Parents should be able to fight for all of their children. HB 944 would allow for a parent to not have to choose which child to fight for, whether it is for a current child or any future children. Colleagues, I asked for a favorable report on HB 944. We do have amendments as well, and we can go over them later. And now I would like to turn it over to the Office of the Public Defender, the Chief of the Parental Defense Division, Ms. Valamera.
Thank you, Delegate Tolles. Mr. Chair and members of the committee, good evening. My name is Nina Villamar, and I lead the Parental Defense Division of the Public Defender's Office. We represent about 95% of all parents who come in on child in need of assistance and TPR cases. TPR is the most, termination of parental rights, is the most extreme action that a state can take against a parent. It's considered the civil law equivalent of the death penalty because it is permanent and irreversible. And when parental rights are terminated, the parents have no ability to have future contact or relationships with their children, and it gives the state the power to make all future decisions about the child, including who should adopt them. Parents do have the right to contest the TPR and force the state to prove in court whether termination of parental rights is in the child's best interest. But under current Maryland law, if a parent fights the TPR and loses, then DSS no longer has to provide reasonable efforts to future children, even children who have not been born yet on the day of the TPR, no matter how much the parent's circumstances have changed and no matter how much time has passed. This law forces parents into the most impossible situation that you can put a parent in: fight for one child and risk losing all future children, or surrender and hope for another chance. It punishes parents who fight for their children, but worse, it punishes children when their parents refuse to give up on them. I'd like to quickly give you a real-world example of how this law works. Let's say that a mother raises her child alone for 10 years. The father is absent, but DSS locates him and involves him in the case. The mother struggles to make efforts to reunify while the father does nothing. DSS files for TPR. The mother objects, the father consents. 5 years later, they each have a different child. The Department of Social Services does not have to provide reunification efforts to the mother, but it must still do so for the father, even though he did nothing for the children. This is unjust, unconstitutional, and harmful to children. I urge you to pass this bill. Thank you.
Chair, Vice Chair, and members of the committee, my name is Shanta Trivedi, and I teach and write about the child welfare system at the University of Baltimore. And I'm the faculty director of the Center for Families, Children, and the Courts. I've also represented parents who have had their rights to their children involuntarily terminated by the state, and I urge you to issue a favorable report on HB 944. As you know, this bill would remove a prior TPR from the list of aggravated circumstances, and that would mean the DSS no longer needs to make reasonable efforts that are generally required. That is, they do not have to provide services to a family who has been separated so that they can reunify. This is antithetical to the goals of the child welfare system, which is supposed to focus on reunification and rehabilitation in each individual case. In these cases where a parent may be struggling with food insecurity, substance use disorder, or mental health concerns, the state has no obligation to provide them with supports. And it's really important to understand how TPR happens. Many, many parents lose their children forever, not because they were the worst parents, but because they failed to meet certain requirements in an arbitrary time frame. Federal law directs states to file a TPR if a child has been in foster care for 15 out of 22 months. For a parent to reunify with their child, they must generally engage in services designed to address the allegations against them, such as parenting classes or anger management. In certain cases, TPR is an inevitability. Incarcerated parents cannot access these services and therefore cannot comply. If a parent is struggling with substance use disorder, relapse is a very normal part of recovery, but can lead to a child going back to foster care and a parent having to start from scratch. In many situations, parents have drastically changed their life circumstances between a TPR and today, but they will not receive the benefits of reasonable efforts. Imagine a teenage parent who is themselves in the foster system and the state terminates their rights. 20 years later, they could be in a very different place in their lives, and the state would not have to make reasonable efforts to keep them with their child if they had contact with the system. TPR is deeply traumatizing for children. A legal proceeding that ends their familial relationship does not undo their biological and emotional connection, and it cannot erase their memories with their families. We should be avoiding it at all costs, and I therefore urge a favorable report.
Good evening. My name is Haley Lichterman, and I'm the Deputy Chief of the Parental Defense Division at the Maryland Office of the Public Defender. I have been doing this work for 14 years, the first 7 of which I spent representing children, and I went into this work idealistically, and in line with that belief, before I started, I thought that determination of parental rights would only happen in the most horrific and dire circumstances where a parent had truly harmed a child to no repair. But I quickly learned that that was not accurate. The Adoption and Safe Families Act makes a cause of action for a TPR just due to the length of time that the child has been in the foster system. Even if a parent completely ameliorates the harm of the removal, the TPR can still be granted simply because of that it took too long for the parent to get to that point. The law is already harsh and it should not contain any shortcuts. Decades of research demonstrates that reunification is best for children, families, and communities. I want to make it clear that by removing this provision about waiving reasonable efforts, it doesn't simply mean that there will be reunification. It would just mean that that DSS would have to provide that support to parents. 7 years ago, I made the choice to switch from representing children to representing parents based on seeing how important it was for parents to have due process and quality representation. Every time a TPR is filed, I have to advise my clients about the potential for a future waiver. For this reason alone, clients most often choose to consent to TPR out of fear, even in cases when they have a valid defense, and I personally don't think TPR is the answer. The law needs to change to give parents a fair chance in every single case and to treat every single child as a new case. The only reason that I can see for this law truly is to coerce parents into agreeing to a TPR. Otherwise, why would there be a distinction between voluntary and involuntary TPRs? In fact, often it's the voluntary TPRs that contain worse facts and allegations against a parent, and they will agree, than a TPR that's more borderline where a parent does choose to go to trial. Why should the parent with more severe allegations have an advantage over the parent with less severe allegations? Thank you.
Again, from the Office of the Public Defender, Kenneth Wardlaw.
Thank you. Good evening, Mr. Chairman, honorable members of the committee, and thank you, Delegate Tolles, for sponsoring this bill.
Perhaps he was just reiterating the other two members of the Public Defender's Office. Mr. Wardlaw, we're going to need you to start over.
He's frozen.
Okay. Mr. Wardlaw maybe needs to log back in, go back out and come back in. I can't tell. But we'll hear from Lucy D'Onofrio right now and let her begin to speak, please. Ms. D'Onofrio? Or no, that's not Ms. D'Onofrio. That's the one we don't have. Jessica Moranto is the one we have. So Ms. Moranto, please go ahead for 2 minutes.
Thank you. Good evening, Chairman, Vice Chair, and Judiciary Committee. I'm Jessica Moranto, and I'm asking for your favorable report on House Bill 944. In 2014, I was incarcerated for alleged child abuse. I sat in jail for 21 months, had no contact with my children during that time, and after an exhausting journey, I was released in 2016. Before then, I had a 19-year history of substance use, a mental health disorder, experienced homelessness, and past domestic violence. In 2018, I agreed to a voluntary TPR. This decision was less voluntary than made out of fear. I was advised that if I went to trial and lost, that my children would be adopted, and if I had another child removed in the future, my past would be held against me, and would make it so I couldn't work toward reunification with that child. It was a lose-lose situation. I was overwhelmed with the decision because I'd been sober for years, I had a job, I was stable, but I signed away my hopes of having my family, or perhaps a family ever again. Unless you've had to make this decision, I assure you it's not one you can ever comprehend. It brought me to my knees and nearly cost me all of my years of sobriety and my marriage. One of my biggest regrets in life is not fighting for my case in trial. The behind-the-scenes truth is that not all voluntary TPRs are truly voluntary. I only wanted to be with and see my children and have them grow up and have a future with me. And it was agreed that if I did terminate my rights voluntarily, that I'd be able to have visitations with them once a month. Laws that allow the department to waive future reasonable efforts after an involuntary TPR for any parent implies that parents are only as good as their worst mistakes. I'm not the woman I was in 2014. I'm a successful person with over 10 years of recovery. In fact, my daughter, who was removed at the age of 7, recently decided to come home to me on her 18th birthday because she loves and appreciates the woman I am today. We have made immeasurable efforts as a family, despite a TPR, to stay connected. And a department making an effort less than reasonable after family separation at any time is unreasonable. For these reasons, I'm urging for your favorable decision on House Bill 944.
Now, Lucy D'Onofrio, please.
Thank you. Good evening, Mr. Chair and the Judiciary Committee. My name is Lucy D'Onofrio, and I'm a licensed clinical social worker. I currently work for the Maryland Office of the Public Defender. However, I'm testifying today on my own behalf as a Baltimore City resident of Legislative District 43A. Today, I testify in support of House Bill 944. This bill would allow parents facing a termination of parental rights, or TPR, to make the decision about whether or not to contest it freely without coercion. When I began working in parental defense, I learned of the concept of a termination of parental rights and assumed it must be only for exceptional circumstances to make such a life-changing decision. I learned quickly that this is not always the case. TPR happens in a wide variety of circumstances, and I've had the displeasure of discussing with parents that DSS wants to terminate their parental rights. This conversation is impossible. I hear moms and dads tell me they must fight back because if they don't, their child will grow up thinking their parents didn't want them. TPRs are often referred to as the civil death penalty, and there's so much grief involved in losing a child that's still alive. As illogical as it sounds in our current system, parents with custody of one child are often told they're not fit to have rights to their others. I've had to explain to parents that have jobs, have other kids, have tried to jump through the hoops that have been asked of them, that if they fight this, they put their other children or their future children at risk. That's because of the provision currently in the law that makes it so that if a child is removed from a parent and the parent has a prior involuntary TPR, that child and parent are on the fast track for termination. HB 944 removes this harmful provision. It removes the gut-wrenching calculus that currently parents are faced with in deciding whether to fight against a TPR. Think about if you had to make this choice, what would you choose? And if you think to yourself, I'd never be in this situation, please know some of those parents thought that too. Today, I ask you to allow parents facing an already horrible situation the choice to fight or not fight without coercion. I urge you to issue a favorable report on House Bill 944.
Delegate Coffin.
Thank you, Mr. Chair. The timer went off before you had a chance to explain your amendments, Delegate Toll, so I wanted to provide you that opportunity.
Sure, thank you, Delegate Kaufman. Can I turn it over to the Chief of the Division to explain those amendments? Thank you, Mr. Chair.
The first amendment, Delegate Kaufman, is to the portion that's, it's under subtitle, it's on page, the second to the last page of the proposed bill. It's a mistake that the drafters made. We are not asking to change the portion regarding waiver of reasonable efforts when parents have been found to have tortured their child. We're not requesting that a conviction also be resulted from that. So that was a mistake by the drafters. We're simply asking for a change in the effect on TPRs when there's an involuntary TPR. So we need to keep the deletion that's under subsection B3. And those are the amendments. There were some mistakes made in the drafting, and we just wanted to make those corrections. And those address the opposition by one of the parties, as well as the concerns raised by Maryland Legal Aid.
Say that again, it's hard to hear you, Delegate. Yes.
Engaged in amendments. Are those two people that were entities that were opposed now on board?
Maryland Legal Aid was not in opposition. They provided informational testimony, and they raised that as one of their concerns.
Thank you, Mr. Chair. Thank you, Delegate Toll.
Thank you, Delegate Kaufman.
Delegate Erican.
Thank you, Mr. Chair. Thank you guys for this this bill. I think, are you Ms. Lichterman? Is that, okay. So you had mentioned, I was going a little fast and my brain was a little slow. Maybe it was all the carbs I ate. But you said it was actually having a disparate impact on people that are like less of a danger to their kids, and somehow there was people that were, some of the worst cases were getting some kind of benefit. Can you just explain that again?
Absolutely. So that is a maybe unintended consequence, but basically, as an attorney, when I'm advising a client, as any attorney does in any case, you look at what the facts are, you look at what the evidence is, and you discuss with your client whether it's worth going to trial. In cases where the facts are really clear and sometimes much worse, and worse against the parent, those are situations where I may advise my client to agree to a TPR. In cases where the facts are more on the border and there really is a valid defense, I would normally advise my client, we should go to trial, you should fight this, you have a valid defense. And so it's a situation where this provision of waiver will affect the person who has worse allegations who agrees versus less worse allegations that's more borderline that doesn't agree.
Okay, I see what you mean. Okay, okay. That makes sense now to me. My other question is like, why is DSS getting it so wrong? What is? I feel like we had the article from, and then the chair tells me actually it's twice as many. What in your perspective is going wrong? Why are they getting, because every case I've ever personally had knowledge of, they have taken the kids from the wrong people and they have left kids in literally the worst situations imaginable. Why? Why is it happening? Yeah, hit me.
Yes. I think there are a lot of reasons why DSS is getting it wrong. One of the reasons is that there are too many cases being reported because of mandated reporting laws that don't need to be reported. We do not need to report every instance where we see a child walking home from school unattended. That is not child abuse or neglect, or not necessarily, right? And so the resources that DHS has are being depleted on cases that should not be investigated and need not be investigated. The second is that there's too much focus on saving face and instead of helping families. DHS gets millions and millions of dollars from the federal government every year. That money should be spent to actually help and address the problems that families are facing. Food insecurity, homelessness, lack of transportation to services. Can you believe that The Department of Social Services is frequently unable to provide rides so that parents can attend visits with their children or attend therapy appointments or attend drug treatment programs. The Public Defender's Office has had to set up its own Uber program to help our clients. We don't have that much money. You know, we need those resources, but DHS is getting millions of dollars. So those are two of the reasons that they're getting it wrong. The third is that the federal law has established these artificial timelines for when a family should have its act together and children should remain with their children. We know now that the social science shows that it is best for children to be with their families. You heard Ms. Moranto's testimony that her daughter went back home to her as soon as she could, literally as soon as she could, the day she turned 18. What we're getting wrong is that we're setting up these artificial timelines for families that don't work. It may take longer for a parent to reach, to become sober than 18 months.
Right.
But that doesn't mean that they should lose their children forever. So I probably have a much longer list, but I probably shouldn't go
I really
on, but
appreciate
those are
that.
some.
Yeah, because this is a scary issue, and we want to make sure we strike the right balance. But like, all of my knowledge of any of these types of situations for more than a decade has been that it's so ineffectual, it's terrifying, and children are literally being murdered. So thanks for your work.
May I add one thing? I'll be brief, I swear.
Very briefly.
I swear. One thing I just wanted to say was that you would think that we would only terminate parental rights if we had a loving adoptive family waiting for these children. That is not the case. We will proceed to terminate a parent's rights if the 15 months have passed, even when we have no plan for this child, and they will languish in foster care, and the outcomes for those children are horrific. So this is not a situation where there's somebody waiting in the wings to accept this child. We will terminate this child's rights to their family and leave them with nothing.
Seeing no further questions for the panel or on the bill, thank you all very much.
Thank you.
That concludes the
Thank you.
testimony for House Bill 944. We're going to go now to House Bill 110, bill that we have heard before, I think. And the first panel is going to be Delegate Simpson, Trina Selden, Fran Schneiderman, Mark Woodward, Amy Vora, Cam Bridges, Christopher Dews, DeJuan Burton.
Give me 1 second, I dropped something under the table. Sorry, Karen. You're good. Oh, God, okay.
Oh, you wanted me to put my lipstick on?
No, what do you want to share?
Thank you. Thank you for coming.
Oh, absolutely. Absolutely.
Delegate Simpson, please.
All right, it is great to be back here to talk about child support again. Since last year was so much fun. And so what are the changes that we've made to this bill? It is still a due process bill. That is the point of this bill, is to reduce the number of errors in suspending driver's license. That's the whole point of the bill, is to make sure that we get someone else that's taking a look at it and that we are only using it. One of the things, as we said last year, that we had not defined is when was it appropriate, and that's what the federal law requires, is that we define when it is appropriate. So, and it should only be appropriate when someone has the money and they are able but unwilling or voluntarily impoverishing themselves. We want to make sure that we are keeping people employed, because we saw the number of errors that there had been. And so therefore we can take those errors and say, look, if there's 10,000 people who are paying their child support and they are paying their arrears and they are still getting their license suspended, then there is also at least 10,000 children that is also affecting. And then it is also somebody is receiving those funds. And then also, hopefully they were employed, and therefore you also have the community at large that is affected. I was glad to see in the department bill that they would also like to increase the delinquency threshold. And as we said, we wanted it at 120 days, regardless of whether, because, you know, Maryland is a driving state, so why have a difference? And there are so many other tools in the toolbox. That's the whole point, is to use those other tools like wage garnishment and things like that before you use this. our hope is that this is actually going to reduce incarceration. It is notable that the judiciary supports this bill and that we, sent it around. We have really done a lot of work on this bill to make sure that we are not repeating ourselves, that we are making it very clear when it is appropriate, and we don't want people driving on a suspended license. So in this case with due process, they will know before they leave court. And just to note, the suspension of a driver's license is much more appropriate as a threat than it is as an actual a punishment, because once they do that, they can end up losing their job, their income, and everything else. So I hope we get a favorable report on this. We all worked really, really hard, and I appreciate everybody at this table for all the time they put into it.
Would you like to go next, please?
I can go next. Good evening again. My name is Ami Vora, and I'm with Maryland Legal Aid. We are urging a favorable report on HB 110, which establishes a judicial process for determining whether to suspend a child support obligor's driver's license for non-payment of support. As we've heard many times today, the current system does not afford parents a full and fair opportunity to contest their referral for license suspension. We know that as lawyers, that the best way to ensure that parents receive proper notice of the potential license suspension and an opportunity to prevent it from happening is to require DHS to pursue license suspensions through the courts in the exact same way that they already pursue child support contempt matters through the courts. Using a judicial process will ensure that parents receive proper service, allow them to seek the assistance of a lawyer more easily, give them the due process and a chance to be heard in court, and allow a neutral decision maker as opposed to an interested party to make the final call about whether their license should be suspended. States like West Virginia and Connecticut already handle license suspensions through a judicial process. And because DHS already pursues civil contempts through the courts, the infrastructure already exists to tack on this one additional enforcement mechanism that can also be adjudicated by the courts. And so because this is a bill that guarantees due process to parents, we strongly urge a favorable report on HB 110.
Good afternoon, or should I say good evening, Mr. Chairman, members of the committee. Mark Woodard, Job Opportunities Task Force, in support of House Bill 110. I really think it's useful to look at these two bills, 110 and 681, in combination. 681 addresses issues for people who are making less than $38,000 a year and provides an exemption from having their license suspended. This bill provides due process for those making above $38,000 a year who wouldn't be covered by that bill, and provides them due process, the opportunity to be in court, have an attorney, make the case. And by the way, if they assert that they need their car to go to work to earn their income so they can pay child support, the court is not to suspend their driver's license. This is a good bill. It passed last year. We urge a favorable report on this bill, House Bill 110, this year. Thank you very much.
Good afternoon. My name is DeJuan Burton. I'm the Deputy Director for Out for Justice, and I stand before you currently in my capacity as the custodial parent. This bill prevents the act of license suspension by Child Support Administration, which has been up to this point arbitrary, without due process for the obligor or consideration of mitigating factors that might address or allow for a more appropriate action to be taken by granting the courts the opportunity to litigate and make the necessary actions. I want to discuss when parents have a copacetic relationship and support the needs of the kids. Weaponizing a parent's driver's license can cripple a stable and cohesive co-parenting system, creating an overburden on the unaffected parent. In my situation, I have the distinct experience of being impacted by my child's father, who is the obligor for kids from his previous marriage, as well as the child that we share. And due to the bureaucracy of the child support and DHS, his license was in jeopardy. This action impacted not only his ability to get to work, but his inability to support the child we share, as well as the children from a previous marriage, one of which was in our physical custody, and for which he was still providing child support payments. This meant I bore the load of transportation to school or activities for our child, but also visitation for the other children. It's a domino effect that is a counterproductive tool to securing or addressing arrearages in child support. Ultimately, what I must press upon you is that the idea that the driver's license suspension is actually an effective tool in securing child support payments, and it's not proven that, and there's no data to support this assertion. What we do know is that it creates a vicious, harmful cycle, and a tool in the wrong hands is just asinine. I urge a favorable report for this particular bill. Thank you.
Thank you. Franz Schneiderman, Consumer Auto Maryland. We're a nonprofit that works for fair treatment for Maryland drivers and Maryland consumers. You know, I want to thank Delegate Simpson for bringing this bill. We've talked a number of times about ways to deal with the counterproductive process we have here of cutting off people's ability to drive and making it more difficult for them to earn a living and pay child support. And I just think of the various things we've considered, this strikes me as the most fundamental and most effective way to get at it, because instead of merely tampering with the criteria for cutoffs, which might or might not really work or involve due process, this requires an affirmative court order for a court to find that it's an appropriate choice in the given situation, and that the parent who owes the debt really is deliberately avoiding paying it. Also sets up clear standards and prohibits the courts from suspending licenses in cases where it'll interfere with employment or interfere with the custody or the person who owes the debt actually has custody, or various other situations in which the suspension is clearly counterproductive. So, I'd be happy to see, of course, it's up to the committee to decide how to address the issue, but I think embracing this bill would be a great way to get to the root of the problem. So I hope you'll give it a favorable report. Thank you.
Good evening. Again, my name is Corinne Berry. I support House Bill 110, a logical and an equitable approach to driver's license suspensions. This bill will allow me to argue for myself in court to protect my freedom, my employment, independence, and most of all, my relationship with my son. I urge a favorable report. Thank you again for your time.
All right, for the record, again, Cam Bridges, public policy advocate for JOTF. Current law already allows individuals in arrears to request an exemption for license suspension if losing their driver's license would be an undue burden on their ability to maintain employment. But in practice, most low-income individuals do not request that exemption even when they qualify. They often do not have stable residency, so mailing information alerting them of this possibility is ineffective, and they remain unaware of that avenue. And even if they do receive the notice, they often do not know how to navigate the process, as they are not legal experts themselves. And we've heard personal stories from impacted individuals earlier today that even if they do receive the notice and even if they do reach out, they're often just told to pay and given no recourse. They can confirm that the petitioning process is wholly ineffective. The current system does not adequately differentiate between non-custodial parents who are purposely withholding their child support and ones who simply do not have the money. Placing the burden of proof on the administration in identifying who is purposely withholding payment by a fair standard will ensure that poverty is not being unfairly criminalized. We appreciate this opportunity to testify and urge a favorable report for this legislation.
Chris Dews, Cornerstone, me too. Thank you all.
Brief question. Yes, very brief questions. Despite your Herculean efforts, Delegate Simpson, the DHS still has issues with your bill, and so they say that it delays the child support process, slows down the process, and they further say that it places new obligations on parents. So I wanted to give you a chance to respond to that.
Well, thank you for that opportunity. That is, it is very interesting since in their bill, they are now adopting the 120 days, which is what they're talking about, the slowing down. So that doesn't make any sense if that's part of their amendment. As I said, this is only one tool in the toolbox. And there are lots of other states, we did our research, that, 38 out of 50 states give a longer period of time before they would suspend a license. Because this really is one of those, it's much better as a threat than it is once you've taken the license, it's a downhill spiral from there. So I would say, first off, their bill, they said, was going to address driver's license, and it doesn't address it at all. And the driver's license program, it's broken. We want to fix that, and we want it to work properly. So, and we will still have a program. It is still not a single state has lost their federal funding for making changes to their driver's license suspension program. We are just trying to make it work better.
Thank you, Delegate Simpson. Thank you, Mr. Chair.
Thank you, Mr. Chair. I think Mr. Woodard might have misspoken on the status of the bill. Delegate Simpson, would you like to clean that up for him?
Yes, thank you very much. It did get out of committee. It was severely cut down. And then, of course, these were in the final hours. And so it was just kind of held, rather than distract from many other bills that were ready to go.
Thank you.
See no further questions for this panel. Thank you all very much. Jonathan Williams, Humani Selden, April Hamilton, Corinne Berry, and Eric Smith are virtual. Neither are there.
They are all me too.
They are all me too. I don't see anybody else coming to the table. Thank you very much. That concludes the testimony for House Bill 110. House Bill 929, Delegate Simpson, Leader Jordan, Brett Engler, Margaret Tehan. This might actually be a straightforward bill that would not require a great deal of conversation, but now that I've jinxed it, hey. Delegate Simpson.
You know what? I'm going to go with what you say, and because it is very straightforward.
It is very straightforward. It genuinely is.
It's very straightforward. So I'm Brett Engler. I'm the chief of the domestic violence unit with Frederick County. I've been a prosecutor doing intimate partner violence work for about 13 years now, and I can't tell you how many victims of domestic violence and survivors I've worked with who are just elated to be able to get a lifetime permanent protective order. It means so much to them. So thank you for passing that. We're just wanting a little bit more here. The ability for a respondent to consent. You can consent to a final, you can consent to an extension, and we have Ms. Tian here who represents petitioners and respondents and criminal defendants. But there's no mechanism to consent. So the burden is on prosecutors to get a 5-year sentence, and that person has to have served a year. And working with intimate partner violence victims, they run the gamut, and it's not a monolith at all. But that is a hefty load, and defendants have the absolute right to a trial. When you tell a defendant, okay, you can plead guilty 5 years, that's a lot, and it makes trial more likely, which is fine, but for domestic violence victims in particular, that is difficult. And many of them don't want to go to trial. They want a plea agreement, and defendants perhaps would be more than happy to consent, but we have judges saying you can't consent because the law doesn't allow for that, and you didn't get the requisite sentence, so my survivor now cannot get a permanent lifetime protective order. So please fix. Thank you.
Hi, everyone. I'm Margaret Tian. I am a partner at the law firm of Etheridge Quinn in Frederick, Maryland. For 25 years, I was a public defender, and for 4 of those years, I served in government relations, and I testified in this committee almost every day of session. In 2024, I was asked to represent a victim in a rape case pending in Frederick County, and I was happy to zealously represent the victim's interests. Very often, I represent defendants, but I also represent victims, usually in child abuse and sex offense cases. And I believe in restorative justice, and all my victim wanted was a permanent protective order. She didn't want to throw the book at the defendant. She just wanted this to be put in place But the logistics of it are a little bit complicated. For anyone who does criminal work, the defendant waived pretrial credits, which means his sentence actually started on the day of his plea. And you can only modify a protective order or rescind it during the life of the protective order. And that 1 year issue that you have for the protective order that it has to be modified in is a little bit tricky. It would be much easier for me, both as a defense attorney and as someone who sometimes represents victims, to just be able to consent. Please pass this bill. I'm hoping there's no opposition. Minimal fiscal note, that's it.
None.
Clear, as a state's attorney, and a defense attorney, agreeing with the delegate at the table, and everybody's on the same page.
It's amazing.
Get her done.
Delegate Kramer.
Thank you. Briefly, so this is a situation, victim just wants to be left alone. Defendant's fine with, I'll leave her alone forever, just don't do X. That, and it's the purpose of the, okay.
I'll consent, I just don't want to serve 5 years, don't link me.
Got it, thank you.
Or even the year.
Or a year, correct.
All right. Seeing no further questions, thank you very much. That concludes
you.
testimony on House Bill 929. Delegate Crutchfield is now making her way up to the front, and if I talk slowly enough, Michelle Smith and Christopher Deuce can also get there with Amy Vora. We can make sure that Eric Smith is still not on new, okay? So it's just going to be the three of them. They're going to be talking about a bill about multifamily adjustment, which we may have passed several times before. And so they're going to bring us up to speed as to what this bill does, which I suspect is something similar to what the last bills did. Delegate Crutchfield.
Yes, Mr. Chair and committee, I got the last bill. Okay, so we're gonna make this real fast. All right, so for the record, I'm Delegate Charlotte Crutchfield. I represent District 19 in Montgomery County, and I'm here in support of House Bill 275, which is to deal with child support, multifamily adjustment. So HB 275 is a product of research and input from the Maryland Child Support Guidelines Advisory Committee, coordinated and chaired by the Maryland Department of Human Services. Both myself and Delegate, who is not here, Simmons, were on the committee together. The legislation will create a deduction for child support determination. Specifically, a deduction may be given when determining a parent's income for child support purposes, based on situations when a parent has an additional child or children who live with them and to whom that parent has a duty of support. HB 275 acknowledges the existence of children in both households, understanding the constraints of income due to the support of extra dependents and reducing the impact related to the sequence of birth order. Currently, child support guidelines are calculated using the party's adjusted actual income, which is their gross monthly income minus alimony or child support that a court has previously ordered the party to pay. At present, financial support provided by parents for children living in their homes is not considered if a court has not ordered the parent to provide such support. HB 275 will permit courts, when establishing or modifying child support, to account for the financial support parties provide to children living in their homes, to whom the parent owes a duty of support, but for whom there is no pre-existing child support order. The legislation would add a new deduction from each parent's actual income for a hypothetical support amount deemed to be provided by that parent for the children living in his or her home. Both the payer and payee of the child support order will be entitled to this deduction from their actual income. To calculate the hypothetical support amount, a court must determine the basic support obligation based solely on that parent's income for the number of children living in the parent's home when multiplying the basic support obligation by 75%. The resulting figure, 75% of what would be required to pay if their child support obligations were calculated under the current guidelines. This will be subtracted from the parent's actual income to produce the adjusted actual income amount. Under this bill, the courts will be permitted to exercise discretion to decline to apply the deduction if the deduction would be unjust or inappropriate in any given case. I respectfully request a favorable report on House Bill 275.
Whoever'd like to go next.
I'll go.
Michelle Smith, on behalf of the Maryland State Bar Association Family Law Section Council, I'm here to testify in support, and we urge a favorable report. I'll just give an anecdotal example for you about this in court and with our case law. Currently, as Vice Chair Crutchfield pointed out, well, she's not the vice chair, but she's the chair of another committee.
Of the subcommittee.
Yes. All right, I'm just going to call her Charlotte.
Right. That's
No. Okay, Delegate Crutchfield, we're going to be serious. I'm using all my time. So if the obligor has child support that he or she pays to another child, it actually doesn't have to be court ordered. Through case law, it can just be if there is an agreement between the obligor and the other parent that is sufficient enough for the court to find that it's an actual agreement, does not have to be court ordered. So, and that child's not even living in the obligor's home. So doesn't it make sense, if that's our case law and our statutory law, that that parent who has a new child living in his or her home, perhaps in a new relationship, should also get the benefit of a deduction for supporting that child? Shouldn't all the children apply to the child support guidelines? I say yes. So we urge a favorable report.
Good evening. For the final time, my name is Ami Vora. I'm the Director of Advocacy for Family Law at Maryland Legal Aid. We urge a favorable committee report on HB 275, which amends Maryland's child support guidelines to create an income deduction for parents who are supporting additional dependent kids in their homes. Maryland's support guidelines are premised on an idea that children are always the products of neat and nuclear households, whereas the reality of modern American families is just far more complex than that. Data shows that 1 in 10 Americans have children with multiple partners, and that statistic is strongly correlated with poverty. So that means the low-income parents that we help at MLA are frequently juggling financial responsibilities to multiple kids, but their child support orders are calculated without considering their expenses for caring for these other kids. HB 275 seeks to bring Maryland in line with what other states are doing, which is baking into the guidelines an income deduction to account for when either parent has additional kids in their home. This proposal is grounded in equality because it applies to both custodial and non-custodial parents, and it's going to lead to orders that are based in the reality of parents' circumstances and therefore are more likely to be paid. So for those reasons, Maryland Legal Aid urges a favorable committee report on this bill.
Yes, sir. I'm on the last one, so I will be very quick. I do actually have words. So very, very briefly, my background was in workforce development. I'm here representing Out for Justice. And in my workforce development space, I used to work for Delegate Dana Stein. Individuals don't know that, at his company called Civic Works. And just like you guys listen to hours and hours of testimony, I listened to hours and hours and hours of my trainees. Literally about to go off the deep end because they finally got full-time employment. They had worked for weeks and weeks and weeks and finally got their first paycheck, only to see that it had been garnished at a significantly high rate, and wanted to quit working, quit everything, relationships, life, and I spent hours talking them off the ledge. When I called some of those same people and say, we're working on a multifamily adjustment, they shot through the roof with excitement and joy, but we're also too embarrassed to actually submit written testimony, so we don't talk about that portion. But I will say this bill is huge. It's a phenomenal piece of legislation. It is very much pro-family. It is a bill that is set for the times, and I think we should move favorable, and we thank Delegate Crutchfield for taking it on. Urge favorable report.
Delegates, Eric Hale.
Thank you, Mr. Chair. Thank you. So I just want to make sure I understand. This has not been my experience, but there are some men who will simply pay for their children outside of a court situation. I actually have known some men to do this. They'll just write a check. Sometimes they are court order, but sometimes they'll write more, frankly, than the court order, which is, God bless them. So what this would do, essentially, would you also be taking into account things above and beyond court orders? Would that also be considered, or just people who are paying outside of court orders completely? Would both of those groups be included?
I think so. Yeah. Yes. We agree that, yes, that within the confines of this bill and current law, that agreements between those parents, if they're not court-ordered, could be considered by the judge.
Okay, so yeah, so that would include the guy with the court order that's paying over his required amounts, and it would include the guy that just generously paid for his children without having to be drugged to court.
And ladies.
And ladies, of course, sorry. My gendered language may never change, but hopefully when I'm old, you'll love me anyways.
Thank you, Mr. Chair. I think the chair mentioned briefly we moved this bill, but I don't see that. Can someone clarify?
No, he was wrong.
Got it, thank you.
He was ambitious. He was being.
Thank you, Mr. Chair. I think this is, another good bill as it relates to, child support. And I think that Chris indicated it correctly, that this is the times that we are in. And when you want to build families up, that everybody sort of can get a piece of that pie when you have, families, extended families. I think it's important to build for that, to ensure that one child, can get equally the support. So I appreciate that. Is this a bill that we heard last year, Delegate Crutchfield?
Yes, it is.
Okay, what happened with this bill last year?
It stalled in this committee.
Okay. I genuinely did not know. I was asking. I could not remember. I had my own child support bill
Please don't do that again. Please don't do that again. This is too important.
But thank you. I just wanted to get an update, and hopefully, look, we see that DHS has sent child support. I think that, it's a good time to have this conversation and move several pieces along as we try to reform this system. So thank you.
Thank you.
Else want to steal the last word? No? Good, sounds good. Thank you very much. That concludes the testimony for House Bill 275, and that concludes the bill hearings for today. Consider this Friday, when we don't have anything going on, a gift. We will be back on